Due to some minor,
Maintain the seniority, please. Maintain the seniority, please.
Yes.
My lord, may I have a good morning to my lord, and also on the case I have filed in the month of June. There's a SIR case.
All mentioning list, give to my court officer, assigning the reason, I will see to that. If I will find there will be no reason, I will not entertain any of the
You're also taking leave.
whatever it
Leave
may
to
be,
file, Lordship.
either upgradation or any mentioning, you give. Only I will take the mention with regard to the unlisted motion.
Lordship, non.
I will here with regard to the mentioning matter which is already on list or you filed, you wanted to upgrade, you give the mentioning list to my court officer. I will see to that. If I find that reason, then I will allow. If I did not find any reason, I will not.
Kindly,
Lordship.
Lordships, kindly, my lord.
Whatever it may be, give the mentioning list. I will see to that. Not any mentioning. Give the mentioning list, assigning the reason, court will consider.
Lordships, kindly, my lord.
My lord, I am submitting that once on time the matter filed, matter you put on the list automatically.
Lordships, kindly, my lord.
File.
I was urgent detention. My lord, I am facing a demolition by granting me any opportunity.
What is the unlisted?
State.
But when the notice was issued,
It has been served upon us on Saturday.
Hmm.
But today,
under public premises,
under the public,
it is not having.
an order passed by the National Grid Tribunal.
Why you are coming?
But the NGT has disposed of the matter. To grant opportunity of claim. Sir.
Lordship, may I please mention an unlisted
Notice fixed tomorrow within 10-15 minutes.
unlisted matter, Lordship.
I will not take any mentioning list. Only I will take the unlisted motion. That's all.
Unlisted. Lordship, unlisted motion. Lordship, unlisted.
Unlisted. Where is the unlisted?
Lordship, I'm seeking leave to file the writ petition. Lordship, there are 5 family members who are being dispossessed by the learned recovery officer of the DRT. We have filed our objection. The objection is pending before the learned RO, but without disposing of that objection,
Go
the
to the
further
DRT. Wow, if the recovery officer has
Lordship, there is no order. There is no order by the learned recovery officer during pendency of the application filed by us.
Who has evicted you?
Nobody, Lordship, we are flat owners, residential registered owners. We reside in that, we've been residing for 20 years in our respective flats. On 17th of June, an attempt was made to attach the property because
Who is going to attach?
the bank, Lordship, the bank on the direction.
Why the bank? Why
Lordship, the TA is already disposed of. This is before the learned recovery officer. The learned recovery officer is duty bound to hear out the application objection filed by us under section 29.
Correct.
That application is pending, Lordship.
Correct.
We mentioned the application by way of a put-up application. The put-up was allowed to be heard on 24th, which was on Friday, Lordship.
Correct.
Friday, the DRT bar had issued a resolution for not to pass any, not to take up any matters, in fact. So, Lordship, now there is no order. There is a fresh direction against us, and upon the Commissioner of Police.
Don't move today. If the Friday.
We have moved, Lordship, we have moved. The learned recovery officer has said to list it on 30th of August, July. That is the only limited writ, Lordship, that till the application is heard out, we may not be disposed.
This matter was heard.
Lordship, argument, Lordship.
Go to the DRT. This court cannot take the jurisdiction of the DRT.
Lordship, only time bound stay till the applications are heard out,
The
Lordship.
DRT.
Lordship, this matter was heard by the Lordship on Friday.
Give the
The name was given wrongly.
give
So it will have to come along with TV mention.
give the
Why is it
mentioning.
matter? My shop has been shut down, your lordship, because incorrect application of the Bengal Excise Act, your lordship. The penalty, your lordship, is a similar imposition of fine. But my shop has been shut down for a period whole 1 month, your lordship. Lordship, the urgency is that, your lordship, if I approach the appellate bench, your lordship, 1 month would expire, your lordship, much before that. Therefore, lordship, there's an urgency in the matter. Kindly take it up.
What urgency? Which
Lordship, the
appellate
shop
court?
will be shut
Who has
down.
passed an order?
Lordship, the district magistrate collector, your lordship.
Collector has passed an
The
order.
Excise Act,
For
your lordship, for shutting down a suspension of my license and shutting down my shop.
so
for
there is
period
an
of 1
appeal.
month.
There is an appeal provision.
But the period, 1 month period, my shop would be shut down for your
Ah,
lordship.
ah.
Therefore, if I prefer an appeal, your lordship, the date will be fixed automatically after a month, your lordship. My entire cause would be infructuous, your lordship.
Lordship, these are residential premises.
You have a appellate authority. You go to the appellate authority. You mention before the appellate authority.
After a period of 1 month.
Maybe what can be done? You go to the appellate. This court is sitting idle. Appellate authority is very busy.
Lordship, but
Yeah,
residential
Oh, madam,
premises.
I already
Lordship. Lordship, residential premises. Lordship,
Maybe,
we
maybe,
will be
maybe. You
dispossessed
go to
of.
the DRT. Go.
Lordship, we are not.
There's a time you mention the before the DRT.
Special disposable. It is like nothing. This advanced redressal cell has directed the FCI, my lord, to consider a representation bank guarantee. Seek just sitting on it, my lord. I'm sorry, I'm sure you notice.
You mentioned that.
Yes,
mention.
I have.
My lord,
No mentioning. Yes, call the list. No mentioning. No mentioning. Sorry. Whatever the mentioning, give the mentioning list to my court officer.
What is this? Well,
my lord, they're facing financial issues and hence they're filing before this court for because
Well, it. Who has restrained you to filing the writ petition?
my lord, district magistrate wrongfully passed an order which is against them while it is wrong. Hence, they are DVC is facing financial loss and having loss financial issues as a whole. So,
What?
regarding this matter,
So why file the writ petition? Why are you mentioning? You file the writ petition. Why are you mentioning?
Your lordship is saying for release of item number 659. If you could-
Sir, you don't understanding the English. If you are having any urgency with regard to the listed matter, you want to upgrade, you give the mentioning list because every 100 advocates I can't hear.
Lordship, I'm not
Then
saying
it
for
will be till 4:30. I will hear the mentioning only.
I'm not saying for application has been wrongly filed before your lordship. It is filed against Kolkata Municipal Corporation, but your lordship does not have the determination.
Which matter?
Item 659 of lease statement 13th of July, monthly lease, your lordship.
6:30.
659, your lordship. Dishan Maiti versus Kolkata Municipal Corporation.
Okay.
659, your lordship.
Dishan Malti.
Yes, lordship.
Minor.
Kolkata Municipal Corporation, but your lordship doesn't have the check.
Though the matter is listed as item number 659 in the monthly list, comma, the land council for the petitioner mention the matter and submit that the petition the petitioner had inadvertently filed the matter before this court as the matter is connected with group 5.
Five, your lordship.
Group 5. Accordingly, press for leave to release and press for release of the matter so that the petitioner can make appropriate prayer before the appropriate court having determination. At the land council for the petitioner, WPA 18854 of 2025 within bracket Rishan Maiti within bracket minor versus Kolkata Municipal Corporation and other is released from the list of this court with the liberty to the petitioner to mention before the appropriate court having determination.
Deeply authorized.
lordship, may I be lordship,
Yes.
May I have the lordship's kindly note this matter lordship was hearing lordship would recollect that OBC certification matter lordship was placed some order on 17th June. So happy that I personally had a family disease, so I could not come. So thereafter the matter has been posted slightly down the list. It's item number 73. majority of the hearing has been concluded. Lordship was will direct the authority to bring the record wherefrom it can be shown. Uh, the guidelines are set out by the Honorable Supreme Court for the committee to determine the certification for other backward classes, SC and ST, whether that has been followed or not, my lord. I believe, my lord, I've served a notice, my lord. It can be taken, my lord.
You mention the reason. You have mentioned the reason why it is. Then I will take care of it.
I'll just do that. My advocate on record will hand it over.
Yes.
Thank you, oblige, my lord.
Lordship, may I be?
There is a senior citizen lordship currently under condition of one Finland doctor lordship. He has not.
Yes.
His passport is not being renewed, lordship. Lordship, it's a
Passport is not renewed. That is what is the urgency.
lordship. He's a senior citizen and he's undergoing a doctor's Finland lordship. Kindly,
Doctors?
he's under supervision of a Finland doctor. He needs to go abroad. Lordship, kindly fix this matter anytime, any day.
When you apply for the passport.
Lordship, long back. 2025, Lordship.
So why you are coming in the last month?
Lordship, now the difficulty is his son is also ill. Lordship, kindly consider the condition of the petitioner, Lordship. Any day, 10 minutes will be taken.
So Tuesday, Wednesday,
Lordship.
to notice. Wednesday we didn't.
Lordship.
Lordship,
Yes, call the list.
Lordship, may I be?
Lordship, may I mention, Lordship? Actually, Lordship,
Yes, who is appearing for the one?
My lord, I am appearing on behalf of the petitioner, my lord.
Lordship,
My lord, in this matter, my lord's kindly court withdraw it, and my lord, I am praying for liberty to file it afresh on the self-same cause of action, my lord. The grounds are have not been set out inadvertently, my lord.
My lord, I am appearing for SEBI in item number 1, my lord. Respond number 1, my lord.
Although, my lord, I have pleaded the grounds.
Landed counsel for the petition submitted, there is some technical error in the writ application, and as such, the same cannot be rectified by way of amendment application. Suppressed for withdrawal of the present writ application with the liberty to file afresh.
On the self-same cause of action, my lord.
The submission made by the counsel for the petitioner. Petition WPA 16013 of 2026 is dismissed as withdrawn with the liberty to file afresh on the same cause of action.
I am grateful to your lordship.
Yes.
Oblige, my lord.
Next.
My lord, in item number 2, my lord, I beg to appear for the petitioner, my lord. My lord, in this matter, my lord, I am led by Mr. Devojyoti Basu, learned senior counsel. My lord, may I seek a very short passover on his ground, my lord?
So the matter is fixed today for urgent.
My lord, may I start the matter, my lord? My lord, may I start the matter, my lord?
Let the matter appear in the month of September 2020.
My lord, may I start the matter? My lord, I have specific instructions to start the matter, my lord. In case your lordship is not inclined to give the passover, my lord, may I start the matter, my lord? My lord, it's very urgent. May I start the matter? My lord, I'm very sorry, my lord.
Call the three.
My lord, may I start the matter? My lord, I have specific instructions to start the matter.
Yes, who is for the three?
My lord, may I start?
The last occasion, your lordship had, my lord, called upon the railways to come up as to whether there is any contract which provides for, my lord, set off. My lord, we have not been served with any copy of any contract. Instead, my lord, what they have served us is a copy of a minutes, my lord, which, my lord, may I hand up to your lordship? They've circulated a copy of these minutes, my lord. If your lordship sees, well, the minutes records, my lord, a discussion but no decision. This is a draft minute. We have objected to it. We're saying that none of this was, my lord, ultimately, my lord, crystallized. That is a letter on record. But my lord, if your lordship sees item number 1, agenda item number 1.
Yes.
My lord, inspection charges and track maintenance charges. The issue relating to inspection charges and track maintenance charges was discussed in detail. It was noted that demand notices towards inspection and maintenance charges had been raised by the railway administration. However, BESCO, through its letter dated such and such and subsequent communications, had declined to make payment on the ground that the siding was being maintained by the company itself. Then, my lord, there are certain discussions. Then please see paragraph 6. It was further agreed that future demand notices relating to inspection and maintenance charges shall contain a detailed calculation sheet, methodology adopted, applicable rates and supporting documents to ensure clarity. And then, my lord, the bills are restrained. Now, my lord, there is no decision taken. If your lordship sees agenda item number 2, My lord, discussion, decision. Agenda item number 3, discussion, decision. Agenda item number 4, discussion, decision. My lord, so far as this is concerned, this is a deliberation that is going on. And my lord, so far as this minutes is concerned, your lordship will see that this is dated 15 July 2026. My lord, on the 16th of July 2026, we served our notice under section 21. My lord, my point was very, my lord, simple. Your lordship has seen, my lord, the communication that, my lord, we are really assailing. Your lordship kindly once come back to page 164.
Yes.
My lord, this is, my lord, there are 3 bills, my lord, raised all of a sudden for the periods from 2017 to 2025 for 1 crore 40 lakhs here. Then, my lord, next paragraph is what is important. Parties have been approached several times for making the above payment by issuing letters in different times and also over telephone. But the party is not responding and delaying in making payment. Under these circumstances, it is requested to adjust the above amount from existing pending dues of BESCO against Eastern Rail.
Yes.
Well, this, according to us, cannot be done. Well, first of all, as to whether this amount is payable or not has to be decided in arbitration. We have made a reference under section 21. Number 2, my lord, this set-off can only happen, my lord, if there's a contractual provision, as in the case of Raman Foundry, Kamaluddin Ansari, etc. Contractual set-off, not the case here. Statutory set-off, not the case here. No question of equitable set-off because, my lord, they are arising out of 2 separate, my lord, contracts altogether. One is, my lord, contract for payment of inspection maintenance charges for railway siding. The other is, my lord, my payment for wagon supplies under the wagon supply agreement. Well, that was my contention. My learned friend said that, my lord, there is some provision in the Railways Act. Your lordship, my lord, in the last order passed on 23rd of July, recorded this. Counsel for the respondent prays for time to place on record whether there is any contract between the parties that the railway authorities can realize alleged dues from the petition and other existing pending dues. Well, that contract, my lord, has not been shown to us.
Yes.
My lord, last occasion, my lord, I have that page 164 that I have placed, my lord, that there is a 2 head charges under. One is, my lord, the maintenance and inspection. That is, my lord, clause 8 of the agreement that has been specifically stated. And, my lord, the next is OHE maintenance charges. My lord, your lordship was directed on last occasion regarding the OHE maintenance charges. And, my lord, kindly consider that.
OHE maintenance charges given up, page 140, exempted, 141, exempted. Page 141, 3rd paragraph. Accordingly, the provision of levy of OHE maintenance cost in respect of BESCO Limited private siding Bariko is not applicable and is to be exempted.
Yes.
So, my lord, there is charges under 2 head. One is, my lord, the maintenance, and that is, my lord, covered under the clause 8 of the agreement. My lord, that clause 8 at page, my lord, 68, my lord. Clause 8, 68, my lord. That last occasion that I have shown, my lord.
Yes.
My lord, I am not placing, my lord. Again, my lord, my humble and respectful, my lord, that first portion that is covered under this agreement, my lord, clause 8.
No, that's correct. But the question is that can you realize the pending dues?
Other bills.
Yes.
Yes, yes. I'm coming, my lord. I'm coming.
That is the question.
Yes, yes. And, my lord, next, kindly come to the page 58, my lord. That is the date of agreement, my lord, was executed on 25th of September 2019.
Correct.
And, my lord, whatever my learned senior said, it shows that that portion is exempted. OHE portion is exempted. So, my lord, the maintenance portion that is not exempted.
Correct.
That is admittedly.
Correct.
And, my lord, humble and respectful submission, my lord, that OHE portion, after the issuance of, my lord, the railway board specific circular regarding, my lord, that portion is also not exempted. That is also included. My lord, kindly, that circular was, clarification circular was issued by the railway board on 19/12/2025. And, my lord, the agreement was executed, my lord, on 25th September 2019. My lord, kindly come the clarification regarding the applicability of the OAC maintenance cost charges for siding commission prior to the issue of siding policy FMA number 11/2026. Railway Board in receipt of South Central Railway letters under reference number such and such seeking clarification regarding applicability of the OAC maintenance charges for siding commission prior to the issuance of such and such. The matter has been examined. A clarification on this issue was earlier issued by letter number 25th of February 2025. Since Zonal Railway has still have some queries on this issue, therefore Zonal Railway queries and clarification thereto are just posted below. Zonal Railway query whether the OHE maintenance costs are to be borne by the railway, the siding owners in respect of the siding that were commissioned prior to the issuance of FMC number such and such dated 28 August 2016. In this context, if applicable, whether the OHE maintenance costs already paid to the railways by the siding owners of the siding commission prior to issuance of FMC number such and such pertaining to the period from June 2020 to February 2025 can be refunded to the siding owners based on Railway Board clarification issued on 25th February 2025, cited under reference 5 above. And under the clarification, the right hand side, it is reiterated that the revised guideline for the para number 93.1 under FMC 06 of 2020 were issued an amendment to private siding policy 2016. Hence, this is under the board's clarification dated 25th to 2025 that is shall not be applied retrospectively implies that siding commission or approved under previous siding policy number such and such are not governed by the amended OHE maintenance provision and shall continue to be regulated as per the original agreements. Thus, siding termination commission prior to FMC 11/60/2016 are not supposed to pay the OHE maintenance charges as these are continued to be responsibility of railway for such siding. And at the next, the status period of applicability of the payment of OHE maintenance cost for the siding commission after 22/8/2016 up to 23/6/2016 dated issue of FMC number such and such. And the clarification, the revised guideline for the OHE maintenance from the earlier page, the revised guideline from the OHE maintenance charges over siding commission under FMC number 11 of 2026 are applicable with effect from 23/6/2020. That is from the date of issue of the amendment letter. Prior to this date, siding terminal were governed as per their original agreement. So, that is effected from 20.
No,
This is prior to 2016.
second, the revised guidelines of OHE maintenance charges over sliding commission under FMC 11 are applicable with effect on 23rd of June 2020.
2020, yes. That I
But
said.
your charge here turned 18. So you have to amend that.
And
So,
then kindly.
Sorry. Go ahead.
Yes.
I'm sorry.
Kindly come to the next.
Hmm.
With reference to the para number 93.1 of FMC number 6 of 2020, whether the OHE maintenance is to be undertaken by the siding owners themselves at their own cost by engaging suitable agencies. The OHE maintenance is to be taken by the railways and the cost thereof to be raised as the OHE maintenance charges on the siding owners. OHE maintenance is to be taken up by the railway and the cost thereof to be raised by the railway as OHE maintenance charges as per guideline mentioned in the board's letter number 6/3/2024. Then your lordship kindly come to the next railway board's clarification letter, my lord. That was, my lord, issued on 25th of 25th of February 2025.
Correct.
My lord, that was the earlier.
Yes.
Thereafter, my lord, that was issued on 19th of December 2025. Then your lordship kindly come. The GCC, my lord, whether that provision is there, my lord, regarding that. My lord, that is my lord. My lord, kindly come to the writ petition. That is also in the writ petition is there, my lord. That is the GCC.
Which
My lord,
page?
page 159, my lord.
Yes.
GCC, my lord, clause 17, my lord.
Yes.
Recovery of sum due. Whenever any claim for the payment of sum of money arises out of or under the contract against the contractor, the President of India shall be entitled to recover such sum by appropriating any sum then due or which at any time thereafter may become due to the contractor under the contract or any other contract with the President of India or any person contracting to the President of India if such sum even be not sufficient to cover the full amount recoverable, the contractor shall be deemed to pay the President of India the balance remaining due. Next paragraph. For the purpose of this clause, where the contractor is a partnership firm, the President of India shall be entitled to recover such amount by appropriating the whole or in any part of sum due in any partner of the firm where this individual capacity or otherwise.
Yes.
So, my lord, if there is any dues, my lord, that can be, my lord, recoverable from the other payment, my lord.
Yes.
And my lord, one judgment. And my lord, on last occasion, my lord, I have just one of our honorable court, one judgment was placed, my lord. That is, my lord, that the arbitration and my lord in this writ petition also, my lord, the arbitration clause is also there. My lord, that I have both my lord, my learned senior friend as a myself, my lord, also placed. My lord, that arbitration clause was also there, my lord, in the agreement also. My lord, that is at page 84, my lord. Arbitration clause, my lord. And my lord, you also got the page 84 arbitration clause.
Yes.
My lord, that arbitration clause that was placed, and my lord, kindly come to the their representation, my lord, at page on last occasion that I have shown, my lord, page 166, my lord, last 3-4 last, my lord, at the bottom paragraph.
Yes.
Page 166. My lord, they have also, my lord, demanded for the arbitration, my lord.
Yes.
And my lord, regarding the my last judgment that I have shown, my lord, due to, my lord, the presence of the arbitration clause and the private nature of contract, the repetition of number, that was the, my lord, kindly consider that particular this judgment, my lord, that is reported in AIR 1984, page 29.
1984 Calcutta.
AIR 1984.
Con court. Calcutta.
Supreme Court. Okay. My lord, kindly come. The page 13, my lord.
Copy দেবেন? Copy দেবেন একটা?
নিশ্চয়।
আচ্ছা।
My lord,
Yes.
my lord, page 13 from top, my lord, clause 18.
Yes.
Clause 18 of the standard form of the contract earlier was slightly differently worded, and it is read, whenever under this contract any sum or money is recoverable under and payable by the contractor, but this formula was deliberately and advisedly altered when the present standard from
Standard form
was introduced, and instead the word whenever any claim for payment of a sum of money arises were substituted, and this change in indicated that in order to attract the applicability of the present clause 18, it was not necessary that there should be a sum of money due and payable by the contractor to the purchaser, but it was enough if there was a mere claim on the part of the purchaser for payment of a sum of money by the contractor, irrespective of the fact whether such a sum money was presently due and payable or not. This court, however, did not attach importance to this aspect of the matter by observing, we do not think it is legitimate to clause 18 of the contract between the parties by reference to a correspondence clause which prevailed in an earlier standard form of contract. This is not a statute enacted by the legislature where it can be said that if the legislature has departed from the language used by it an earlier enactment, it would be the fair presumption to make that the alteration in the language was deliberate and it was intended to convey a different meaning. It is a clause in a contract which we were constructing, and there any reference to a claim. This similar clause in another contract would be irrelevant. The court itself, while interpreting clause 18 of the contract, has observed, it is true that the word any claim for the payment of a sum of money occurring in opening part clause 18 are worth a great amplitude wide enough to cover even a claim for damages, but it is well settled that the rule of interpretation applicable alike to instrument as to statute. Then, my lord, kindly come to the last portion, my lord, bottom portion. We are clearly, my lord, bottom portion of the page 13, my lord. We are clearly of the view that an injunction order restraining respondent from the withholding the amount due under other pending bills to the contractor virtually amounts to a direction to pay the amount to the contractor appellant. Such an order was clearly beyond the purview of clause B of section 41 of the Arbitration Act. Well, that is in connection with the arbitration matter that judgment was pronounced. The Union of India has no objection to grant of an injunction restraining it from recovering or appreciating the amount lying in respect of the other claims of the contractor towards its claim for damages. But certainly clause 18 of the standard contract confers ample power upon the Union of India to withhold the amount, and no injunction order could be passed restraining the Union of India from withholding that amount. We find no error in the impugned order passed by the Allahabad or Delhi High Court. In the two cases, the appeals therefore must fail and therefore accordingly dismissed. In the circumstances of the cases, however, we direct the parties to so bear their own cost. The last two lines of that, first two lines of paragraph 14 is the very important. From the last paragraph bottom 13 to the beginning of paragraph 14. So that clause 18 and the clause 17 of this contract GCC almost 7, and the clause 17 that power has been given to the railway to adjust the dues with the other pending bills.
Which court order it is?
This is
Kamaluddin answer. You have cited it before, Your Lordship.
Which court order it is?
That is AIN only.
Yes. Anything further?
And it is a 3 judges being judgment. The bench at the first page top.
Yes.
Misra.
Yes. Anything next?
Yes,
Anything further? That's all.
May I answer straight away? Well, if Your Lordship, the first question is whether they can adjust from other contract. Well, please come to page 159.
But Mr. Shah, you have made a request for arbitration.
No. Well, that is what I said.
Request to arbitration. How this court can?
Well, arbitration will decide what? Well, that is paragraph
Maybe,
10.
whatever it may
No,
be.
kindly give me a moment.
Once you are approached,
I cannot, my lord, ask the arbitrator to decide this question.
Why?
My lord, please see Kamaluddin Ansari, paragraph 10. The same judgment that my learned friend just cited before, Your Lordship. My lord, it is also there in AIR. My lord, I had shown Your Lordship, my lord, paragraph 10 of
paragraph 10 you are shown.
My lord, what does paragraph 10 say?
Yes.
My lord, that the arbitrator can, my lord, only decide matters, my lord, which is subject matter of the contract, my lord, under which the arbitration is. Now, my lord.
Yes, you have shown that. Now, kindly come to the page 58.
My lord, page 58 of my lord.
Page 58 with regard to the maintenance of the charges, kindly
Yes.
page 68.
My lord, may I just answer this?
Yes.
My lord, first, my lord, may I just answer it one by one?
Yes.
My lord, Your Lordship, please have a look at my lord Kamaluddin Ansari once, paragraph 10.
Yes.
Well, at paragraph 10, your lordship will find, well, that I had given your lordship the SCC citation.
Yes, I am having that.
Yes. Now, well, let me just read it once. While construing the scope of section 41B of the Arbitration Act, this court held that the court has therefore power under section 41B read with the second schedule to issue interim injunction, but such interim injunction can only be for the purpose of and in relation to arbitration proceedings. The arbitration proceedings in the present case were for determination of the mutual claims of the appellant and the respondent arising out of the contract contained in the acceptance of tender dated such and such. The question whether any amounts were payable by the appellant to the respondent under other contracts was not the subject matter of arbitration proceedings. The court obviously could not therefore make an interim order which, though ostensibly in the form of an interim order of injunction, in substance amounted to a direction to the appellant to pay the amounts due to the respondent under other contracts. Now, my lord, what is my case before lordship? My case is, my lord, I cannot approach the arbitrator, my lord, for an injunction restraining them from, my lord, ultimately proceeding under the siding contract, my lord, to realize, my lord, what is due to them under the siding contract from my bills under the wagon contract. My lord, that was my answer. Now, my lord, let me show you, lordship, my lord, as to why, my lord, this clause that my learned friend has shown at page, my lord, in the contract, my lord, page 151, 159 is a part of, my lord, the contract which starts at page 144. My lord, please come to page 144.
Yes.
My lord, page 144, lordship will see, my lord, this is, my lord, contract, subject is contract number such and such for manufacture and supply of wagons.
Correct.
Nothing to do with siding. Now, my lord, if your lordship sees now, my lord, page 159, which my learned friend showed. My lord, this is a part of, my lord, that contract, not a part of the siding contract. My lord, please see clause 17, page 159. This is a part of the wagon contract. Whenever any claim for payment of any sum of money arises out of or under the contract, my lord, under the wagon contract. My lord, that is, my lord, the clause. It has no application, my lord, to the siding contract. That is, my lord, my first submission. My lord, if monies are due under the wagon contract, there can be recovery made, not under the siding contract. So, my lord, that this clause will not, my lord, entitle my learned friend to, my lord, to claim a set off.
But you have made a request to the arbitrator.
No, my lord, I'll show you, lordship, what is my request to the arbitrator.
Kindly come to the page 166.
Yes, my lord. Page 166 is my request to the arbitrator to decide as to whether, my lord, the bills for siding are payable. That your lordship cannot decide in the writ jurisdiction.
Correct.
So, my lord, what will the arbitrator decide? The claims that they are making for, my lord, the bills from 2017, whether that is actually payable or not, because I say that you have not rendered any service at all. That is the matter which the arbitrator will decide. Arbitrator will not decide the question as to whether there can be appropriation of money, my lord, under this contract from the wagon contract, because then we will be ultimately merging two contracts into one, which cannot be done.
No, kindly come to the your page 166.
Yes, my lord.
Last paragraph.
Yes, my lord.
In view of the aforesaid, we demanded justice from your good self and request your office not to take any coercive steps or make adjustments from our other bills pending resolution
That's
of the aforementioned dispute.
Yes.
So,
Now, my lord, so, my lord, what are we saying?
you referred to that, and
Yeah.
kindly the mechanism provided under section article clause 34 of
Yes,
the
yes.
private sliding agreement.
Well, what are we saying? We are saying the question as to whether this bill is payable or not will be decided arbitration, but the arbitrator cannot decide as to whether they can appropriate, my lord, bills payable under the siding contract from the wagon contract.
Correct.
And, my lord, that is clear, my lord, made clear in Kamaluddin Ansari.
No,
My lord,
the answer is correct, but you have approached the arbitrator
for
the
a very
same
limited
claim,
purpose.
For the same claim.
No,
How
my
the-
lord, I have asked him to adjudicate. My lord,
how can you turn around
my lord,
now?
can your lordship, my lord, decide as to, my lord, whether this amount is due or payable? My lord, that inquiry your lordship
So
cannot
this
do.
court cannot. So you go
So,
to
my
the
lord-
arbitrator. Why this court? Now, if you go to the arbitrator, you go to the section 9. Why?
No, my lord,
why
section
the
9 arbitrator cannot, my lord, do that, because, my lord, the arbitrator will then.
Once you play page 166, 167, you have claiming the same amount. Can you see?
My lord, my
Kindly
very
see page
respectful.
166 last
Yes, my lord,
paragraph.
I have seen it.
Yes.
My lord, and my lord, not only
Sliding,
that.
sliding agreement, sliding contract. That
No, my lord, siding contract, whether money is due or payable or not, will be decided in arbitration.
correct.
Now, my lord, whether the question is, my lord, what is allegedly due to them under the siding contract, they can realize from the wagon contract. My lord, how can the arbitrator decide that?
And that has been issued by you only after receipt of this.
No, of
payment,
course.
This notice.
My lord, my very simple, my lord, humble submission before lordship is, my lord, the question as to whether the money that is payable under the siding contract can be realized from the wagon contract is something that the arbitrator cannot decide.
Let the arbitrator decide. No, he cannot decide. He cannot decide. Then we'll see.
Well,
to
he
that.
cannot decide this, my lord, with the greatest
How?
respect.
You have claimed, sir.
No, no.
163,
My lord,
167.
kindly see, my lord, I have no option but to go to arbitration for adjudication of the quantum due.
Once you approach the authorities with regard to the arbitration, kindly see the paragraphs.
Yes,
Page
yes,
166, last paragraph,
I
and
have
the next
seen.
paragraph of 167.
My lord,
Clearly, you have.
I have, of course, my lord, and my lord, thereafter I've also issued a section 21 notice. But my lord, that is only for adjudication of what is, my lord, due, if any money is due at all. That cannot, my lord, ultimately allow the arbitrator, my lord.
Kindly see the second line.
Yes, my lord.
Coercive steps or make any adjustment from other bills pending resolution of the aforementioned dispute.
That's right, my lord. Now, my lord, I am saying that you do not, my lord, make any adjustment because I am going to go to the arbitrator to, my lord, decide as to whether any money is due and payable. Arbitrator may decide money is due and payable. Arbitrator may decide money is not due and payable. But in the meantime, the question is, my lord, the question whether the arbitrator will have jurisdiction to direct appropriation from the wagons contract or not direct that. My lord, that jurisdiction the arbitrator will not have, and that is, my lord, exactly what Kamaluddin Ansari has said in paragraph 10. And my lord, the second question, my lord, which my friend
That's
said.
correct. I totally agree with you with regard to the judgment of the Kamaluddin Ansari.
This is, my lord, only a demand justice.
But once you have made up your mind for deciding the issue by the arbitrator, can you turn around and file the writ application?
But I have, my lord, I have separate remedies.
Arbitration Act.
My lord, writ application is filed first. My lord, section 21 notice is thereafter. But my lord, my respectful submission is
11 July 2020.
well, I cannot. No, my lord, this is not the section 21 notice.
Whatever it may be, your
My lord, this is the demand justice only.
demand justice notice.
Well, the section 21 notice has come thereafter because I say that, my lord, no money is due and payable and that dispute has to be adjudicated in arbitration, not the dispute as to whether there can be an adjustment of, my lord, private siding bills from wagon contract. That is not the subject matter of arbitration. My lord, please see, my lord, what is the dispute of which I have sought reference? Whether, my lord, any, my lord, OHE charge is payable, whether any inspection charge is payable. Well, I'm sorry, I think I handed up the wrong, my lord, document to your lordship. Well, the section 21 notice is, my lord, whether any inspection charge is payable, whether any OHE charge is payable. That is, my lord, the section 21 notice. Not the question of whether there can be adjustment of one claim from another. That is not, my lord, my claim.
No, that is.
Well, otherwise, my lord, I would have gone and filed a section 9. I would not have troubled your lordship. That I cannot do.
Correct. So why this court can entertain all these?
Because
how this court can adjudicate all these?
Well, I have no other remedy. Well, arbitration court cannot, my lord, grant me this relief because this will be beyond the pale of, my lord, my section and application because of Kamaluddin Ansari. Because I shall be asking for, my lord, arbitrator appointed under contract A to pass an order in respect of contract B. Well, otherwise I would have gone to section 9. I would not have troubled your lordship. My lord, the second question which my learned friend raised, my lord, with regard to the OHE charges. My lord, kindly see, my lord, the circular that he has handed up to your lordship. My lord, this circular is of 2025. Circular is, my lord, of 2025. My lord, the exemption is granted to me. Well, I have just one.
Yes.
Well, please see, my lord, the circular is 2025.
Yes.
The exemption that is granted to me at page 141 is of 2026. Number one. Number two. Well, please see, what does the circular say? This circular says, my lord, just after the reference, Railway Board is in receipt of South Central Railway's letter under such and such, seeking clarifications regarding applicability of OHE maintenance charges for sidings commissioned prior to FMC of 2016. Our agreement is of 2019.
Yes.
This has no application.
No, subsequently paragraphs are there.
Yes, my lord, but even subsequently, please see the clarification. Well, at first clarification, it is reiterated that the revised guidelines for para number such and such under FMC such and such were issued as an amendment to private siding policy of 2016. Hence, the phrase under board's clarification dated such and such shall not be applied retrospectively implies that the siding commissioned or approved under previous siding policies. Now, my lord, my siding is, my lord, after 2019. And, my lord, this also is something that the arbitrator will decide ultimately. I'm not saying that, my lord, your lordship will decide as to whether this is payable or not payable.
Correct.
Well, I am only, my lord, now saying that assuming for the sake of argument that money is due and payable for on account of maintenance and inspection. Assuming for the sake of argument, money is payable on account of OHE. The question is whether you can adjust it from my bills under the wagon contracts. Because, my lord, I say that this dispute is a dispute for which there is an arbitration clause. As to whether this money is due and payable will have to be decided in arbitration. But whether, my lord, you can realize, even before adjudication, you can realize this money.
Correct, that's I'm telling, so you can.
Well, that, my lord, is very respectful.
In the repetition.
Well, that is, my lord, the difficulty I face. Otherwise, why should I have not gone to section 9?
This court can entertain all these.
Otherwise, my lord, I would have gone to section 9
With
court.
regard to the disputed, whether you are entitled to pay or whether they are liable to pay or they are entitled to recover. How
Well,
this court
I
can?
have come
If it
before
is a
your lordship.
contract matter.
Well, I have come before your lordship, no, my lord. The question here is of, my lord, arbitrary appropriation without any contractual provision to back it up. Now, my lord, had there been a contractual provision in the railway siding contract allowing, my lord, appropriation of bills in one contract from other bills in other contracts, my lord, there would have been different situation. There is no such, my lord, clause. So therefore, I say it is arbitrary attempt to appropriate. And that is why I am before your lordship. Otherwise, I would have most certainly gone to the section 9 court.
Yes.
And I have shown to your lordship, my lord, the judgment in Bharti Airtel, which
Yes,
talks
there is
about.
where is the contact of the sliding agreement with regard to this? The agreement which you have
17, my
shown.
lord, I have shown, my lord.
No, that is the with regard to the manufacture of supply of wagon.
Okay.
Kindly come to the page 144. That is the
Page
with regard to
121.
124. 144.
144.
144. That is for my manufacture of supply of the wagons. That is not with regard to the sliding.
Yes, my lord.
Then
Maintenance and inspection charges of such and such. This office letter number, even number dated 21st of July, 28th of July.
where from you are reading?
Page 124.
144.
144.
Yes, my lord.
144. Kindly see contact number 77 for manufacturing and supply. Where is the sliding?
Contract number such and such dated 28 to 2024 for manufacture and supply of wagons.
And this,
My lord, he tendered the President of India action through the Executive Director Railway.
and sliding tender is 158.
And for you manufacture supply of
Sliding tender is 58.
yes, my lord. That siding contract is, my lord, that I have shown. My lord, kindly see.
58.
Siding contracts that starts from page, my lord, 57.
Yes, 58.
Yes.
Yes.
Okay, sorry, my lord, 58. That is the siding, private siding agreement. And the
Correct.
private siding agreement, my lord, that clause 70, clause 8 is there.
Clause 8 is arbitration.
Not, my lord. Clause 8 is, my lord, for the maintenance charge.
Maintenance charges.
And, my lord, clause 34 is the arbitration.
Arbitration.
Arbitration. And
Correct.
clause 17 is there, my lord, for
Not that. That is correct. Arbitration clause maintenance. OEH with regard to the question for taking the amount from the pending areas of the other contract.
yes, my lord.
Where is that?
That is, my lord, clause 17, my lord.
Clause 17 the manufacturing.
My
And
lord,
the sliding agreement.
this is, my lord, for him.
That's
for a
why
moment,
you
my
are
lord.
referring page
My
159.
lord,
You are referring page 159, clause 17. Correct. What this court has
my lord, the GCC, clause 17 of the general condition of contract, my lord.
where is that?
My lord, that is, my lord,
Where is that?
just now I have shown, my lord.
Yes, 159.
Yes, my lord.
159. 159. Kindly come to clause 17.
Yes.
Correct. This clause 17 is continuation of which? Page 144?
My lord, GCC, my lord, the jail, that is, my lord, the jail.
It's not the GCC. This is the contract condition of the contract with regard to the manufacture and supply of wagon. Page 140. It is the continuation of page 144. It is not the GCC. That's why I given a chance on the last occasion. You produce the document. Is there any GCC or
GCC, yes, there, my lord. I have
where is that?
handed over, my lord, that copy. My lord, that I have handed over, my lord.
Handed over what? This one.
My lord, my lord, kindly, yes, GCC, that is also,
153.
that is also, my lord, no, my lord. That is start from page 153, my lord. Kindly see.
That's for
Page
manufacturing.
153.
Kindly see the
Yes, my lord. Indian Railway General Condition of Contract for the Manufacture and Supply of Wagons. Yes, my lord.
Manufacture
And supply.
Supply.
My lord, what they are doing there? My lord, in that private side, my lord.
You satisfy me.
Yes. That is, my lord.
There are two contracts. One is with regard to sliding agreement. Second is the manufacturing and supply of wagon. Correct? What this court and you have claimed with regard to the OEH as well as maintenance. Correct. OEH, there is a dispute. You are telling that as per the letters, so you have withdrawn all these things, OEH applicable. They are relying upon 141. They have stated that OEH is not applicable. That is one aspect. Now, second aspect is now the impugn order dated 3rd of July 2026, page 164, which you have wanted to realize the amount of the pending existing bill. This court has specific put a question to you to show the tender contract. You can realize the amount from the existing contract.
Any other.
Now you have relying upon page 159, clause 17. That's correct. That's correct. That 159 is the continuation of page 144. 144. Page 144 is the contract with regard to the manufacture and supply of wagon, not the agreement, sliding agreement. Sliding agreement starts at page 58. Correct.
Yes.
In the sliding agreement or in the GCC, where is the condition that you can claim that?
Yes.
That is the only
Yes.
question.
Grateful, Your Honor. My lord, kindly consider that the siding agreement for what purpose? They have, my lord, leased out one portion of a railway land.
Correct.
And my lord, what is the purpose of, my lord, leasing of that land? My lord, for manufacturing of the wagon. So, my lord, on that land, which was, my lord, leased from the railway, my lord, on the land they are using for a particular purpose of manufacturing of wagon. And, my lord, for manufacturing the wagon, my lord, they have to pay that is, my lord, that both the wagon agreement and, my lord, the siding agreement, that is to be considered, my lord, together.
Okay.
Otherwise, my lord, that cannot be.
Okay.
My lord,
So why if it is together, why you entered into two agreement?
If
it is
yes, my
if
lord.
it is together, so why you entered into the sliding agreement separately and the manufacturing agreement separately?
Because of the fact, my lord, that initially, my lord, that portion of a railway land was leased out by the siding agreement. And, my lord, they have, my lord, the siding after, my lord, that, my lord, construction of that place. My lord, they, my lord, wanted to, my lord, the manufacture of wagons. And, my lord, for manufacturing of wagons, my lord, that is that process of, my lord, in another, my lord, JK Steel matter, I have, my lord, shown, my lord, prototype, my lord, that they have initially they have to, my lord, satisfied, they have to, my lord, able to manufacture the wagons. Thereafter, my lord, the prototype wagons. Thereafter, satisfaction of the manufacturing of wagons. Then, my lord, they have executed this agreement. And, my lord, so, my lord, if your lordship not consider this together, my lord, that cannot be separated because, my lord, on the land where I have, my lord, the railway has leased out, and in this land, my lord, they have manufacturing the wagon. And, my lord, in this there, my lord, the for OHE, my lord, the overhead equipment, my lord, why that was the overhead truck, my lord, that was installed, my lord, for what purpose? If, my lord, the electric engine, my lord, otherwise that cannot be moved towards the factory or that cannot be go out of the factory. For this reason, my lord, for their manufacturing, for the purpose of wagon, that was installed. So, my lord, which was so installed for their profit, my lord, for manufacturing, my lord, they have to pay, my lord, the maintenance for that. And, my lord, that maintenance, that cannot be done by the
That's
petitioner
why
himself.
at this stage, this court is not going to decide whether they are liable to pay maintenance. You are liable to
Yes, my lord. They have
entitled to recover the amount. Now, only the question is that whether, because they have taken the two plea. One plea that in the sliding agreement, there is no contract, there is no condition that you can claim the amount which you are claiming that cannot be realized from the existing bill. of the contractor. One. Second, they are telling that though he has given the arbitration, but the arbitration which the claim of the 2017-2018, that is not in consonance with the agreement. This is not the subject matter of the agreement. That's why the arbitrator cannot decide that issue. So they wanted to decide this. This
My
is the
lord,
two.
my lord,
Now the question whether it is agreement or not, let the court be decide. On the last occasion, this court has categorically informed and directed you to show the clause whether you can realize this amount from the pending bill. So you are showing the clause of 17, which is with respect to the manufacture and supply, not with regard to the sliding. So that is the only question. What you mean?
and my lord, kindly consider one thing, my lord, their standpoint is also, my lord, contradictory. That is page 167.
Yeah.
And my lord, that clause 17, my lord, that is applicable, my lord, in respect of also, my lord, the maintenance charges also.
Okay.
My lord, may I have your lordship's leave, my lord?
Yes. The petitioner has filed the present.
And my lord, that learned honorable single judge has been judgment, my lord.
Yes,
that,
I have.
that will correct also.
The petitioner has filed the present writ application challenging the impugn notice dated 3rd of July 2026, wherein the railways have claimed an amount of rupees 1,40,57,835.32 from the petitioner, being the maintenance and inspection as well as OHE maintenance charges from 2017-18 to 2022 to 2025, 2017 to 18 to 2022 to 2025. The counsel for Mr. Shah Leonard Senior Advocate representing the petitioner submits that in the said notice, the respondents have threatened the petitioner that if the petitioner will not pay the aforementioned amount, the respondent authority adjust the amount from the existing pending dues of the petitioner against the Eastern Railway. And counsel for the petitioner submit that there are two agreements entered between the parties. One is with regard to the agreement. One is with regard to the private sliding agreement dated agreement number 567 dated 6th of February 2018, and another is with regard to the manufacture and supply of wagons. He submitted that under the sliding agreement there is no provision or clause that the respondents can, that the railway authorities can adjust the pending amount of the petitioner from the existing pending dues of the petitioner. Counsel for the petitioner further submit that though in the agreement there is a clause of arbitration, but the claim raised by the railway authorities are beyond the purview of the agreement, that is from 2017 onwards. But the sliding agreement was entered in 2018, and as such, the claim of the respondent will also not coming under the purview of the said agreement. Thus, the arbitration clause will not apply with regard to the said claim. The learned counsel for the petitioner further submit that by a letter dated 30 January 2026, the railway authorities have informed that OHE maintenance cost in respect of the petitioner for siding Baraipur is not applicable and is exempted. But in spite of the same the respondent authorities in the impugn notice have claimed the OHE maintenance. OHE maintenance charges. Okay.
My lord, if your lordship will permit, my lord, may I offer one clarification? Your lordship has been pleased to record, my lord, it is the petitioner's submission that since, my lord, the claims have been made for a period since 2017, my lord, and the agreement is executed in 2019, the claims cannot come under this agreement.
Yes.
That perhaps is not correct, my lord, because if your lordship will see the agreement at page 90, it says, my lord, it comes into effect from 2003.
90?
90, my lord.
It's
From page 88, my lord, will see the private siding agreement. It takes effect, my lord, from 7th November 2003.
Where
clause
is that?
37.
Where is that?
Clause 37, my lord, at page 88. So it takes effect from an antecedent date.
But though the siding agreement was entered on 6 February 2018, but the agreement will be given effect to from 7th of November 2023. This is the
yes, my lord.
2023. Full stop. Land Council for the petitioner has relied upon the judgment in the case of Bharti Airtel Limited and another versus Vijay Kumar V. Iyer and others reported in 2024 SCC online SC4 and submits that SC4 and submits that contractual set-off is a matter of agreement rather than a separate application of set-off. He submits that the parties are free for mutually agreement on the outcomes they desire, being consciential when he expressly stated the normal rules of set-off regarding the mutually credits or debts, liquidated debts, and connected debts aspect relevant to the notice while dealing with the statutory legal set-off. The Land Council for the petitioner further relied upon the judgment in the case of Gangotri Enterprises Limited versus Union of India and others reported in 2016 volume 11 SCC 720 and submits that the person who commits a breach of contract incurs any pecuniary liability, nor would be true to say that the other party to the contract who complains of the breach has any amount due to him from the other party. As already stated, the only right which he has the right to go to the court of law and recover damages. He further relied upon the judgment in the case of Messrs. H.M. Kamaluddin Ansari and another and company versus Union of India and others reported in 1983 volume 4 SCC 417 and submits that the question whether any amount were payable by the appellants to the petitioner to the respondent under other contract was not subject matter of the arbitration proceeding. He submits full stop. Per contra, an advocate appearing for the petitioner, appearing for the railway authorities, raised a preliminary objection with regard to the maintainability of the present date application. He submits that as per the agreement date, as per the siding agreement dated 6th of February 2018.
My lord, it's 25th September 2018. 25th September 2018, my lord. 6th February 2018 is a land license agreement. It's separate, my lord.
What is the date? 25th of September 2018. ऊपर भी डेट करना 25 September 2019 19 19
My lord, only one thing, my lord, that the railway board circular dated 19 December 2025 that has given right to the railway to, my lord,
I will come here to the
that is
submission.
on
I will record.
23rd June 2020. But my lord, railway charge this charge on
I will
finance
come.
on
I will record your submission. क्या बोला? The counsel for this respondent raised the objection with regard to the mentality of the writ application on the ground that the agreement dated 25th of September 2019 contains the arbitration clause, and the petitioner by a letter dated by a notice dated 11th of July 2026 has admitted that the dispute between the parties is to decided under the arbitration, but instead of initiating the arbitration proceeding, the petitioner has filed the present writ application. Full stop. And counsel for the respondent further submit that time and again the respondents have issued the demand notice with regard to the claim of the respondent, but the petitioner has not paid the said amount, and as such, finding no other alternative, the respondent authorities have issued the said notice directing the petitioner to pay the amount of 1, 40, 57, 853.32, failing which the amount will be, the pending dues will be recovered from the will be adjusted from the pending bill of the petitioner. He has relied upon the clarification dated 19th of December 2025, wherein the railway authorities have clarified regarding applicability of the OHE maintenance cost oblique charges for siding commission, and submit that the query raised by the zonal railways have been clarified by the concerned authority, wherein it is categorically mentioned that the siding oblique terminal commission prior to FMC 11 of 2016 are not supposed to pay OHE maintenance charges, as there are continue to be responsibility of the railway siding. But subsequently, it was further clarified that the revised guidelines of the OHE maintenance charges within bracket over siding commission under the FMC 11 of 2016 are applicable with effect on 23rd of June 2020. That is,
yes, my lord, that is charge, my lord, with effect from 25th of October 2022, page 164, my lord.
No, their clarification, the revised guideline, kindly come to the page 1 which you have given to that 19 December 2025. That is from the date of issue of the amendment letter prior to the date of siding terminal were governed as per the so and so. He further submit that the authorities have further clarified that OHE maintenance is to be taken up by the railway and the cost thereof to be raised by the railway as OHE maintenance charges as per the guidelines mentioned in the board's letter dated 6th of March 2024. 6th March 2024. Full stop. The counsel for the respondent further submits that in clause 8 of the siding agreement provides for maintenance and the other charges, and as such the respondent authorities have raised the bill with regard to the maintenance and inspection as well as the OEH maintenance charges in accordance with the agreement. Thus, the petitioner cannot say the respondent authorities cannot raise the maintenance charges and OEH maintenance charges. Yes, any further?
My lord, that is page 164.
My
lord, your lordship was pleased to record that was, my lord, railway can be charged with effect from 23rd of June 2020.
Yes.
But in that case, my lord, railway charge from the date 25th of October 2022. My lord, page 164, that is the impugned bill, my lord.
Yes. So with regard to 2017 to 2022, there'll be no charges.
No, my lord, 1720, that was the two part.
Ah,
That is maintenance and inspection, that was from 1718.
correct.
But my lord, the OHE maintenance, that is from 25th of October 2022.
Fine. Yes.
But my submission is this, my lord, the OHE can be charged from 23rd of June 2020, my lord. That is my lord clarification circular
The
19th
counsel for
December
the
2025.
respondent further submits that in terms of the clarification dated 9th of December 2025, the respondents can claim the OEH maintenance from 23rd June 2020 instead of 25th of October 2022. If we submit that the claim made by the respondent in the impugned notice dated 3rd of July 2026, the OEH maintenance charges is to be claimed only from 23rd of June 2020, not from 25th of October 2022. Full stop. And counsel for the respondents has also relied upon the judgment in the case of Kamiluddin Ansari Supra, and submit that the Honorable Supreme Court has categorically held that injunction order restraining the respondents from withholding the amount due under other pending bills to the contractor virtually amounts to a direction to pay the amount to the contractor. Such order was clearly beyond the purview of Clause B of Section 41 of the Arbitration Act. By referring the said judgment, Learned Counsel for the respondent submitted if this court pass any order restraining the respondent for realizing the amount claimed by the respondents, this amounts to allow the petitioner to pay the remaining pending bill of the petitioner. The petitioner also relied upon the unreported judgment passed by the coordinate bench of this court in the case of Titagar Wagons Limited and another versus Union of India in WPA 18852 of 2021 dated 5th of April 2022, wherein the coordinate bench of this court held that the matter falls in the realm of private contract between the railway and the petitioner, and the demand raised by the railway cannot be gone into or decided by the court since it involves a disputed question of fact requiring a trial by evidence, and the Honorable Judge has dismissed the writ application. Had the learned counsel for the respective parties peruse the materials on record. The respondents have claimed an amount of rupees 1,40,57,835.32 by the impugned notice dated 3rd of July 2026, being the maintenance and inspection as well as OHE maintenance charges. The maintenance and inspection has been claimed from the year 2017 to 2018, 2021 to 2022, 22 to 23, and OEH maintenance charge has been claimed from 25th of October 2022 to 24th of October 2025 and 24th of July 2022 to 24th of July 2020. But at the time of hearing of the present application, at the time of hearing, the learned counsel for the respondent submit that the OHE maintenance charges is to be paid by the petitioner from 23rd of June 2020 instead of 25th of October 2022. The issue raised in the present application whether the claim made by the respondents are coming under the purview of the arbitration clause. Clause 34 of the siding agreement dated 25th of September 2019 provides for arbitration, which reads as follows. 8 of origin. Page 87, clause 34. As per the said clause, any dispute or differences of opinion between the parties to the respective rights of obligation of the parties hereunder, or to the true intent and meaning of this present any condition thereof arising such dispute or differences of the opinion, the arbitration and the parties has to approach the arbitration. In the present case, the respondents have claimed the OEH maintenance charge, have claimed the maintenance and inspection charges from 2017 to 2023, and the OEH maintenance charges from 25th of October 2022. Now the respondents claiming that the claim should be from 23rd of June 2020 till 24th of July 2025. The siding agreement was entered on 25th of September 2019. But as per clause, as per clause 37 of the agreement shall deemed to have come into force on and from 7th of November 2003. 2003. The Land Council for the petitioner submits that that the claim raised by the respondent authorities are not coming under the purview of the arbitration, and the arbitration cannot decide the said claim. Thus, this court has to decide whether the claim raised by the petitioner and whether the claim raised by the respondent authorities are is to decide with regard to the claim raised by the respondent authorities are legal or sustainable. Full stop. This court find that though the siding agreement was entered on 25th of September 2019, but the same was given effect to on 7th of November 2023, and the maintenance agreement when it was entered, when the maintenance agreement same, where it is. Maintenance agreement is also provided in the said agreement. But the respondent authorities by a letter dated 30th of January 2026 have informed the petitioner that the OEH maintenance is not applicable and is exempted. This court failed to appreciate that why the petitioner has This court also find that the petitioner by a communication dated 11th of July 2026 raised an objection with regard to the demand of maintenance and inspection charges and OEH maintenance charges. In the said letter, the respondents have mentioned as follows. Page 167, 166 last and 167. Full stop. Subsequent to the said letter, the respondent authorities have issued the notice under section 21 of the Arbitration and Cancellation Act. Once the petitioners have taken the plea with regard to the arbitration, whether the claim made by the petitioners is coming under the purview of arbitration is not, it is the matter, and the matter is to be decided by the arbitrator, not by this court. The clause 34 of the agreement also prescribed with regard to the arbitration. And the said agreement also provide with regard to the maintenance charges. Thus, full stop. Whether the OEH has been exempted or not, that is also the matter of evidence. The petitioner has to prove that the letter issued by the petitioner have been respondents with regard to exempting the OEH maintenance is in accordance with law or not. Accordingly, this court did not find any merit in the matter. The petitioner, instead of approaching the arbitration proceeding, has filed the writ application. Thus, writ application is not maintainable. The same is dismissed. Next. Where is the affidavit? Huh? Page 22. Yes. What is your prayer?
For returning of my granddaughter, who has been
What is the age of the granddaughter? 13 years. She is the victim.
She's the victim.
She is the victim. Case initiated where? Police? Where? Mumbai?
Follow-up petition. हमारा क्या repose वाला क्या है discharge तो लोग पहले take मारो page 21 1 position तो लोग पहले see closed and discharge it starts from page 19 the deposition.
Achha, her evidence is over.
Yes, ma'am.
Okay. When the case was, she is the victim of the case.
Yes.
And on the basis of the charge has been framed and the evidence has been closed.
Taken my lord, she has deposed my lord, is got to take my lord page 21 my lord 20 my lord fourth paragraph. I stated everything to the magistrate and the speaker by my second mark volunteer.
Yes.
Now you have to take my lord the next page and subsequent. My lord fifth line. From top.
Yes, I just followed.
Followed the instruction of my second mother, expecting no return.
Expecting to return to house of my dadi. With my father.
With my father.
Yes.
Since
Who has filed the present date application?
This application is filed by the grandfather.
Grandfather.
Yes.
And when the incident was occurred, where was the minor?
Minor was staying with her grandmother in Mumbai, madam.
This is a sister grandmother?
Grandmother.
Okay.
She was seized, my lord. She was brought to the magistrate, my lord. Grandmother and the my lord child both were brought, my lord. The grandmother is right now languishing the bar, my lord. Father has been obtaining bail, my lord.
Grandmother?
Grandmother is still in the custody, my lord.
She is in custody.
Yes, because my lord, she was directed to produce, my lord. She could not produce the child. The police authorities were recovered her and produced, my lord. Now, my
Against whom the case was initiated?
against the father.
Against the father?
Yes.
And who is the petitioner here?
Grandfather.
Grandfather.
Yes.
Yes.
You lordship kindly sees my lord the affidavit, page 24.
Where is the FIR?
The FIR is that starts from my lord complaint is at page 16, my lord. And all the contents of the FIR is page 13.
Where is the complaint?
Complaining that my
Who
lord.
has made the complaint?
My lord, page 16 is the complaint.
Raj Mukhopadhyay, inspector. Complaint against Lufta baby. Who is the Lufta baby grandmother?
Yes. Zero.
Who is the petitioner here?
The grandfather, my lord.
Grandfather.
Yes,
So
ma'am.
Lupta Bibi, grandmother.
Yes,
So Lupta Bibi is the wife of S.K. Mojammal.
yes, ma'am. She was my second wife, my lord. She has tutored, my lord. Don't you kindly please, my lord, page 24 once, my lord.
No, that is correct. But thereafter the chairperson Uttapara was communicated to provide the confirmation. Subsequently, it was informed that the chairperson C.W. Yugli through the PS email, VG was handed over to the grandmother Lupta Bibi. Lupta Bibi is the accused herein now.
Yes, ma'am. Because she had not surrendered, my lord, to the court.
And from the Pravarak. As such, the grandmother, the Lupta Bibi was the custodian of the VG. After the grandmother VG was, Lupta Bibi was examined several times. VG was placing before the court and compliance with the order. So, see, the Lupta Bibi is the original grandmother or the step grandmother?
My lord, she is the original grandmother.
Lupta Bibi. And who is the second grandmother?
My lord, that is not possible.
Ah.
Because I am the biological.
So where you put the daughter to because
I say, my lord, the daughter should stay with the grandfather, my lord. I will take.
let this remain here in the CBC. Why she should come out? They're providing the education.
My lord.
No, they're not providing education. CWC.
No, my lord.
Since when
Actually,
she is in custody of the
actually,
CBC?
my lord, inquiry is already has been going on. My lord.
Inquiry is leaving aside. Once the child is in the home.
Yes, my lord.
So whether the education facilities have not been provided to the minor.
That should be, my lord, but I shall
What
take
should be?
instruction, my lord.
Why the grandfather will take? Because earlier grandmother has taken, this incident was happened. Then
cannot improve, my lord. I say, my lord, whatever is the stringent condition we put upon me, my lord, I will bring her, my lord.
no. You file the report
Yes, my lord. Kindly fix it. My lord, report has not been ready yet, my
from the
lord.
CWC.
Yes, my lord.
When you file the report.
My lord, fortnight, my lord. Fortnight, my lord.
And you since when she is in custody? Since when she is in the seat with the home? October 2024.
24.
So 24, 1 year, 2 years is going to. What is the condition of the victim? Whether she has been given the education facility or not?
That shall, my lord, I shall take instructions, my lord.
The counsel for the state press for time to file report with regard to the status of the victim girl in the home. Let the report be filed within 2 weeks. After let the matter appear. Let the matter appear on 20th August 2026 under the same heading. Open legal affidavit filed by the petitioner be kept with the report. 20 August.
20th August. March.
Same heading. Yes, next. Yes. Yes, what is the matter? Huh? 18. (26 to 30). Sanction of credit facilities. What is the total amount? 150 lakhs. Okay. Yes. Yes. %18 per annum on excess drawing. Yes.
My lord has got it.
Where?
Page 29.
Uh,
Absolute left. There's a column as per other terms and condition matrix. Left. Top left, my lord.
top left, as per other conditions. Yes.
Now, my lord, kindly comes to absolute right. Second, my lord, column. 2% over and above prevailing rates in case of stock and book debit statement. Delay. Now, my lord, I will correlate this, my lord.
Now, where from you are reading?
My lord, this is the column I'm reading, my lord.
Insured insurance, stock and book debit.
First is, my lord, valid insurance not submitted within 30 days. Second is, my lord, stock and book debit statement.
Correct.
In case of failing, my lord, there's a penalty 2% over and above prevailing rates for irregular period.
Okay.
So, my lord, whatever the amount of interest, the percentage of interest, 2% extra will be levied. So, this is the clause, my lord. I will correlate this, my lord, as I proceed. Now, my lord, kindly, my lord, comes to page 61 of the writ petition. This is an email communication.
61.
Lordship, 29th January 2025.
Yes.
Lord, this is a communication by the bank asking me to pay 7 lakhs. Otherwise, my account will be declared as NPA. Kindly, my lord, notes the date 29th January.
Yes.
Now, my lord.
Credit note, please deposit 7 lakh into your account, else the account will be NPA.
NPA.
Yes.
Now, my lord, kindly comes to page 68. This is a notice of section 30 under section 13(2).
68.
Lordship. This is dated 19th of June 2025.
Yes. Surface side.
Lordship. Lord, the relevant page is at 70. It starts from 68.
Yes.
Lord, kindly comes to page 70. My lord will find at my lord paragraph 3.
You as borrower borrowed the so and so.
This has been declared NPA as in 28th of January 2025. Similar, the date on which they have declared NPA, after that they are asking me to pay 7 lakhs. I have paid 9.25 lakhs.
29 January, you have been directed to pay 7 lakhs.
7 lakhs.
When you paid the amount?
Milord, after that I have paid the amount of 9.25 lakhs, but Milord kindly sees in the
notice was issued on 19 January 25.
Lordship. And 19th of June.
Yes.
29th January 2025 is the communication.
Correct.
And 19 June 2025 is the notice.
Correct.
Section 32 notice.
Correct.
13(2).
Correct.
There they are saying that account has been declared NPA on 28th January 2025 already. So,
correct.
Kindly, my lord, takes note of this. Now, my lord. My lord, I'm being led by Mr. Gupta, my lord.
Yes.
Your lordship, at the occasion to hear this matter, issue is date of the first letter asking me to pay is 29th of January.
Correct.
19th June, we have been informed that 28th of January it is NP.
Correct.
So your lordship would recollect when we first moved the matter, we had pointed out entries within the last 90 days to show that we have made payment of the interest. Your lordship was satisfied with that, called up on the other side. They said that we want to use an affidavit. In the affidavit, they make a diametrically opposite stand. But what is the stand? That my that the payments which I have made was not sufficient within the meaning of the circular, and I take your lordship to the wording of the circular to make it.
No. When you made the 7 lakh rupees, when you made this rupees 7 lakh, paid the 7 lakh rupees
within 90 days. So, may I take your lordship to the circular ones, and I'll try and demolish all 3 cases which they have made out. Kindly takes a look at my supplementary affidavit once, my lord. But we had annexed the circular of the Reserve Bank of India.
Yes.
My lord, will kindly have a look at page 10.
Yes.
2.1.2, has your lordship got it, my lord? A non-performing asset is a loan or an advance where, kindly marks this, my lord, interest and or installment of principal remains overdue for a period of more than 90 days in respect of a term loan. May I pause here for a moment with my lord's kind indulgence? We had shown we have paid interest within this 90 period.
That's
90 days.
where you paid?
I shall show. Your lordship was satisfied on that. I shall show that once again. Then 2, the account remains out of order as indicated in paragraph 2.2 below. Here is where what they are now coming to. Kindly see 2.2, page 11. Page 11, 2.2 gives what is an out of order status. Kindly see 2.2.1, then a CC or an OD, cash credit or overdraft, account shall be treated as out of order if, then 1, the outstanding balance in the CCOD account remains continuously in excess of the sanction limit or drawing power. This was never the case in their opposition previously also, Now they are coming up with this case in the supplementary. I shall show why this is also wrong. Then 2, the outstanding balance in the CCOD account is less than the sanction drawing limit or power, but there are no credits for continuous period of 90 days, or the outstanding balance in the CCOD account is less than the sanction limit drawing. Then 3, power, no, I'm sorry.
But the credit are enough to cover.
Not enough. They had, initially, first day, they were saying 90 days period, we defaulted, we showed no. Second, they have said, this last leg, that the credits are not enough to cover. We take this point in their opposition. We deal with this in a reply. Not, your lordship was satisfied on this also. I'll take your lordship one by one. Now they're coming up with a third case in the supplementary affidavit. They are saying it's below the sanction limit. The withdrawal is below the sanction limit. So I need to, my lord, get all these 3 points off my back one by one. Firstly, my lord, we'll kindly take a look at how 90 days, within the period of 90 days, I have made the payments. My lord, will kindly have a look at. But kindly notes, my lord, the date, 29th of January. 28th of January is the date of the NPA. So I need to satisfy your lordship 90 days prior to that. Now your lordship would kindly have a look at page. Kindly takes a look at my writ petition, my lord, page 37. 37. My lord, there are 2 entries. Possibly these would be marked in my lord's brief also. Page 37.
Yes.
Your lordship would find 2 entries, 9th of January and 28th of January, both within that period. This is so far as January is concerned. Now, my lord, we'll kindly have a look at page 38. This is December, amount of 45,000. 27th of December.
Yes.
Their bank statement, my lord. I am not. Now, my lord, we'll kindly have a look at, my lord, page 40. Your lordship would find payments from 30th October onwards. Kindly marks, my lord. 30th October, 4 lakhs. Then, my lord, 31st October, your lordship would find several entries, 65, 63, 64, 63, 64.
Yes.
And in fact, in the bottom of that page, total credit, they are counting it as 10,49,000.
Yes.
But they have not reflected this amount in their opposition. Kindly takes a look at their opposition. So, my lord, within 90 days, I have made this payment. So 30th October to 28th January is 90-day period. So within that, I have made payments on 30th, 31st October, 27 December, 7 January, 28 January. Now kindly takes a look at their opposition case.
No, January 29 January, the notice was issued.
Yes, so I have made payment on 28th and 7th. January 2 payments I have made.
January you have made.
Page 37, my lord. We'll kindly have a look at.
37, 2 payments, 50,000 and 1 lakh.
Yes, yes. So all payments within 90 days.
Okay.
So, my lord, this 90-day period of non-payment.
No, how you consider 90 days?
Lord,
January the notice was issued.
NPA has to be, from the date of NPA, the look back period is 90 days.
Correct.
So if your lordship considers 28 January as the NPA date,
correct.
So the look back period takes us to 30th of October.
How the 90 days 30th October?
No, because October 30th, then we are remaining with 1 day in October. Then November,
When the notice, January,
no, my lord, it's not about the notice. It is, my lord, regarding the date of the NP. So for a continuous period of 90 days, from the date of the NP, if it remains unserviced, then that is a out of order status. One.
no, they have issued the notice on 29th of January 2025.
Asking me to make payment.
Make payment of
Yes,
7.
yes.
Correct.
So as on that date, I did not know my account was NPA.
Correct.
I have made subsequent payments also.
So you have made the payment on 28th January. Notice was issued on 29th January. So leave aside the January and 28th January. Why the 28th January? Because after the 28th January, they have issued the notice on 29th of January. 29 January. So 29 January, with the notice, if the notice dated 29 January is taken into consideration, to 90 days will come when? February, March and April.
No, not after. I'm saying before. NPA, for an account to be declared as NPA, there has to be continuous non-service of interest for 90 days.
90 days from when?
No, kindly sees for a period of 90 days pre the date of NPA.
That's why you will.
Kindly sees my supplementary affidavit where I have annexed the Reserve Bank of India circular.
Overdue for a period of 90 days in respect of.
So overdue.
Interest and installment of the principal overdue for a period of more than, yes. So they have informed you on 29th of January.
Correct.
So 29th January, there was NPA.
28th January was NPA.
Huh?
28th January.
28th January. Okay, 28th January. There was NPA.
So look back period is 90 days is December, November, October. If my account remains unserviced for 90 days, then only it can be declared as NPA.
Correct.
So, my lord, if I can show that I have been paying interest in this look back period of 90 days, so then, my lord, I am through so far as clause 1 is concerned. I need to satisfy your lordship on 1, 2, 3 all. I'll do that. But so far as 1 is concerned, that 90 days, but here, my lord, I am through because I've made payments within that 90-day period. So, NPA is declared, so the account stops functioning. So,
what was the cash credit limit?
150 lakhs, 1.5
50 lakhs.
Yes, yes.
Correct.
Yes.
And as on when was they are taking the plea that on 28th of January and your account was become NPA. Prior to that, 90 days is to be taken into consideration.
Yes.
So within 90 days, what was the amount lying in your bank account?
No, but I have paid interest. I have shown these transactions, page 37, 38 and 40. Within that 90-day period, I have paid interest.
You might be paid interest.
Yes. So, my lord, 1 goes off. So, 1 is out of the equation. I need to now satisfy your lordship with 2 and 3.
First, you have to satisfy whether within that 90 days there was not overdue. You paid interest. You might be paid
So,
interest.
that is the second clause. That is exactly what I need to satisfy you.
Correct.
Yes, so I am coming to that. Yes, now your lordship would kindly take a look at their affidavit in opposition, where they have not acknowledged the amounts paid by me. Your lordship would kindly take a look at page 8.
Yes.
Possibly your lordship would also be having a marking on this. Page 8, paragraph 7, there is a table there of their affidavit in opposition, my lord.
Yes.
Has your lordship got it, my lord?
Page 8.
Page 8, paragraph 7, my lord.
Paragraph 7. That's one number 2 and 3.
Yes, my lord. It's an affidavit, my lord, affirm.
On behalf of the petitioners to the supplement.
No, that's a different document. But it should be, my lord, an affidavit which is affirmed by, no, it's only headed affidavit in opposition in the backsheet of Miss Soni Ojha, my lord.
Where is the affidavit in opposition?
But we had given a copy because the affidavit got misplaced. We had given a photocopy.
Okay. Page 7.
Page 8, my lord. Kindly takes a look at the table at paragraph 7, my lord.
Yes.
So they admit these payments made. Kindly see amount actually paid by customer. There is a 45,000 entry on 27 January. There is a 9 January entry of 50,000 which has not been paid. And 1 lakh. I had shown from the bank account. Now, interestingly, kindly see the first column, first row. Value date, your lordship would find there is a description of transaction. Your lordship would find interest debited till 31st October. They received the payment, they have not shown this in the affidavit. I had shown the payments at page 40. But if your lordship wants me, I can kindly keeps this open and kindly takes my writ petition. Kindly sees their bank statement. I have made payments of 3,24,000 on 30th October and 31st October, which they do not take into account.
That's why. So, as per your case, the amount actually paid by the customer that has not been shown.
Yes. Shown in the bank statement, not in the affidavit.
That's right.
Yes.
They have not shown.
Yes. Now kindly takes a look at their annexure.
As per their amount to be paid by the customer is totally 4,55,578.
But this is a different story now they are running. But
no,
may I try and segregate into three parts?
So you are telling that because as per the third clause.
Yes, Mullah.
As per the third clause, amount to be paid by the customer 12,06,585.
Yes.
Correct. This was to be paid by the customer. They are telling that you are not paid, and you are telling that you have paid. It has not been shown. Where is that?
Yes, Mullah. Could I try and dissect into three parts, Mullah? So first clause, to declare my account as NPA is continuous non-payment of interest in 90 days. We are through. Correct. Now the second clause.
Correct.
Kindly sees now. Kindly takes a look at my opposition to my affidavit in reply.
Mr. Gupta.
Yes, Mullah.
Come to the paragraph 7. You are in paragraph 7.
Yes, Mullah.
Not to distract that. Come to the paragraph 7.
Yes, Mullah.
1/11/2024 interest debited till 31st of October 2024 1,26,585. Correct. Amount to be paid by the customer.
Yes,
they are telling that 1,26,585 is to be paid. Whether this amount was paid by you?
We have paid 3,20,000.
Where is that?
Page 40 of my writ petition.
Page 40.
Page 40. Kindly keeps this table and the writ petition side by side. Kindly sees page 40. Your lordship would find there are 6 entries. One is 30th October. Your lordship would find 4 lakh.
Correct.
Then your lordship would find 31st October 5 entries.
Correct.
65, 63, 64, 63, 64.
Correct.
So during this, all these amounts would add up to 7,24,000.
7,24,000.
4 lakh plus 63 plus 63 plus 64 plus 63 plus 64.
Okay.
So these are aggregate to 7,25,000.
Correct. 25 or 24?
But দেখ না কত হচ্ছে 65 into 5 মানে 3,25,000 minus 3,20,000 but around 3,20,000. 3,20,000 3,19,000 3,19,000. So 7,19,000.
7,19,000.
19.
Yes. 7,19,000.
Yes.
Correct.
So their amount, I've paid more than that amount.
Correct.
Now your lordship would kindly.
More than amount. Okay. So as per your case, so within 90 days you have paid the amount.
Yes. Now
so
kindly.
Now come to the 7. Now come
yes,
to the
kindly comes to 7.
1/11/2024. They are claiming that 1,26,585
was to be paid.
Actually,
they are showing 0.
Correct.
This is the fraud.
Correct. So, but you have paid this amount by 31st.
Yes.
October.
Yes.
So they have not considered this.
They have not considered this.
How this 12 lakhs, 1,26,000.
That I do not know, but they have not considered any payment I have made.
Okay. Then
kindly sees the second row. Interest debited till November 1,17,934. I have not paid. So that is correct.
Where is the debited?
So I have not paid in November. That is correct. But I have paid more in October.
Correct. October you have paid 7,19,000.
I have paid 7. Now kindly sees the third row. These amounts are not relevant so far as declaration of NPA is concerned. They are including some bank charges.
Already declared NPA.
No, I'm saying I'm saying, no, at that point of time, it was not declared as NPA, but I'm saying non-payment of these charges cannot be a ground to say I have a defaulter. This is a separate charge, bank charges, whatever it is. So, my lord, item numbers 2 and 3 goes. Then, my lord, 4 is UPI, your lordship would find 45,000, correct entry.
Yes.
Page 7.
Yes.
Page 8. So, this is a correct entry. Then, my lord, your lordship would kindly find 9 January 2025. It's irrelevant for declaration of NPA. This penal charges, this is not a ground, non-payment of penal charges is not a ground for NPA. Then kindly sees cash deposited by self Lake Town, they have not included any amount. I have shown from my bank statement, I have paid 1 lakh. They have also missed 50,000 which I have paid on 9th of January, 7th of January. That is also not reflected. So, kindly see page 37 once more. Your lordship would find on 7th of January, there is a payment not counted. I'm sorry, 9th of January, there is a payment not counted.
Where?
Page 37 of my writ petition. Second entry.
9th of January.
Yes, my lord. There is a payment made.
50,000.
And my lord, 1 lakh on 28th.
Yes.
They have not counted that, my lord. In the table.
Yes.
So, my lord, their contention that now they're totaling this and it's an incorrect totaling, my lord. Their total is coming to, my lord, 4,55,000, whereas I have paid, my lord, 8,19,000 in this period.
8,19,000.
8,19,000. In fact, little more, 7,19,000, 8,19,000, then my lord, around 9,14,000.
9,14,000.
Yes. In this period, my lord. So, my lord, now
14,000.
yes. So, my lord, 2 cases now go. 2 of the clauses. 90 days goes, or not serviced enough interest goes. Now remains the 3rd clause. This is their second supplementary affidavit. Completely diametrically opposite stand.
Yes.
Now they say that we have withdrawn more than the sanction limit. This was never the case. Kindly see that affidavit case, my lord.
Where is the affidavit?
My lord, they have filed another affidavit, a supplementary affidavit, my lord. But your lordship was possibly looking at that a while back, my lord, thinking it to be the opposition, my lord, in the backsheet of Ms. Oja, my lord. If your lordship kindly comes to paragraph 3 at page 3, my lord, it starts with it is submitted that. Has your lordship got it, my lord? Page 3, paragraph 3, my lord.
Yes.
It starts with it is submitted that.
Yes.
Yes. Kindly sees, my lord, it is what their case is. My lord, kindly comes to paragraph 4. It is further submitted that as per terms and conditions of sanction, the borrower was obliged to submit stock and book debts and the creditor statement on a monthly basis containing details of debtors such and such, 10th of every month. In the event of non-deposit of such stock statement within the stipulated period, the same would also affect the credit limit under the agreement. This is a wrong statement I should show from the agreement. It's a wrong statement made on oath. The borrower petitioner herein failed to submit monthly stock statement within the stipulated period, again wrong statement, which is a prerequisite for maintaining regular status in the account, resultantly causing the drawing limit to be reduced by 4 lakhs, wrong, in the month of September 2024 alone. Accordingly, as in the month of September 2024, the drawing power was 137, which was further reduced to 136 in October, 135 in November. Each of these statements are wrong. Kindly sees the writ petition, kindly sees the agreement. Nowhere it is mentioned that the limit would go down if I do not give the stock statement. This is one, and then I shall show I've given the stock statement. They have said thank you. Kindly takes a look at the page 28, my lord. The contract starts from, this is the sanction, my lord.
Yes.
It starts from 26, my lord. Kindly takes a look at page 28. In fact, I cannot show what is not there. Your lordship would kindly have a look at this, my lord. I have not found, subject to what my learned friend submits, nothing so far as reduction if I do not provide stock statement. Only statement or only clause pertaining to stock statement, my lord will find at page 29.
Yes.
Kindly see page 29. This is under the heading as per other terms and conditions matrix. Then stock statement, stock and book debit statement. 2% and above prevailing rates for irregular period. Does not say my sanction limit would come down. Now, my lord, kindly takes a look at my reply to the opposition, where they have thanked us for giving the stock statement.
Page.
Kindly takes a look at my affidavit in reply to this, my lord. Starts from, my lord, page 26. Relevant portion, my lord, will find. Has your lordship got the affidavit, my lord?
Yes.
Yes, my lord. Then your lordship would kindly come to page 27. 27. The stock statement for client ID, has your lordship got it, my lord? Stock statement for the client ID such and such has been processed, and your drawing power is now such and such. It's increased.
Yes.
Then kindly turns to the next page, page 28. Their email, my lord, bank's email, page 28. Stock statement for client ID. This is November. Previous one is October.
Yes.
This is November. The stock statement for client ID such and such is now such and such. Drawing limit is. Again, my lord, March 2025, I have given. So I have been giving stock statements. And, my lord.
No, they are stating that prerequisite maintaining regular status in account causing drawing the power limit to be reduced by 4 lakhs in the month of September 2020.
May I pause here for a moment, my lord? From where are they getting this? A, is there a contemporaneous correspondence? The answer is no.
Okay.
B, on the contrary, I've given the stock statement. Bank has acknowledged, saying thank you.
Okay.
So, my lord, all the three limbs of, my lord, NPA declaration prerequisite, but I have satisfied.
Yes.
Last submission, petitioner is an MSME. So, my lord, they have not even followed that circular also. It was not a point taken in the writ petition, but now since new points are coming up every day with every affidavit, I have also come up with a new point.
Yes.
With my reply that they have not followed the mandatory prerequisite of the RBI circular.
Yes. Yes, madam.
Your Lordship, first of all, it was never our contention that the first clause would apply that no payment was made within 90 days. That's why.
You tell me whether your bank has received the amount or not in October.
Your Lordship, whatever amount.
I am asking one question to you, whether it is correct before NPA 90 days, you have received the amount in October or not?
My lord, if deepest of respect, I submit that, my lord, this is not the only criteria on which NPA can be declared. 90 days period, even that amount was not sufficient. Whatever amount is paid, that I'm not disputing. That is on record. It appears from the statement. But this is not the only criteria on which an account can be declared as NPA.
Where is your affidavit in opposition? You stated that?
Yes, my lord.
What ground you have taken in the affidavit in
Yes,
opposition? That is also not the ground, and these are the ground.
Yes, my lord.
Kindly come to the page 7, paragraph 7.
Yes. Kindly take up page 6, my lord, of my opposition.
Yes.
Page 6, paragraph K.
Yes.
My first point is that, my lord, the whatever amount was paid, that was not sufficient to serve the interest. And in supplementary, I have taken a point, my lord, that when it was called from my lord to show whether from the statement.
What is the amount is to be maintained by the petitioner before declaring the NPA?
That depends upon the utilization, because it's not.
That's why where is your calculation?
It is not a term loan, my lord. Kindly.
So how you can declare the not a term loan? It's okay. It is a cash credit.
Yes, my lord.
Correct.
Yes,
Cash
my lord.
credit, this much amount is to be maintained. This much amount is not to be maintained by the period of 3 months, then NPA. Correct. So 1 crore 50 lakhs is the CC.
No, my lord. This is for cash credit. This is not applicable, my lord. I humbly submit so, my lord. And this 150 cc was reducing every month 1 lakh by every month, which is as per the terms and condition. And due to non-submission of stock statement, my lord, it was in 1 month it was reduced by 4 lakhs, and subsequently every month it was reduced by 1 lakh. So by that, during the period from October 2024 till January 28 January 2025, my lord, for a period of 90 days, this drawing power the drawing power reduced every month. However, the drawing limit exceeded for continuously remain in excess for this period of 90 days, for which
That's why show me.
Yes, my lord. I'm coming. Kindly.
That's the code is asking.
Yes, my lord. I'll search first.
Show me the 90 days. January 29, January 28 January 2026, you declared the
Yes,
NPA.
yes.
So January prior to that, show me the 90 days.
Yes.
This is the
Kindly
this is the amount they have not maintained.
take up my supplementary affidavit, my lord.
Yes.
Kindly first take a paragraph 5 at page number 4. Then I will show the statement, my lord.
Yes.
It is further submitted that on 17/9/2024, the limit was downsized by rupees 1.37 crore. So in September, it was 1.37 crore, which further reduced to rupees 1.6 crore on 16/10/2024 and to 1.35 crore on 19/11/2024. Every month it was reducing. It is evident from the statement of account that the petitioner continued to utilize the facility over the limit from prevailing month. It would be further evident that during the period of October 2024, with the drawing power limit being rupees 1.36 crore, the account was overdrawn during most of the period and further dipped to a debit balance of rupees 1 crore 37, which was in excess of the drawing power. On 31st October 2024, on account of application of interest for the month of October 2024 to the tune of this much. As it is evident from the statement of account, the overdrawn status continues so for the month of November 2024, December 2024, and January 2025, whereupon no further payment was received to maintain regularity in the account. Amount was received, my lord. However, this was already 28 January, whatever payment is made after 28 January, because NPA was declared on 28. So that is kept in a separate account. Now that cannot be taken into consideration. But till 28 January, whatever payment was received, my lord, that was not sufficient to make it regular. Now kindly come to the state.
Now you come to the page.
Yes, my lord.
Now you come to the page 37.
37 of
37 of the writ petition.
Yes, my lord.
37 of the writ petition. So you have a specific case that October, November, December, January, there was a continuous overdrawn. So that's why NPA you are declared on January 28th of January.
Yes.
Now kindly come to the page 37 of the writ petition.
Yes, ma'am, I'm there.
This 50,000 was deposited, 1 lakh was deposited.
Yes, that was not sufficient.
Huh?
That was not sufficient.
Where is a justification of this deposit has been
Kindly
taken
come to
in?
the
Just a minute. Then you come to the page 40. Page 40. Got it?
Yes, sir.
Then 30th October he has deposited 4 lakh. And the total 7,19,000 he was deposited. So after depositing this amount, it was overdue.
9,25,000 included the amount which were paid after the declaration of NPA. 9,25,000 is not paid prior to declaration of NPA.
NPA when the declared, madam?
28 January
20th January which year?
2025.
2025.
Yes.
I kindly come to the page 40 which year?
Pilot, this total amount what?
Kindly come to page 40 and tell me which year?
Was it 20?
Which year?
That is of 31st October 2020. It's the statement is changed.
2024.
Yes.
So now you can say 7,19,000 you have received plus here 1,50,000 you have received. Then how you can say?
The payment what they are mentioning, my lord, that is paid after. There are certain payments.
How it can be after? You are telling that November, December, January.
My lord, I am not disputing that the payment is not made, but that payment is not sufficient, my lord.
Where is your case?
Kindly come to the statement, my lord. Kindly may I just place, my lord, my case, my lord, then whatever my is fallen.
Unless and until court cannot satisfy, I may allow to argue the matter. Let the court satisfy first.
My lord, kindly may I just place a statement of account, my lord, then I will not make any submission, because this is, my lord, payment. I am not disputing that they have not made, but
that's why the court is asking you once you.
The limit is if.
Show me your statement.
Yes, my lord. Kindly take my supplementary affidavit, my lord. That is what I am trying to show, my lord.
Yes, supplementary affidavit is in my hand.
Yes, my lord. Kindly come to page. Kindly come to page 15, my lord.
Yes.
From 31st, kindly take up the entries from 31st October. The last column where all the entries are in minus, my lord, because it has exceeded the drawing power. 1 crore 35, 1 crore 35, always. Now it also goes up to, in January 2025, it goes to 1 crore 40 lakhs. Whereas there was no limit, my lord. Okay. The amount always remain drawn in excess to the limit.
So you tell me that that's what the court is asking.
Yes, this is
so even after receipt of that amount, the amount was
it always they are paid. They paid certain amount.
It was going minus.
But in the same month they crossed their limit of drawing, my lord. So that's why it always remain in excess, in negative, till 24th January. Sorry, 28th January, my lord.
28th January, 13 lakh and 1 crore
39 lakh, whereas the drawing power was, my lord, it was 1.35 crore.
1.35.
Yes, my lord. Kindly come to my supplementary affidavit, my lord. At page 4, I have mentioned the drawing power in January, my lord. It.
Where is which pair?
Para 5 and 6, my lord. In October it was 1.36 crore, and thereafter it reduced.
No, September the limit was downsized 137.
Yes. Thereafter 1.36 in October. In November it went to 1.35 crore. Thereafter in December it will be 1.34, and in January it was 1.33. So continuously this reduction is made as per the terms of the sanction, my lord. That I will my lord has seen from the sanction letter, my lord. Yes. If I once again place, my lord.
Yes. Then
page 28 of the writ petition, my lord.
28.
Yes.
Yes.
Limit to be downsized by rupees 1 lakh per month for the entire renewal period of 1 year.
Where from you are reading?
Page 28, the third block, my lord.
Special condition.
Special condition.
Yes.
Limit to be downsized by rupees 1 lakh per month for the entire renewal period of 1 year. Renewal to be done for 1 year with close monitoring via call memo. So this was discussion of the bank whether to renew further or not, my lord. And kindly come to page 27, my lord.
Yes.
Stock and receivable audit, my lord. It was a primary condition. Stock and book dates and creditor statement on a monthly basis with aging details of the debtors and stock or WIP to be received preferably by 10th of every month for previous month. The book date statement will not include such as. So it was a mandatory stock and receivable, page 27. It was a mandatory condition to submit, my lord. And there was page 29 says the penalties which can be imposed for non-submission of the documents, my lord. So this is my case, my lord, that payments are made.
If stock and book is, it is the penalty, not the NPA. You cannot treat it as NPA.
No, yes. For NPA,
it is only the penalty of 2%.
NPA is not done for non-submission of this stock and dates, my lord. NPA is done.
Okay, so that is not the ground with regard to the stock and debtors.
No, not for NPA. For downsizing the limit, it is the ground, my lord. And
But-
1 lakh was to be done as per the sanction term, and 4 lakh which was done once, my lord, that was as per this terms and condition due to non-submission within time.
But what the paragraph 4 says your affidavit in opposition?
Yes, my lord. Yes. This further submitted that as per the terms and conditions of the sanction, the borrower is obliged to submit the stock and book dates and creditors statement on a monthly basis containing details of the debtors and stock or WIP to be received preferably within.
What is the WIP?
That full, I'm also not aware of that. I'm so sorry, my lord.
Thinking work in progress, but it should not be.
Short bit.
WIP.
WIP, I have to take. In the event of non-deposit of a stock statement within the stipulated period, the same would also affect the credit limit under the agreement. The borrower petitioner herein failed to submit the monthly stock statement within the stipulated period.
How you can say if it is not even credit will affect the credit limit come down? In the event non-deposit of such a stock statement within the stipulated, the same would be affect the credit limit. How it can be?
My lord, kindly come to page 29, my lord.
Page
29.
yes.
Non-compliance of clause 5.
Correct.
Non-compliance of general. This submission of a stock statement is, my lord, its operational terms and conditions. Now, kindly come to page 29.5. Non-compliance of.
General takeover condition.
This is like, no, that's not, my lord. I'm so sorry.
That is not.
Kindly come to page, point 4.
Yes. 0.4, that's a 2% over and above the prevailing rate. You take the interest more than 2% more, nothing else.
Downsizing was done on two grounds.
Downsizing is not maintaining the account properly, downsizing, no problem at all. But with regard to stock and deposit, non-stock and stock deposit, that is only you can charge 2% of the what the interest you are charging actually. How you can say?
NPA is not done for this point, my lord. On this.
No, but your paragraph 4 says like that.
My lord, downsizing.
Your paragraph 4, in the event of non-deposit of such stock statement within the stipulated, the same would be effect of credit limit under the agreement. How?
This is as per specifically.
By deducting the 2%.
2% interest is to be imposed, but
Deducting the
downsizing.
2%.
No, downsizing.
Penalty interest.
Downsizing is done as per the terms of the sanction, 1 lakh per month. That has been done.
That you stated that 136,
And
134,
from the
135.
I have shown, my lord, that it was always for more than 90 days it remained in excess of the drawing power, my lord.
So this is not the ground for
no, this is not the ground for NPA, my lord. Ground for NPA is since it remained in excess for a period of more than 90 days. And may I just show the RBI guidelines, my lord, what it says? What I did. Kindly take up their first supplementary affidavit, my lord.
Yes.
Page 11, my lord, which is applicable in case of CC accounts out of order.
Yes.
2.2. 2.2.
MSME?
No, my lord.
Petition is MSME.
That this for the first time they have come up with that, my lord. In any event, that point is not applicable here, my lord.
I will also come up with
Besides, Swami Samarth construction specifically says, my lord, it has to be done merely by saying MSME. It does not automatically apply. They have to make a representation.
Initial stage. At the initial stage.
Yes, my lord. And
I have paid after that also.
With appropriate.
After January, I have paid. They have taken. So this is not a rogue.
Yes.
The outstanding balance in CC/OD account remains continuously in excess of the sanction limit.
Where
Drawing
you are reading, madam?
2.2.1A
of
clause page 11. Their supplementary affidavit, my lord. They have annexed the circular.
Affidavit in opposition on
No, supplementary affidavit filed by the petitioner.
But the one from where I was showing the circular, my lord, the first supplementary which we had filed.
Yes. Page 11.
Yes, ma'am.
Yes.
2.2.1A, my lord, clause 1.
2.2.1A.
Out of order, the second.
Yes, CC and OD.
Yes, my lord.
Hmm.
The outstanding balance in CC/OD account remains continuously in excess of the sanctioned limit drawing power for 90 days, which is where I fall, my lord, and also non-serving of interest. Means the amount has been paid, but that is not sufficient to cover up, my lord. Clause 2 of the same heading, my lord. The outstanding balance in CC/OD account is less than the sanctioned limit drawing power, but there are no credits continuously for 90 days. I do not fall within that. I'm not relying on that, my lord. Or the outstanding balance in CC/OD account is less than the sanction limit drawing power, but credits are not enough to cover up the interest debit during.
So no credit continuously, they are depositing.
Yes,
that.
here the two grounds are there. Limit was also in excess, which is clause 1.
Less than the section limit,
limit,
not enough to cover the interest debit.
Interest debit. Interest was also not paid, my lord.
No.
It was not to cover that.
No. Outstanding balance CCOD is less than the sanctioned drawing power. That is your case.
No, it was exceeded. My case fall within 1, my lord.
Correct.
It exceeded the sanction, the limit.
Correct.
And also the amount which was paid, that was not sufficient to cover the interest.
Outstanding balance remains continuously in excess. That's your case.
Yes.
Now kindly II.
Yes.
The outstanding balance of CCD was less than the sanctioned drawing.
I do not come within the first part of II.
Sanction drawing.
Yes, I do not come. No credits continuously for 90 days. I'm not claiming that. I do not fall within
Correct.
that, my lord. Or the outstanding balance in CC/OD is less than the sanction limit. Here it was not less than. It was exceeded, which is I. The drawing power, but the credits are not enough to cover the interest. So this second portion, my lord, the credits were also not enough to cover the interest portion, and the
why you are telling that it is not cover the interest portion?
Had it would have covered, my lord, then this situation would have not arisen, because they are drawing always drawing in excess.
How you are calculating the interest? And you see, not enough to cover the interest debit. So how you are calculating
on the amount which has been drawn, which has been utilized? Interest has to be calculated on that amount only. So whatever payment has been made, that was not sufficient, because had it been sufficient, my lord, then this situation would not have arisen.
So you mean to say the amount which they have deposited, that has not covered the interest part?
That was not sufficient to cover the interest, because in CC account, my lord,
it is not covered the interest part, so leave aside the main.
My lord,
so what was your claim now?
Account has been classified as NPA.
Correct.
To be the steps under surface has to be taken, my lord. In CC account, the interest
NPA, there should be a claim.
Yes.
What is the claim?
For the entire amount now, because now the account has become NPA. So my claim would be entire principal plus interest.
What is the claim in the 13.2?
Yes, my lord. 13.2 there. They must have annexed, I think. I'll come to that, my lord.
68.
Yes.
So how you can say, kindly come to the 70?
Yes.
Outstanding interest?
1 crore 20, yes.
Interest.
Outstanding interest was 1,99,721, and the total amount is 1 crore 28.
How you can say interest? Can you see?
As on that date, page
So
yes.
So 1 lakh, if your case is 199, 1,99,721 is the outstanding interest, and they have deposited 7,90,000. So 19,000. So how you can say that it is not covered the interest part?
That was, my lord, this is after adjustment of whatever payment they have made. Till 28th June, from the date of, on the date of NPA, whatever payment is made, that has been taken into consideration.
I have made several payments after NPA because I was
That
not informed.
When NPA
I have
has
been making payments. February, March, April, I've made payments, continuous.
But that is
Suddenly
not
this letter comes out of the...
No, on 29th June, an email was given, my lord, because by that time, 28th June, the account was in such a position that it would be classified as NPA. But as a caution, email was issued. Since it till
No,
that,
I
till
am not
29th June, it was not posted.
No, I am not on. But with if you in the notice dated in your affidavit, you are stating that that amount is not covered the interest part.
Yes.
And as per your 13.2 and 13.2 notice was issued on June 2025. Then June 2025 only 1,99,000. So June 22 99,000 means you have calculated the interest from the January 2026 to June 2026. 2025.
No, my lord, it was
No,
till
NPA.
This amount refers to till the date of NPA, 28th June. It does not include, my lord. Kindly take up the first paragraph. This outstanding is till 28th January 2025.
No, kindly see paragraph 4. The following amount due payable as on 18 June 2025. 18 June 2025.
What's there? Whatever is there, my lord, I cannot go beyond that, my lord. But this is the
But
case.
your bank should be come with the clean hand. You cannot say here and there. And the court is not the accountant by sitting here.
I am not the whatever payment is made, my lord, that is evident from the statement. There is no suppression that bank has.
The court is not telling the suppression. Just that's why this court has asked the clarification from you. You are telling that the amount which they have deposited, neither that covered the principal nor that covered the interest. That's why it is covered under the, that's why it's 1 also covered, 2 also covered. 2, 1 and 2 is not telling that the part 3 is covered. Part 3 is with regard to the interest. The amount which the petitioner has deposited from the October to January, that has not been covered the interest also, as per your submission, just 2 minutes before.
Yes.
But the notice was issued on 29th of the notice was issued, and in the notice you are telling that that was on June 2025. June 2025, only the 1,99,000. If June 2025, 1,95,000, and you accepted the further amount, so how you can claim this?
The payment, whatever is made after declaration of any account as NPA, my lord, that is kept in a separate, that cannot be added here, my lord. So whatever is payment is made, my lord, that is reflected from the statement of account. Bank is has not suppressed any, that are not disputing, my lord. But it is a fact that this account remains in excess drawn, my lord, for a period of more than 90 days, which is the ground for declaration of the account as NPA.
Then you come to the page 15 of your supplementary.
Yes, my lord.
Which is showing that the minus it is going. Now you come to that, the first is 30th October, 31st of October, 65,000. That 65,000 you've taken into the main.
Yes, my lord.
Then?
The payment till 20th January, every payment has been given credit to. Still it remained in excess. The drawing power, the limit was overutilized every month.
Okay.
And with regard to this MSME point, my lord, this does not apply here because
What
for
MSME? Whether they have taken anything?
yes, in reply to my supplementary affidavit, for the first time they have come up no reply.
Where is the reply to this section 13?
13 to reply.
Section 13 they have issued given the reply.
Representation to 13.
Yes, page 73.
Yes, my lord.
Have taken the plea of the MSME?
No, my lord.
No.
Here.
Not.
No.
Now what step you have taken? Now what steps you have taken now?
13 to, since there was an order.
Only 13-2.
Yes.
He came immediately.
No,
You came after immediately.
That's right.
And 13-2, you have not taken the plea of with regard to MSME.
No,
Then
in this reply, they have not taken any point of
Then-
MSME.
But only one other thing to satisfy my lord's conscience. But kindly takes a look at from page 36 of the writ petition, payments made after January.
maybe.
So, my lord, I have been making payments before, after. Every
Maybe.
time I have been making.
That's why, but their contention is that kindly come to the affidavit and oppose the supplementary affidavit, page 16.
Yes, my lord.
You are going minus.
That is wrong.
How it can be wrong?
Because they say 4 lakhs gets knocked off. That is wrong.
How it can be wrong?
Because that is only for
Okay,
stock
okay,
statement.
you go and you back to the DRT and
decided
satisfy.
That is only for stock statement.
The writ court can do that.
Because that is contrary to the contract.
What?
I had shown the sanction
It's a
letter.
private contract, my lord.
I
They
had
can,
shown,
Go to,
that is
go to this DRT and
especially illegal. But may I then try and satisfy your lordship, my lord?
I have given the time of 1 hour.
I just in reply.
Yes.
2 minutes in reply.
Yes.
Lordship would kindly have a look at the sanction letter.
Yes.
This 4 lakh deduction is not there in the sanction letter. But for that deduction of 4 lakhs, my limit is much above.
What 4 lakhs?
Their affidavit case is 4 lakhs was reduced for non-submission of stock statement.
Correct.
That is why my limit got reduced. My lord will kindly,
See.
will kindly bear with me for a minute. Kindly. But let me explain one, my lord. Kindly,
Your case
kindly let me explain once, my
at the
lord.
time of hearing, now in the page, your case is page 36, 37,
40.
and 40.
Yes.
Correct. This is the
37,
amount which you have deposited. They have taken into consideration your deposited. In spite of taking your amount which you have deposited, that continue the less.
That is wrong, contrary to the
How you can
I can
say?
show it in one page.
So,
Yes. My sanction letter is 1 lakh reduction every month. So my sanction letter was December 2023. So 10 months, which is, we are talking.
sanction letter.
Minute kindly comes to the sanction letter, which is page 26. Minute page 27. Your lordship would kindly have a look at page 28. Special conditions.
Yes.
1 lakh reduction per month.
Yes.
So my sanction letter is December 2023. Per month 1 lakh for 10 months. October is 10 months off. So 1 lakh, 1 crore 40 lakhs. Per month 1 lakh. 10 months 10 lakh. 1 crore 40. Their reduction of further 4 lakhs is divorce the agreement. Otherwise we are through.
See, your total, what is the total sanction amount?
1 crore 50.
150. And
With 1 lakh reduction.
Which month?
December 2023.
2023 with 1 lakh deduction.
Yes.
Correct. As per the special condition.
Yes.
So
In October it is 1 lakh 40, 1 crore 40, 10 months.
you have taken the 2023
December.
Leave aside December.
So
And
January, February, March, April, May, June, July, August, September, October. 10 months.
10 months.
10 lakhs goes off.
Correct.
1 crore 50,
140.
140. They are saying it's 135. That is wrong.
Correct. So that's why you have written much.
No,
Yeah.
they are saying my limit got reduced.
Correct. Because
I
the
have
account,
withdrawn.
how the account has come less.
They are saying because of non-submission of stock statement, my limit got reduced. That is the affidavit case. Kindly seize.
Even though you kindly come to the your statement itself.
Yes, my lord.
Kindly come to your statement itself.
In my lord, page 40.
Page 40. You come from the page 37 itself.
37, yes,
but, come to first 37.
37 is January. Page 40 is October.
Huh?
Page 40 is October.
40 is October.
Yes, my lord.
So 40 is October. On 40 October, you have deposited 4 lakh.
Yes, my lord.
Correct.
Your lordship would find the closing balance there.
Correct.
Last entry, 1 crore 35.
1 crore 35 lakh.
Last entry.
Yes.
So my limit was 1 crore 40.
Correct.
So, my lord, without them deducting further 4 crore for this alleged imaginary clause of non-submission of stock statement, this cannot be done, my lord. Completely illegal.
No.
My lord, from where are they reducing my 1 crore 40 to 1 crore 35? May I ask this question to myself? Without this arbitrary deduction, of 4 crore. From where are
we
they?
are telling that the deduction. Show me the
Affidavit,
deduction.
kindly see the supplementary affidavit.
Show me the deduction. You
Yes.
show me the from account here.
They are not showing that for the first time they're making.
You have to prove from the account
They are
the
making
illegal
this
deduction.
out for the first time from the affidavit.
You are the petition. You have to show the illegal deduction.
I am saying they have not deducted ever.
So then it is coming down.
So
The
that
court
is
has to
wrong.
go by the accounts.
I am saying I have not
Not by
reduced.
your submission. You show this is the illegal deduction. Show me which amount has been illegal deducted.
It should have been 140. I had
You
shown.
show me from the account, Mr. Gupta.
My lord,
You show me the account. This amount is illegal deducted. Show me.
not amount. I am saying limit.
Show me.
I showed 1 crore 40.
Sir.
1 lakh downsizing per month is 1 crore 40. How can they show 1 crore 35? That is illegal. Their statement, how can they deduct 4 lakh from my drawing limit for the month of October? That is deholds
Where from you telling that it has been deducted 4 lakh?
Yes, kindly see the supplementary affidavit. Kindly see.
No, from account. You show me the from
I
account.
cannot show from the account. That is not reflected. That is the case which they are now coming up for the first time. This is illegal.
Sir, the statement account is your document. You had submitted.
Bank has issued.
Bank has given to you. You have submitted. You are relying upon. It is your not case. The document which has been submitted is a forged one.
Right.
Correct.
Right.
If it is, you have relied upon this to show me from this document where the bank has illegally deducted 4 lakhs.
Kindly
Show
seize,
me.
kindly seize this with their
The
affidavit
4 lakhs.
case.
Again, you are coming to the
But from
affidavit.
where are they getting 1 crore 35 if it is 1 crore 40? My agreement says 1 lakh downsizing every month.
See, come to the page 40. Come to the page 40.
Yes, kindly comes to page 40. And
Yes.
I'm grateful to my learned junior.
Yes, kindly come to the
Kindly
page
comes
40.
to page 40.
Yes.
Kindly sees.
See, it was 1
It
lakh.
was 1 crore 39 lakhs.
Please, 18th October, it was 1 crore 42.
Yes, my lord.
Correct.
Yes, my lord.
And 21st October, 1 crore 41 minus.
Yes.
Then it was again 1 crore 40. Then 13, it has come 13, 80,000. It is deducted, credited. Who credited? You credited.
I
Not
paid
the
money.
bank.
I have paid money. Yes.
Credited means who credited?
My payment got credited in the account.
Correct.
Yes.
So, after the credited, this amount has come. It is not that they have shown less.
No, my lord, if your lordship sees, it's 1 crore 35 as on 30th October.
Correct.
So how are they getting 1 crore 35 as my drawing limit? Now kindly do not look at the accounts in isolation. Kindly marriage this entry with my drawing limit. Their contention as per the RBI guideline is if my actual limit, if my account is lesser than the drawing limit, then my account should be NP.
That is the case.
I am saying my drawing limit was 1 crore 40.
Show me.
That is the agreement.
Agreement, but the account you coming down.
As on, so 1 crore 40 could have been my drawing limit.
Correct.
How can they reduce it by 1 crore to 1 crore 35? Their reduction is on the basis of their pleading in the supplementary. They are saying I have not submitted stock statement,
Okay.
so limit got reduced by 4 lakhs.
Thank you.
So how are they getting this reduction? This is deholds the contract.
Thank you.
But for this reduction, my limit would be 140, so I'm within the limit.
Okay, thank you.
But if
you're not understanding the court's question, then the court is very.
But if my limit was 140 and here overdrawn is 135, so I'm within the limit. I have not overdrawn more. So many this entire this is wrong.
Okay, you go to the SRPC, and the court will.
But I'm challenging the NPA.
No, I am not satisfied.
This reduction is completely deholds the agreement.
Sorry.
4 lakh deduction they are not getting from anywhere.
Sorry. You are admitting one.
I am not admitting.
And now after receipt of the affidavit, you are changing your stand. And you are telling the bank has changed your stand.
Banks.
Where is your averment that the statement is not correct?
In my affidavit in
not in your petition. You have disclosed the affidavit, the statement account in your petition, where you have stated that this account is not correct.
First day before your lordship, their point was 90 days interest not serviced. I satisfied that. Second day, their point was my payment, my interest payment was not up to the mark. I satisfied that. Third day, their point is that my drawing is more than the sanction limit. Now I am satisfying that this reduction of limit is dehors the contract. The contract only provides increase in the rate of interest if I do not submit stock sheet. So reduction from 1 crore 40 to 1 crore 36 is something not borne from the contract, comes for the first time from the supplementary affidavit.
Okay. Hearing concluded, CAV. Next.
I'm for the petitioner, Madam, item number 5 and 6. My last occasion, there was direction to file supplementary affidavit, Madam. This is our supplementary affidavit. And it contains, Madam, 2 deed of declaration. So, yes.
Yes, what is the case?
And Madam, there is 2 deed of declaration. The draft, original draft is also there, Madam. In case the Lordships wants to see.
What is a prayer?
My case is, my lord, that I am the absolute owner of 8 Shatak land that is situated in Noida district. My 4 Shatak was acquired by way of deed of gift that was actually executed by my father, and 4 Shatak I purchased from the vendors. Now, my lord, at the time of registrations, it was wrongfully and inadvertently recorded that Ela's dark number was 1953. And it is reflected in the deed, my lord. Now, my lord, as per the recent government survey report, this dark number should be 1384.
1384,
my lord. I have annexed the sketch map.
What was the earlier DAG number?
Earlier DAG number 1953.
1953.
Yes. My lord, when I approached to the block revenue officer, my lord, they are not willing to rectify these things. Then I have even made a representation to the Register of Assurance, and even my deed of declaration is ready, but they are not willing to accept this, my lord. My lord, the law says that as per the Registration Act, the law says, my lord, that the sub-register, if they want to refuse this rectification thing, they must issue an order of refusal, and the order of refusal must contain the reasons for recording this refusal. And even, my lord, even section 68 of the Registration Act, it also says the registrar has the power to issue an order to the sub-register for the act and omissions in respect of the rectification of the error or something done in the book. So, my lord, in this case, my lord, they haven't even issued any order of refusal, nor reason has been issued. And, my lord, I am not able to dispose of this property because of this defects, my lord. So I'm
my lord. No instruction.
Yes, my lord.
Last occasion you are appeared.
Yes, Bimal
Haldar was appeared.
My lord, that was 27th of April, my lord, before the change of the panel, my lord.
So why your authorities are not considering?
My lord, that I shall take instruction.
Huh?
That I shall take instruction, my lord.
Take instruction when you will come.
My lord, 1 week.
Learned counsel for the state prays for time to take instruction. According cases adjourned. Let the matter appear on
give me the contact details.
12th August under the same heading.
12th August.
Supplementary affidavit filed by the petitioner be kept with the record.
Well, item 6 also similar matters, my lord. Well,
There also you file supplementary?
No, my lord. This is the first time
also,
is coming up, so I will serve the note.
Same matter.
Same.
Next.
Much obliged.
Yes, who is for the 7?
We beg to appear for the petitioner.
Yes.
For the petitioner.
Yeah.
Affidavit. The affidavit of service. So, I am a senior citizen. I had approached the tribunal, my lord. I had approached the tribunal
seeking for an order of maintenance against my son.
Hmm.
My lords will come to page 42, which is the operative portion of the SDO's order.
42.
Page 42, my lords.
Ah.
My lords, the SDO.
Your mother.
I'm the mother and the father. Two petitioners. my lord.
Father.
Mother and father.
Both initiated case before the tribunal.
Before the tribunal.
Against the son.
Against the son. Yes.
Yes.
One of the sons.
Hmm.
The opposite party, this is page number 42, my lords, paragraph 2, the last paragraph of the OP, that is Bapigiri, is directed to pay rupees 7,000 per month as maintenance allowance as per the provisions laid out under section 9(2), such and such, my lords. Thereafter, my lords, lordship will come to page 45. There are two memos issued by the SDO, the officiating tribunal, to the officer in charge of Jhodkhali, which is the jurisdictional police station where I reside. Well, it's no amount is paid till date.
Item number 7, I am appearing for the private respondent. Lordship, only yesterday client communicated me. I have not received the brief and the Bhakalatnama, Lordship.
Why you're not paying the amount?
They are not paying from 2023, my lords. This is 26. We had served a copy of the petition in July.
Why your client is not paying?
In May.
I have not taken the instruction.
If your client, being the son, is not paying the maintenance to the parents,
I have to take instruction in this regard, Lordship. Only 2 days time. I have not received the brief yet, Lordship.
So 2,92,000 is due as on date. They have not complied with the.
Have you filed an execution before the authority?
My lords, I have filed.
Where is that?
That is at page 52, my lords. Kindly comes. The execution application is not taken up for hearing. And he is a locally influential person, my lord, which is why this entire thing is happening.
She kindly grant
Execution application has been filed. Kindly comes to page 60, my lords. A representation there has been filed.
Yes.
Lordship, I don't have the brief, Lordship. Only yesterday client communicated me over phone. I have seen this matter is.
Well, take a coercive
Before
step
this-
against him.
Lordship, only 2 days. Only 2 days.
As per this submission made by the counsel for the private respondent, case is adjourned for taking further case is adjourned. Let the matter appear on 31st of July under the same heading within 5 matters. Affidavit of service we kept in the record.
Grateful.
Come with the total instruction. If you're not paid, if he paid, come with the document that he has paid.
Lordship.
Yes, next.
Grateful, my lord.
Challenged a debarment order, but only on the one ground I am challenging this, my lord. As your lordship knows, my lord, they have to give me a show cause notice before the debarment. A principle. I have to be heard. Without hearing, my lord, there can be no debarment.
Who is your junior? The advocate on record?
Before my learned senior.
Before filing the writ application, have you checked the writ petition? And how the oath commissioner has affirmed this affidavit, or after the affirmation you change the page number 46? It might be how you change the page 46, or how you cut the stitch of the writ application after affirmation. See, Mr. Sen. Yes. The oath commissioner will not affirm this type of the putting the seal.
কি করেছো? এরকম হলো কি করে?
No, once the affirmation, how you can change all these things?
এইভাবে তো অ্যাফার্মেশন করবেন না, ওটাই তো বলছি। এই পাতাটাতে মেরেছে তো, হ্যাঁ, এটা সোজাই ছিল, তা না হলে এটা হয় না।
They have changed. Because kindly see the seal. Kindly see the seal.
এটা সোজা না হলে অ্যাফার্মেশন হবে না। এটা সোজা না হলে সাক্ষ্যটা অ্যাফার্মেশন হবে না। এই দেখো
সোজা না হলে
সাক্ষ্যদা, এই দেখো আমার কাছে যেটা আছে এটা এখানে আছে। হ্যাঁ, এবার এটা উল্টে গেছে, তার মানে দিস হ্যাজ বিন চেঞ্জ। এটা ঘুরিয়ানো হয়েছে।
I really, my lord, just, yes. My lord, your lordship will kindly come to.
দুটোর পরে করি?
Matter, lordship.
Yes, page,
কি করে করবো একটা?
which page?
Kindly come to page 247, second volume, my lord. This is the order, debarment order,
Page 47.
247. This is, my lord, second volume.
247.
Yes, my lord.
Yes.
But we have supplied the material. There was prior testing. Now they are saying Roman 5 and Roman 6 that they have taken sample on October 25. Kindly see Roman 5 and Roman 6, 24th October and 29th October. And they say that the material has been rejected. No rejection notice was ever given. Then, my lord, they refer to clause number 2.5.6 of the guidelines. And then they, my lord, next page, your lordship will see.
4 is afterward the test of the first sample was conducted on 2nd October and 8th October.
Yes.
But the
Sample did not withstand breaking load test, conductor resistance test of 2 phases. And the test on the first sample conducted on 30th September, but sample did not withstand conductor resistance. Then, my lord, Roman 5 and Roman 6, they are saying material has been rejected. Your lordship sees last line of para 5 and para 6. After testing, the material has been rejected. I did not receive any notice of rejection. I am not on that, my lord, here. I am only saying this, my lord, under the, now they have under Romans 7, page 248, they have debarred me from for 5 years. Only issue is, my lord, can debarment be effected without any hearing? I am only relying upon the settled judgment, my lord, that I must be heard before taking this drastic step. Even if they have a very good case, but that final decision can be arrived at only after giving notice to me and hearing. This is only the order which I have received. There was no notice of hearing why I should not regard, no show cause notice, nothing. And even this rejection is not communicated. Rejection is of 2025. And after this, I will show your lordship, from November till February, further materials they have accepted after testing. Kindly come to page 184. WBSEDCL is giving me dispatch instruction after those dates for supply, and it has been supplied. I still don't go to the merits here, my lord, because I only say that the.
So, as per your contention, 248 was issued without any notice.
Yes, absolutely without.
No hearing was done.
No hearing was given. Nothing.
Yes.
No, just for the sake of completeness, my lord, I rely upon this judgment. It is now followed everywhere. It is now. This is 2020 UMC Technologies. Para 13 and 14. Twelve, 13, 14, my lord.
Citation.
Kindly take paragraph. Yes, 13 and 14, my lord. We have given our anxious consideration submission made at learned counsel at the bar. In our opinion, validity of the impugned order of corporation dated such and such, so far as blacklisting of the appellant thereon would in turn be determined by validity of the underlying show cause notice issued by the corporation. At the outset, it must be noted that the first principle of civilized jurisprudence, a person against whom action is sought to be taken or whose rights or interests are being affected should be given reasonable opportunity to defend. Basic principle of natural justice: before adjudication starts, authority should give to the affected party the notice of the case so that he can defend. Such notice should be adequate and grounds necessary action and penalty action proposed should be mentioned specifically ambiguously. An order traveling beyond the bounds of notice is impermissible and without jurisdiction. Then, my lord, para 14, specifically in the context of blacklisting of a person or an entity by the state or a state corporation, requirement of a valid, particularized and unambiguous show cause notice is particularly crucial due to the severe consequence of blacklisting and stigmatization. And my lord, following Eurasian, my lord, Eurasian is the parent judgment. I don't want to, my lord, multiply. Yeah, okay. This is followed in 2026 judgment also. Yes. Just, my lord, for your records, your lordship can keep this, my lord. 26. 26 FCC online SC. 26 FCC online SC 520. Paragraph 5 itself, your lordship will see. Having upheld the order of, having upheld the order of viewer of the opinion that assumed logical consequence of blacklisting is neither supported by application nor followed by a clear notice proposing blacklisting. We set aside the order of due to passive and social monitor director or letter of file director, but cease to operate from the date of a.
Yes. Yes. No matter the question of natural justice, Manoj, as is being argued by my learned friend, and that will not apply because, Manoj, there was a show cause notice which they have not annexed. There was a response given thereto, which was also taken into consideration. My lord will find that being referred, my lord, in the order, my lord, whereby, my lord, the manufacturing has been debarred for 5 years. Now, what happens is, my lord, here, my lord, it is not the supplier, my lord, who has been debarred. It is the manufacturer in terms of clause 2.5.6, my lord, of the guidelines. And, my lord, it is a case, I'll say, where, my lord, where the contractor,
yes,
they, while giving their reply, had admitted, my lord, this particular default.
Yeah,
Kindly takes page 236, my lord. This is the response by Universal Project.
Two
236, my lord. This is the response to the show cause. Now, my lord, kindly takes the next page, my lord. May kindly come straightway to page 237, the third paragraph. The Universal states, my lord, in this context, we reiterate that the event of failure is unforeseen and stand out as an exceptional incident only. So it's an admitted failure. The supplier has expressed their concern over the event and have assured non-recurrence of similar event. We, being the TKC, had initiated swift action on the subject immediately after the intimation of sample failure, and going forward will try to refrain from such incident by being more vigilant on the subject. As a proactive measure, we have strengthened our internal quality control mechanisms at the manufacturer's work, including enhanced pre-dispatch inspections and additional test verification prior to offering materials for inspection. So, my lord, the privity of contract that exists as between, my lord, Universal and, my lord, the West Bengal WBACDCL, my lord.
Yes.
And Bhindrawal also additionally, my lord, the petitioner herein, at page 238, I'm sorry, my lord, at page 246, my lord, they also, my lord.
Where is the show cause notice?
Show cause notice, they have not annexed, my lord. But we have a copy.
You are having copy?
Yes, yes.
There's a reply. Page 36, 236 is the reply.
No, that is the reply by Universal.
Yes, so it's the.
Not by us.
Naturally.
We are Bhindanwala.
Naturally. Universal. Bhindrawal might be a manufacturer from whom, my lord, Universal takes products.
To whom the impinging order was issued?
But it is issued to, my lord, Universal.
No.
Universal.
Yes.
Address to Universal.
Naturally, yes, because that is
address to Universal.
The contract
blacklisted me.
No, the contract subsists between, my lord, the ACTCL and Universal.
Then how can they debar me at all? If there is no contract with me.
No, it's a
that's what
turnkey.
they're un-
No, it's a turnkey contract.
Kindly see page 248.
No, my lord,
last
kindly,
paragraph.
just a second. Dada, আমি শেষ করি, এক
Yes,
minute.
yes, yes.
Yes. No, my lord, kindly thereafter takes page 246, my lord. This is the version of the petitioner. Kindly takes page 246. They address a letter to us on the 27th of March 2026. Kindly takes, my lord, last but 3 paragraphs. Please therefore take a compassionate view. I'm sorry, my lord. Page 246.
Yes.
Please therefore take a compassionate view and waive any punitive action against us as our unit is under small scale registered with Udyam and commenced manufacturing journey in 1964. It's a case, my lord, of admitted failure. Universal admits it, and in fact, my lord, the manufacturer, who's the turnkey contractor, my lord, they also say that yes, this has happened, it will not happen. Now, my lord, what does now, my lord, let us appreciate, my lord, what the guidelines state, my lord. But kindly takes the impugned order, page 248. The guidelines have been, my lord, reproduced therein, my lord. It's clause 2.5.6 of the guidelines for quality monitoring.
Yes.
Yes, it states that, my lord, in cases where pre-dispatch and factory test results or by NABL accredited lab reports are found mismatched with the test results on the sample picked from field, actions shall be taken against the willful defaulted manufacturer and the turnkey contractor or both. So 2.5.6.1.1 states, my lord, sub-vendors or vendors registration of the manufacturer shall be discontinued in all the power utilities of the country for a period of 5 years, including in power utility concern where this act is found. 2.5.6.1.2 states, my lord, entire lot of materials equipment supplied by the defaulting manufacturer shall be rejected whether supplied materials equipment is lying in site stores, in transit under erection, testing and commissioning or has already been commissioned. All costs related to removal of such rejected materials and reinstating fresh lot of materials shall be borne by the turnkey contractor without any cost implication or power utility. And thereafter 2.5.6.1.3, turnkey contractor shall be responsible for repetitive failures of materials in field of testing in a turnkey contract. In such situations, registration of turnkey contractor firm shall be discontinued in all the power utilities of the country for a period of 5 years, including in all power utility concern where this act is found. The above clause is also a part of standard bidding document. So, my lord, it has been only, my lord, clause 2.5.6.1.1, my lord, which has been invoked. Thereby saying, my lord, that, my lord, the ACDCL decides, my lord, not to accept, my lord, the materials from a particular manufacturer. They say to their, my lord, to their contractor that we have decided that you continue. I am invoking 2.5.6.1.1, but with superior materials because it is a case where, my lord, both of them have admitted about the failure. So, my lord, in teeth of, my lord, such admission.
But no notice was issued to the company.
My lord, I cannot, my lord, to the manufacturer because I do not have any.
If it is not issued the notice, how you can debar? You can only.
No, my lord, there are, as I said, my lord, I have privity of contract only with Universal.
But if correct,
Yes.
then how the Bindwala cable has been debarred?
No, Bhindranwala is, my lord, they take materials from Bhindranwala. Universal takes materials from Bhindranwala.
Maybe, but without the notice, it is the violation of the natural justice of Bindwala.
Now, my lord, only one thing, my lord, Universal as well as, my lord, I am being repetitive, my lord, as well as Bhindranwala, both of them, my lord, have stated, have admitted about, my lord, the defect, my lord.
Correct.
As I indicated, as I had taken your lordship's, my lord, through the 2 replies, it has been done, my lord. It has been accepted by them. So, in light of that, my lord, as to whether the question is, my lord, whether a party, despite not being a party to a contract, but whether he has any right of audience.
If it is not have right of audience, so how he can be debarred?
No, my lord, I can tell my contractor that I have decided not to take materials
You can-
beyond a particular standard. So
You
that is
can,
what I have
but
done, my lord.
You can no, but here yes is that the Mrs. Bindwala so and so.
Yes.
Limited.
That is in terms of the yes, that is in terms of the guidelines, my lord. These are, my lord, the guidelines.
You can I ask your contractor not to purchase, that is different thing, but you have debarred directly. That is on, and you are not debarred your contractor.
Yes.
Then, my lord, may I just do this, my lord? But the practical way out will be, my lord, to write a letter to the contractor stating that we will not be accepting, my lord, any products manufactured by this particular.
But this
No,
letter-
but they have, my lord, may I come back, my lord, with instructions, my lord, as to whether, my lord.
Otherwise debarring, then he will not be in a position to supply other.
Yes. My lord, let me come back, my lord, on Friday. Or may I come back on Friday with the instructions? কোথায় যাবে? অভিষেক ব্যানার্জি মামলাটা fix আছে, চলবে সারাদিন।
তাহলে Tuesday পরে পড়াবে।
Tuesday।
Friday, Monday,
আচ্ছা।
Tuesday থাকবে।
My lord, kindly takes it up on next Wednesday, my lord.
Wednesday মানে তাই।
Till
Still
that,
open this, এখন কিভাবে?
till that not to give any effect of this.
My lord, it's an order. The impugned order, my lord, is
With regard to the Bindwala petitioner, not, this is not against the contractor.
then, my lord, kindly
And
takes it up on
Bindwala, there is no notice. Or you come with the corrigendum or clarification, there is no problem.
then kindly takes it up this Wednesday.
Wednesday.
Kindly takes it up this Wednesday. I'll come back with instructions for it.
Landed council for the respective parties have argued the matter. ऊपर लिख दें, affidavit of service filed with the petitioner, copy the record. Landed council for the parties have argued the matter at length. Landed council for the Mr. Bidwala, Landed council appearing for the respondents, prays for time to take instruction. According case is adjourned, let the matter appear on 29th July under the same heading within 5 matters.
Well, may it be taken up at 2 o'clock, my lord.
2 o'clock, already matter is fixed. Within 5 matters, morning hours I will take.
Well,
2 p.m.
Not 2 p.m. My matter is fixed. Already fixed matter is there.
My junior is in something.
আরে ভার্চুয়ালি করে দিবি না, কি অসুবিধা আছে?
Come on virtually.
করে দিবি, কি আছে?
Thursday বলো, Thursday।
আজকে করো না, আজকে আমার অভিষেক ভাই I have to assist
2 बजे क्या
solve it.
मैटर फिक्स 1 बजे 1 बजे है कुछ
না না, জজ সাহেব বলবেন যেটা সেটা করবো তো না।
1 p.m.
1 p.m.
At 1 p.m.
1
At 1 p.m.
I hope no effect will be given.
No, it's on Wednesday, so 24 hours what will happen?
My
Effect
lord,
has already been given.
Yes.
my lord, I am extremely apologetic, my lord, but while I was hearing, my lord, I have had the experience that apart from, my lord, excellent legal acumen, my lords, we should not also forget, my lord is also the master of economics. My lord had so much taken pain, my
This
lord,
court
to
is not the master. This court is only to give the
relief, my lord.
hear the petition.
Hear the petitioners, my lord. Now, my lord, with the deepest of humiliation, my lord, in item 2, Lordship granted me leave. My lord, I was running from Surya Sen statute. Lordship knows, my lord, how the situations of
See,
my junior even didn't seek for passport.
I am telling in
My lord.
this court
My
till
lord.
when I am taken the
My lord.
determination.
My lord.
This court welcomes the junior.
Exactly. My lord, he was
This
about
court
to start
finds
also.
that the juniors
Admitted.
difficulty and going to pass any adverse order.
Admitted.
Naturally, I will hear.
Admitted.
But immediately when the matter is called, my senior is appearing.
Admitted. My lord,
And the first matter.
I know, my lord. I know, my lord, Lordships, my lord, always being sympathetic, my lord.
At the first matter,
my lord.
you persons are getting the matter.
Lordship, absolutely,
Within
absolutely.
10 matters, you are facing so
Absolutely,
hard.
absolutely.
And
my lord.
this court is also facing
Absolutely.
so hard to fix the matter.
Well, I take
Then-
this owner's charge and responsibility. I was running from Shudusan statue. Lordship knows his traffic's movement. Well, he was even on the very first moment he was about to start. Well, anyway,
I am
kindly.
telling the juniors
Yes,
to
yes.
start
My lord, my lord.
so that you can also get the benefit.
Yes, yes, my lord.
And this court is going to pass any
No, always, always.
going give
My lord, always.
to the
My
senior.
lord, my lord. My lord, either today or tomorrow, my lord, the same position, same position. Extremely grateful. Deeply obliged.
My lord, I am for the petition. 130.
The last order was passed, my lord. The interim order was passed on way back in December 18, 2025. Thereafter, last it was extended 10/6/2026.
Till today.
Yes, today, my lord. Today, my lord, till today it is.
For affidavit. You are appearing for all.
For respondent number 1, your lordship, I am appearing. I had taken I had prayed in March, your lordship, for filing of the opposition, but the same has not been filed. I'm praying for an extension. Pollution Department, your lordship.
Net counsel for the respondents prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within.
Your lordship, further 4 weeks time may be granted, your lordship.
3 weeks.
And 2 weeks from me.
Reply, if any, there to be filed within 2 weeks thereafter. Please the matter. Huh?
Except 21st September, any day, my lord, one matter as it is. 22nd?
22nd September at 2 p.m. is specially fixed matter. Interim order is extended till the next date of hearing.
Grateful, your lordship.
Next.
On item number 9, I beg to appear on behalf of the petitioner, my lord.
I'm appearing for the respondents.
And I'm led by Mohammed Sabir Ahmed.
Yes.
My lord, this is the third round of litigation between the parties. Basically, the petitioner, my lord, challenged the order of invocation under section 123 of the Army Act by the respondent authority. My lord, initially the background of the case is, my lord, the petitioner joined as a constable in the army. My lord, during his tenure of service, he had acquired some qualifications in regards to the assistance to the doctor, and during his tenure, a procedure was done. The petitioner was acted as per the directions by the concerned doctor. My lord, after completion of that procedure, a complaint has been lodged by the concerned lady, my lord, against the petition. That at the time of applying the jail, my lord, he has
applying the
jail, my lord. Actually, there is a procedure, and for such purposes, a jail has to be applied, my lord, to the complainant, my lord. And in during such procedure, my lord, she was uncomfortable and lodged a criminal complaint, my lord. My lord, on the date of my retirement, I was initially issued a notice under section 123 of the Army Act, my lord. My lord, I have challenged such invocation and I was detained in the army custody, my lord. I was initially, my lord, I challenged such invocation before this honorable court, my lord. During the pendency of that writ petition, the army has withdrawn that invocation of section 123, my lord. So after passing of elapsement of my lord a particular period, the army again, my lord, issued a notice under section 123, my lord. I challenge that notice before this honorable court on this score that over the self-same cause of action, you cannot issue, my lord, two consecutive, my lord, 123 notice, my lord. But while this matter was taken up by the vacation means, my lord, I have annexed the order. This honorable court was of the opinion that no, this matter will not be, my lord, entertained under Article 226. It has to be go to the, my lord, Army Tribunal, my lord. Order has been passed, my lord. There is also a, my lord, liberty has also been given to the petitioner, my lord, that if in case the Army Tribunal is not, my lord, in function, then the petitioner would be at liberty to approach before this honorable court. Kindly straight away come to that order, my lord.
Yes, page 119.
My lord. My lord, I made a, my lord, letter to the concerned department.
Have you prepared an appeal before the army tribunal?
My lord, I have, well, kindly come to the page 120, 127, 128, my lord. Pursuant to my, my lord, written communications, the authority has given a reply that presently there is no army tribunal. The army tribunal is not functioning regularly. I wrote a letter, man, that is appearing at page 121, and the reply is 128, man. Which, my lord, actually this letter is specific that the army tribunal is not functioning for a continuous and regular period of time, and for such purpose, my lord, because the army is continuously, my lord, harping to my personal appearance with them as per the section 123 of the Army Act, and my lord, that is why, with the leave granted by this honorable court, while passing the earlier order, my lord, I am approaching this honorable court, my lord. This is my lord, grievance in this situation, my lord.
So you have you filed the appeal before the application before the army armed force tribunal?
No, my lord, I have not, because the tribunal, my lord, is not functioning regularly. That is why I have not. And my lord, there is a time limit. Since within the 15 days, as
No, you do one thing. Kindly come to the page 128. They are telling that only one judicial members come from outside, and sometimes the bench constitutes, or sometimes it takes the online. You file, and I will direct whenever the first opportunity will come. Then
I'm so grateful. Also, Your Lordship, I want to show Your Lordship there is a letter to the
That I
headquarter.
can do it. That I can do
May
it.
I-
But subject to Lordship's kind consideration, the issue is exercising Lord 123 of the Army Act means I'll be taken into custody. Now, my lord, if I file an application by this time, there are continuous letters to submit me, Lord, to the office of the Lord Superior. Now, the moment I go to Lord there, I'll be detained. I'm not on that, Lord. I'm on subject to kind sanction, Lord. There is no provision for bail. Now, so far the offense alleged is concerned, and my presence, Lord, is for the purpose of securing my presence is for the purpose of trial. But I'm not, I'll also face the trial, but I don't say that I'm trying to avoid the trial. But I'm beseeching your Lordship, Lord, the issue which is raised before your Lordship is only to the extent that whether I may be allowed to stay outside or not with the mess. Now, my lord, I say I want to participate. Lord, my right of representation through a lawyer is also not available under the Act. Though, my lord, I have not exercised yes because I did not appear. Now, issue is, my lord, at this juncture, whether they can force me or whether they can detain me or not. If I may be allowed to place section 120.
Lordship, may I
But if my learned friends are agreeing that I may be allowed to stay outside, I'm ready and willing to participate in the proceedings.
Okay, I will hear it.
The AFT legal cell officer is written to my officer, the officer in charge of the person taking care of the army matters in the High Court. And the letter states, Your Lordship, and I'll share a copy, that there is no OA pertaining to the DV issue filed by Muhammad Ashraful Mullah before the Honorable AFT. So the filing section is open, Your Lordship. And one OA 30 of 2026 regarding his disability pension has been filed by the applicant before the Honorable AFT, Kolkata, in the month of April. So nothing prevented him, Your Lordship, from filing. Filing is open, Your Lordship. So therefore, that's what I wanted to show to Your Lordship.
Yes. So, Mr. Ahmed, you do one thing. You go and file, and I will direct whenever the first opportunity the member will come. Your the matter be placed before.
May I go, Lord, may I subject Lordship kindly, Lord, may go one step ahead. Now, Lord, this application is for the purpose of only seeking a restraint upon Lord the authority that they do not take me into custody.
Lordship.
Now, Lord, may I just
Let
conclude,
me
please?
hear.
Now, Lord, what I'm on, Lord, if your Lordship kindly allow me that I'll stay outside, but I'll participate every day. Lord, that protection, if your lordship.
Where is the charge sheet?
Lord, the charge sheet, Lord, I have annexed, Lord. Your lordship would kind. Lord, may I say the factual background for a second, Lord, in the meantime. Lord, it was petitioner, Lord, was working as a staff nurse, Lord, in a Lord hospital. Now, Lord, what has happened, Lord? A lady comes and Lord, thereafter she gives her consent, Lord, to go for a Lord treatment. Now, this is being done under the supervision of a doctor. Now, Lord, the procedure, Lord, for the purpose of Lord giving her relief, Lord, a jail is to be applied. Lord, there, Lord, in presence of Lord, a staff nurse, a lady female member, Lord, I have applied a jail. Now, thereafter, on that date, Lord, nothing was, no objection was given, no. Later on, she comes and says that this is not a procedure where that jail is to be applied. Now, later on, Lord, during the course of inquiry, certain witnesses have been examined, including the doctor. They said that this is a part of procedure. There are, Lord, divergent version, Lord. For that reason, Lord, I have been, Lord, charged under section 354 of, Lord, the nature of offense, Lord, if I may be allowed to say that. The nature of offense is 354. Lord, this is the allegation. Now, Lord, initially, Lord, the inquiry was conducted. Thereafter, Lord, I was released. I was, Lord, I superannuated, and thereafter, Lord, I was left. Pension, Lord, has also been released. Lord, there, Lord, also, they have specifically stated that no proceedings is pending. However, they have a, Lord, under section 122, they have a, Lord, right, Lord, they can start, Lord, the proceedings, Lord, within 3 years from the date of superannuation. They have waited so long. Lord, I, being a, Lord, retired person also, Lord, I have also my right of defense, Lord, that I'll take. But I don't want to go to, Lord, to their custody. Now, Lord, the custody means, Lord, then I'll be withdrawn from my, Lord, normal life. That is a violation of Article 21. There, Lord, I say, I undertake before this court, even if, Lord, with the appropriate authority, that every day, whenever the date is, Lord, fixed, I will go, or not, previous day I will go. And then I'll attend the proceedings and then I'll come back. Because it is not a continuous procedure.
Where is the procedure for you have to taken into custody and the
No, I'll just section 1
custody only.
Page 40, Lord, is the charge sheet. Lord, may I just one by one, Lord, I satisfy your lordship's query, Lord. Page 40, annexure P7. And then, Lord, I'll place, Lord, section 123 and as well as 122. Your lordship would kindly take, Lord, page 40 for a second, Lord.
Lordship, may I assist your lordship?
Yes.
So 123(1) of the Army Act, if I may be allowed to read, your lordship.
I will come. I will hear
One
you.
minute.
Let the petition complete. Yes.
So these are the, this is the charge sheet. Now. Again, charge sheet, my lord, put. The process is called lithotripsy.
Yes,
then, Lord, this is the charge. Now, Lord, your lordship would kindly come to, Lord, section 123 of the Army Act. I'll just keep, Lord. Ito, my lord. Now, Lord, that is the reason, Lord, I was saying, Lord, 122, that is the period of limitation for trial. But it says, Lord, within 3 years from the date of superannuation, they can do. I'm not challenging that part. It says, Lord, liability of offender who ceases to be subject to act. Where an offence under this act has been committed by person while subject to this act and he has ceased to be so subject, he may be taken into and kept in military custody and tried and punished for such offence as if he continued to be so subject. So, Lord, it is that I am in the service. No person shall be tried for an offence unless his trial commences within a period of 3 years after he had ceased to be subject to this act. Here in this case, almost 2 years, 8 months and all. And in computing such period, the time during which such person has avoided arrest by absconding or concealing himself, where the institution of the proceedings is in respect of the offence. Lord, these are, Lord, the first part is, Lord, more important. Now, Lord, as if I may put it in this
So
way,
that
Lord,
the act provides.
The act provides that I'll be taken into custody.
Correct, kept in the custody,
Now,
military
my lord,
custody.
this is for the purpose so that I do not appear in the proceedings, so that his attendance is secured during the trial. So
Correct.
that's the object of the act. So
Correct.
that is the reason, Lord, I was beseeching your lordship, Lord, since I have been superannuated from the service, because this is applicable for those persons who are not in service. Now, if Lord, there is no, as I said, Lord, in my opening submission, that there is no provision for bail. Now, Lord, a person who has the benefit of Lord presumption of innocence, Lord, since inception, Lord, since he is not proven guilty yet, the charge framed, Lord, are alike, Lord, the charge sheet filed in Lord criminal proceedings. I have a right of defense. Lord, what I am on, Lord, this is 123 does not have a provision of 439 or Lord 482 BNSS nowadays. So this act, Lord, can only be, Lord, of this power, Lord, I am saying, Lord, subject to kind sanction, this power under section 123 can be, Lord, exercised in a, Lord, exceptional circumstances, because that indicates that when a person withheld himself, I never said that I will not appear. I have participated in all proceedings. Even today in court, Lord, I say I am undertaking that on every day, whenever the date is fixed, I'll be appearing.
But how the, because act provides.
No, act, Lord,
Act, where is
this is
the exemption?
the
Where is the proviso? Where is
My
the
lord,
explanation?
My lord, you would kindly appreciate one aspect, Lord. That is the reason, Lord. If your lordship would kindly take, Lord, the punishment. Now, your lordship would kindly come to, Lord, the charges, Lord, leveled against the petitioner. That is section 63 and 69. Now, kindly come to, Lord, section 63 for a second.
Fresh invocation order.
Now, what is the offense? Violation of, Lord, I am on, Lord, that there should have been a provision. Now, if that way, now, Lord, if it is not there,
So you're not challenge the virus of the act.
no, Lord, what I'm on is
Challenge
what
the
I'm
virus
on.
of the act, then could have.
What I'm on is, Lord, the exercise of power under section 163 should be reasonable, and keeping in mind that, and there should be, Lord, a reasonable, Lord, reasons, Lord, to be recorded, that why they are doing it. It's not an automatic. I'll show the order. Now, Lord, kindly see the order, the offense, violation of good order and discipline. Any person subject to this act who is guilty of any act or omission which...
Where from you are reading?
Section 63.
63.
Of the same act.
Yes. Yes.
Now, my lord, any person subject to this act, the heading is, my lord, violation of good order and discipline. Lordship has got, Lord. Any person subject to this act who is guilty of any act or omission which, though not specified in this act, is prejudicial to goods or order and military discipline, shall, on conviction by court-martial, be liable to suffer imprisonment for a term which may extend to 7 years, or such less punishment as is in this act mentioned. So, my lord, the upper punishment is 7 years.
Correct.
Now, my lord, section 69. Lord, your lordship would kindly come to, my lord, section 69 for a second, Lord. Now, this is a civil offense. The primary offense against me is civil offense, which is 354, my lord, which I have shown your lordship at page 40 of the charges. Now, my lord, civil offences subject to the provision of section 70, any person subject to this act who at any place in or beyond India commit any civil offence shall be deemed to be guilty of an offence against this act, and if charged therewith under this section shall be liable to be tried by a court-martial, and on conviction be punishable as follows. That is to say, if the offence is one which would be punishable under any law in force in India, I be stand with regard to with death or with transportation, he shall be liable to suffer any punishment other than whipping assigned for this offence by the aforesaid law, and such less punishment as is in this act mentioned. And in any other case, Lord, he shall be liable to suffer any punishment other than whipping assigned for this offence by the law in force in India, or imprisonment for a term which may extend to 7 years. Lord, in my case, Lord, section 354 is the civil offence. So, Lord, it will go, Lord. Now, there, Lord, I, subject lordship kind sanction, Lord, I join an issue. Lord, that notice under section 35(3) or nowadays, Lord, the heinousness of the offence is to be looked into for the purpose of exercising jurisdiction under section 123. This cannot be automatic. Because as I said, Lord, this exercise of power is only for the purpose of securing attendance, like not the warrant is issued in criminal court. That a person is avoiding due process of law for the purpose of securing his attendance, Lord, a warrant is issued, he is brought before the court may release him on bail or may not release him on bail. Now, 123 is an order which is akin to, Lord, issuance of warrant of arrest. Lord, this is my first submission. Now, Lord, this is for the purpose of detaining a person, an individual. Now, if a person is, Lord, if a person is undertaking or giving a bond before the court martial that I will not leave the jurisdiction of the Kolkata, or, Lord, I will appear each and every date and time fixed by the Lord, court proceed of the proceedings. Lord,
But
why should I be detained? Lord, that's the
123 is discretionary or mandatory?
Lord, I say it comes with the reasonable restrictions and, Lord, the reasons to be recorded. It's not automatic.
No, because see, where an offense under this act been committed by any person subject to this act has ceased to be, he may be taken.
Now, this is what I'm saying. He may be taken into and kept in military custody. So, Lord, this may, Lord, that is the reason, Lord, I was referring your Lordship, Lord, the procedures of the criminal procedure, that it's not, Lord, mandatory. So, if the act is not, Lord, mandatory, it should come with, Lord, a reasoning that why my detention is necessary. Now, they may withhold. So, that is the reason I'm, Lord, the first instance, Lord, I proposed your Lordship, Lord, I will not go into the custody, but I'll appear.
Yes.
Up to 7 years. So, Lord, since, Lord, your Lordship would kindly take, Lord, the order passed by the competent authority under section 123, your Lordship would kindly take, Lord, first order to the
Where is the order 123?
I'll just page 64, Lord, your Lordship would kindly take P9. That is the first order. I know. P9 64 is the order, Lord, first order passed under section 123 of the Army Act. Now, Lord, it is the undersigned while later suggestion invoked Army Act 123 against you with effect from 1st July 2025. Consequently, proceedings of such and such. So, Lord, there is nothing which says that.
And regulation for the army, revised edition 1994.
Now, Lord, why I am insisting so much, because this was withdrawn without giving any reason and all.
Yeah.
So, Lord, the purpose of taking me into custody in accordance with section 123 is discretionary. This was withdrawn. Now, this particular letter which I have shown to your Lordship. They have forwarded across last order. Last 123. Now, this was, Lord, as I said.
Yes.
Now, this was subsequently withdrawn.
But
now, later on,
Mr. Sabi, how the tribunal is there? You go and file the tribunal. Let the tribunal exercise the jurisdiction.
Indeed, Lord. Since, Lord, that is the issue, Lord. If you, Lord, kindly allow me to place another, Lord, the last order, Lord, which we intended to challenge before this court. Last order, last 123 order. Lord, since your Lordship, Lord, there is no army, Lord, tribunal functioning. Now, Lord, if I need to, Lord, challenge, Lord, the order under section 123, Lord, your Lordship would kindly see the order again. Then, Lord, I'm a remediless person, because it says, and time and again, Lord, they are sending letters to my local police station. And, Lord, the learned magistrate, in the meantime, Lord, since, Lord, my writ petition is pending, and on the last day, Lord, my learned junior friend was little ill. Despite that, Lord, I have served them a notice saying this, please do not take any contrary steps, because the matter, the Honorable High Court is insisting of the matter. But still then they have approached before the learned magistrate seeking an order of warrant. So, Lord, within 30th, I have to appear before them. Lord, I do not have any, Lord, remedy left open as on date.
Yes.
Now, Lord, your Lordship would kindly come, Lord, to the 123 order issued afresh at page 114. No, Now, my lord, the same, Lord, under the provisions of section 123 of the Army Act 1950 and additional such and such, sanction of General Office Commanding in Chief. My lord is more conversant with the proceedings, Lord, than me. Lord, consequent to the sanction of General such and such, I'm nothing. My lord, my contention is subject lordship kind sanction, my lord. A person cannot be put to Lord such restrictions unless he is Lord proved to be guilty. One, I am remediless as on date, because neither I can, there is no provision for bail in before the court martial as well. Neither I can approach Lord the tribunal, because the tribunal is not functioning. By this time there is an order of the landed magistrate which says that I should appear.
But Mr. Sabir, you not challenge the virus of this 123.
No, Lord, I am on, Lord. I have also pleaded.
Challenge that.
I have pleaded, Lord. As I said, your lordship has
There
rightly.
are so many points for the writ application, but you not taken anything.
No, this is a act, Lord. I have not challenged the provision, but I am on, Lord. Your lordship has read, Lord. Lord, I bow down to your lordship, Lord. Your lordship says that he may be taken into and kept in military custody. Lord, that is the reason, Lord. They have issued an order of recall at 108. The first order under section 123 was recalled by them at 108. Lord, there is a provision for recalling. Otherwise, they would not have exercised that jurisdiction. I am on, let there be reasonable restrictions on me. I will appear, because I may not be, Lord, cut off from my normal life. Now, by this time, Lord, I have retired from the service. There is no question of, Lord.
How many witnesses are there?
Lord, there are as many as, Lord, the prosecution can tell how many witnesses they are going to, Lord.
It does not reflect.
No, it does not. Not only the charges are served with me. Lord, the prosecution, while Lord, during the course of inquiry, examined as many as 16 witnesses, if I am not mistaken, Lord.
During preliminary inquiry?
Yes, there was. There, Lord, the doctor came and said that, yes, I was there, nurse was there, and he was, and there is an opinion that I can do it. I'm not in discharge of official duty, the offense has been reported. So there is another provision of the Lord Act, since it is a.
There is no CCTV.
In the Lord, inside Lord, it is not Lord, they can apprise your lordship Lord to that. It's in the hospital, commander. On the second day she came also. Lord, later on.
In the procedure room, there's no CCTV.
Procedure room, Lord, it is not. And I was not doing it alone. So, Lord, why I'm pressing so much? Because of the degree of offense.
Let me hear.
I leave it to your lordship, Lord.
Lordship, to answer your lordship's question regarding how many witnesses.
No, see, he is superannuated person. Correct?
Absolutely.
And after the superannuation, in the last moment, you have submitted, inquiry conducted, charge sheet filed. Whatever the tribunal is there, here, and that is
But they started before the superannuation.
whatever it may be. So the act says it may. What is the necessity of the custody?
So, your lordship.
Because you preliminary inquiry conducted, you collected the evidence, evidence on
very
record, correct, and you have to prove. So what is the necessity for keeping in custody?
Yes. So, your lordship, under Army Act, under 123 of the Army Act, it gives me the right to take into military custody.
I am not telling you are not right. You have
Absolutely.
passed the order illegally, but there should be some justification.
Absolutely. So, if your lordship kindly takes the order 104.
Your lordship, it's our submission that we are not going to put him in custody, your lordship.
Lordship, may I please show
Let
a
the
particular
advocate speak.
document?
If necessary, I will take. Yes.
If your lordship kindly takes page 114, your lordship.
No, if your client is telling that it is, they are not taking the custody.
I'll clarify, your lordship. If your lordship kindly takes page 114.
Yes. Yes.
Lordship, this is the order of invocation, the second time that we have invoked the Army Act. Now, Your Lordship, in view of the above, you are hereby directed to report to this hospital by 27th May 2026. He has never reported, Your Lordship. That is the precise reason why we want him in custody. But when we say custody, Your Lordship, he will be placed in the JCO officer's mess. The JCO mess, Your Lordship. It is not like he will be arrested. It's not like his rights will be fettered, Your Lordship. He is just there for the purpose of this investigation and summary of evidence. That is all that we need him for 3 weeks. And after that, he'll be released, Your Lordship. So none of his rights will be fettered.
How you can restrict the movement?
We will not restrict him. It will be so. I'll show Your Lordship. I'll show Your Lordship. Your Lordship kindly sees this document.
In that case, I will direct. He will
Yes.
appear.
The problem is
morning
there is
tuning he will
limitation running. There is limitation running. From the 10th of October, this started. 10th of October this year, it will get over. If by any chance he says he is not well, he could not catch his train, whatever the reason.
You take your officers, fix the schedule, come with the schedule. I will direct all the schedule. He will appear and he will not miss the hearing. And if one day he will miss the hearing, he will be taken into custody.
Obliged. We are ready with them.
You come with the schedule.
And after the investigation, if prima facie there is something against him, Your Lordship.
See, that's why the trial. Correct.
Yes.
So that's what the trial. As like a criminal, because I had also appeared in the several.
Even if he can be directed to come on the previous day and stay in the JCO's mess, he can come on the previous day.
4 hours.
Yes.
Appear
I bow down.
4 hours before.
I bow down.
If 24 hours he will not appear, then the automatically if any order is passed by this court deemed to be
obliged, but even that suffices. That I will not stand in.
The issue is this is a continuous recording process. When we record the summary of evidence, so
see if it is continuous.
So again he'll go, he'll come back.
So
So
you
it is
come,
for his convenience.
So you come with your schedule. See,
Hmm.
under the Army Acts and your officers
Hmm.
are fixing maximum 3 days for the evidence. As far as my knowledge goes, they are fixing the 3 days as maximum for the trial.
So my learned friend, she wants to submit.
Yes.
Your Lordship, when calling a petitioner to investigate, our objective and purpose is not to firstly put him under any military custody, because section 123 Your Lordship has already gone through. It is clear that we are not exercising any of that. We will keep him in a comfortable guest room, sir. So that is what we are mentioning, that he will be in the unit location. Your Lordship, resisting saying that I have retired from the Indian Army does not subject me to the procedure which is written in the law, is absolutely unjustified, Your Lordship. He is still a reservist. He can be called back in the case of an exigency also, as Your Lordship is already aware. So we cannot say that I am not subject to the Army Act anymore. So Your Lordship, that is our very objective, that we'll call him, we'll keep him in a JCO mess. A mess is a kind of a room, like a guest room, equivalent to a guest room, Your Lordship. More than that, how can we facilitate an individual who will need to investigate? That is our very submission, Your Lordship. Kindly please consider the same, Your Lordship.
My learned friend, Lord, I missed one thing. I was not allowed to sign a wakalatnama previously when I was taken into custody.
Your Lordship, may I submit?
Yes, this will continue.
Your Lordship, whatever notice we have issued to him, we have not used any word as arrest. We had asking him just to report. Had that been an issue, we would have requested the CGM to arrest him and give it to us.
That's correct.
We don't want to arrest him. We just want him to participate in the investigation.
And for that, it is imperative that he stays on camp, in the camp.
For the participation of the person, he should be in your mess so that your proceeding can be continued.
We will finish it in one week.
Your intention, but not the petition. See, if the High Court is directed, if you fix the 3-day schedule, okay, in the 3-day schedule, if within 24 hours or 5-day schedule or 1 week schedule, if it is there, he will come within a week.
His house is 5 hours away, Your Lordship. That is the difficulty. He stays in Murshidabad.
I stay in Calcutta.
No, let. If suppose you fix the case for hearing of 1 week from 10th of August onwards till 14th of August onwards. So he will report on 13th, he will continue with there till 14th, then 14 evening when the next day schedule will be fixed, he will go and he will. No problem.
So we'll give him a schedule and he will abide by that schedule.
That he will abide, he will come with the 24 hours.
He
and
can
will-
come
he will
24
come-
hours
he
before
come-
he will
he
report to
come
our
in
mess.
Commanding officer,
Hmm.
he will join, he will report your commanding officer, then you put in the JCO mess and the schedule, if it is continuous schedule, he will not go, he will remain there till the schedule is over. When the schedule is over, after 5 PM or the next day, he will allow. If the next schedule is fixed, the next schedule he will, you take the undertaking, he will appear before the JCO on with so and so.
That undertaking, your lordship can record here.
That can be done.
Kindly record
Why
that,
the-
your
why-
lordship, so that they can't resile from their
So that
stand.
your proceeding can be expedited.
Absolutely, absolutely. I bow down.
Intention that the proceeding should be completed.
Yes.
Leaving here, giving,
Yes.
I will give the direction to the appellate tribunal, the armed force tribunal, then when he will say it. when it will
Absolutely. And the limitation clock is
you come
ticking.
tomorrow or day after tomorrow with the total schedule.
Yes.
Not one schedule, total schedule, what if it's possible.
Yes.
Come out day after tomorrow, I will pass appropriate order recording the
Is it
schedule and he will appear before this. So your intention will also be taken, your contention will also taken care of it.
Obliged, deeply obliged.
Actually, the witnesses also who are going to come, they are out of station. They don't live here anymore. They've been transferred out. So that is also something that needs to be
Okay,
considered.
otherwise I will fix
Let
after
them
a
give
week.
the first schedule, Lord.
Or I will fix after a week. You come with the total when your witness will be appear.
Let the first schedule be fixed, Lord.
Whatever it may be.
Lordship, my instructions are that whenever we write to him saying, please appear on this date, he should.
He will give that telling. I will record the undertaking. He will, whenever you issue the notice,
He should appear.
either to
24
even
hours.
I will direct the notice to the council also.
Yes.
To the council also. And he will,
Within 24
within 24 hours, he will report your commanding officer and he will put in the JCO. And if it is continuous, he will continue in the your mass, JCO mass. If it is not continue, he will, if the proceeding is over, he will give the undertaking, he will appear on next day. Because the next day will be fixed by the
Yes. Yes.
the proceeding
If the
itself.
proceeding continues, then on the next day he has to be present there. Very well.
Correct. So can dispose of, you come with the schedule.
You logically dispose it of. No. They will not be able to conclude within 6 months. So, Lord, they will not be able to come with 6 months schedule. Your lordship knows, Lord. The approval, Lord, it takes, Lord, at least 5 stages. But ultimately, that order remains against me. Lord, I am ready and willing to go.
Lordship kindly does not disposes this off because, your lordship, they will, after the investigation.
Okay, you
is
do
over-
one thing. I am fixing up on Thursday. You
Yes.
take when the first schedule will be taken.
Yes.
I will fix on the first schedule. After the first schedule, then I will fix another day.
Yes.
So that
Yes.
the-
Yes. Very well.
Correct?
Very well. Very well. Bow down.
In the meantime,
So
let
deeply
them not
obliged.
take any coercive steps. Lord, in this Thursday.
What coercive steps will we take? What coercive
Yes, there is
steps?
a warrant pending against
This
me.
is not a warrant, sir. Please understand the whole report of 123.
At the Learned Council for the respective parties at length, full stop. The Learned Council appearing for the Union of India prays for a time to
No, there is no.
intimate this court and to inform this court with regard to the first schedule of the trial fixed by the what is called
Fixed in the court martial, Lord. Your lordship,
fixed in the court martial. Fully, sir. Let the matter appear on Thursday. You will come Thursday.
Thursday.
Lord,
Very well.
kindly record an order.
Very well, your lordship.
Yes.
I may be, Lord, kindly
Thursday,
record.
Thursday, I have some difficulty. It can be either Wednesday or Friday, your lordship.
Okay, Friday. Come on,
Friday.
Till Friday, Lord, the petitioner is, Lord, till Friday.
Court is here, 31st of July.
Lord, the police is going to my native place. Police is searching me like anything. CGM has passed an order. Lord, the difficulty is difficult.
This court hope and trust. In the meantime, the authority will not take any steps for.
Lordship, there's no prayer to that effect. Exactly. In their petition.
No, I am not passing any other. This court is hope and trust. The authority will not take any steps with regard to the presence of the petitioner during the.
Lord, let them come up with the schedule, but I'll give my undertaking here. The deeply blessed.
Come with the schedule. Come with the schedule. Because you take also approval from your authority. Otherwise, you will be in trouble.
Yes, your lordship.
But I'm so deeply obliged.
The 10, my lord, I am for the petition at 10 and 11, my lord. And also one thing, my lord, item number 135 is an analogous matter. Same.
What is the matter?
My lord, it is, my lord, with regard to election of the district committee of a service
Divisional
association-
Conference Bharatiya Postal Mazdoor. Yes.
of a service association of the postal department, my lord. Now, this divisional committee election, my lord, was held on the was supposed to be held on the 24th of May in a conference. Now, at page 17, my lord will find the order dated 22nd May that has withheld the permission for holding the conference. Now, we are general members of of this association, my lord. We are just seeking expedited election of the district committee. That is the short case. Now, here, my lord, this particular case.
Who are you?
My lord,
Who are you?
I am a general member of this particular association, my lord.
The member of the association.
Yes, my lord.
So what is the prayer now?
My lord, the prayer is firstly for conduct of the election.
Assistant Director Postal Services of the Chief Postmaster General to forthwith grant permission to hold the organized and fourth divisional conference. Yes.
And my lord, the second prayer also I would press, my lord, the senior superintendent of post office, East Kolkata division, should appoint the observer. Because this is the most vital part, my lord. Unless the observer is appointed by the department, the committee is not recognized. The elected.
So it is by the Chief Master General or with the Central Labour Commissioner's office?
No, my lord. It is with the
It is not a union. It is not a trade union.
It is not a trade union.
What is said?
That is the my lord,
Association. It is not a union.
It is an association, my lord.
It is not a union.
Not a union.
Otherwise, you have to go for the
Yes.
Central Labour Commissioner's office, and the Labour Commissioner, the conciliation will be done, and the Labour Commissioner will appoint the conciliation. Yes. So, who is appearing?
No one is appearing. I have the.
It is the central government. Central government it is,
Yes,
not the state government.
Then
when you issue the notice?
Well, notice was issued initially, man, because it was.
You do one thing.
Well,
Serve the notice to the office of the ESG.
Well,
ESGI. Correct. ESGI, and I'm fixing next week.
My lord, also, my lord, consider item number 135, my lord.
Both are same.
Same matter. My lord.
What is
My lord, the difference only is that this one is of the association of Group C. The other matters are for GDS and also, my lord, postman and MTS. That's why 3 matters.
Affidavit of service filed with the petition be kept with the record. In spite of service, none appears on behalf of the respondent. This court find that the respondents are the postal department authorities. Accordingly, the petition is directed to serve a fresh notice along with the copy of the writ application to the office of the ASGI, informing the next date of hearing, and to file fresh affidavit of service on the next date fix. List the matter on 11th August under the same heading. Same as 135.
135,
11th August. 10, 11, 135. 10, 11 and 135.
Yes, ma'am. 10, 11 and 135. My lord, the affidavit of services for the other 2 matters. I'm grateful, my lord.
Lordship, I am appearing on behalf of petitioner. Lordship, the petitioner was appointed as data entry operator at Block Health and Family Welfare Committee under National Rural Health Mission, under the various programs of National Rural Health Mission. And he has been continuing his uninterrupted service since 2007. And it is a contractual service and renews time to time. Lordship, on 29th July 2025, the petitioner was served with a letter intimating that his non-renewal of his service. On the basis
non-renewal
of his service.
Service was not extended.
No,
what was the last date of the service? When your service was terminated?
Terminated, Lordship. Page 15 is.
Page 15.
Yes.
Regarding the design nature devising.
Hmm.
Shall not be renewed further. Yes.
Lordship,
What post you are holding? In which post?
data entry operator.
Data entry operator. As a contract basis or daily rated?
Lordship, it is contractual service.
Contractual service. So what right you are having?
Lordship, actually, the petitioner has not been served with the resolution of the 27 meeting of HRSC committee resolution, on the basis of which he was terminated from his service.
Maybe. So the authority has decided not to come, not to extend your duty service. So what? It is a contractual service. What right you are having?
Lordship, petitioner filed a section 6 application, RTI application. Then further he preferred the appeal under
Correct.
19.
I appreciate, madam. If the resolution is also given to you, whether not extending your service, whether they have employed any other third person, then your case is made out. If not, then where is your case? You are the contractual worker. The authorities find your service, you have been appointed on contractual basis. Now authority find your service is not required. Now the contractual work is not extended. If it is the case that yes, you have been removed and the third party has been replaced against you, then you can say you are right. But how you can contractual worker? What the contractual worker having the right to continue in the service if the authorities didn't want to continue with the service?
Lordship, I need to take instruction. Kindly fix the date.
Go the Uma Devi. Supreme Court judgment.
Lordship, kindly fix the date.
Take instruction from your scene. Learned counsel for the petitioner prays for time. Accordingly, case is adjourned. Let the matter appear on 20th August. Yes, next.
I am appearing on behalf of the petitioner.
Affidavit in service. Lordship, I am filing the affidavit in service.
कौन सा matter? No, this is you पहले वाला matter.
I file now. I am filing in respect of item number 30.
Yes.
Lordship, petitioner came before your lordship. Petitioner came before your lordship for her gratuity amount.
Gratuity amount.
Actually, my lord, petitioner's husband, Ram Lohar, who was died while in service as driver. Suddenly, he was died by car accident.
How this writ petition is maintained before this court?
Because my lord,
Gratuity.
petitioner is he has been working. He was working Eastern Coalfield Limited.
Eastern
Yes, Jharkhand, as a driver, and she was received the amount by RTGS. Only gratuity amount.
Schedule caste and schedule tribe. Appeal side rule nahi. He. Yes. Have you saw the copy?
Yes.
Who is appearing?
Lordship, kindly see my last.
Sir, I am appearing on behalf of the respondent ECL, my lord.
Yes.
My lord, in this matter, I think one party has been left because the writ petitioner has prayed for gratuity, which has already been paid, my lord, as per my instruction. But the pensionary benefit, Provident Fund has been paid, but the pensionary and other benefits is to be paid by the Coal Mines Regional Organization. That party needs to be added for processing the pensionary benefit. Even though it is lack on their part, but my lord, for the sake of justice, if I may suggest, because gratuity has been paid as per my instruction, but even if my lord accepts my plea and disposes of, they will still not get paid the pensionary benefit.
You're getting the pension benefit.
Gratuity, according to my client's instruction, Provident Fund has been received.
But have you getting the pensionary benefit? So that's why they're telling that all the things has been given with regard to the only pensionary benefit is to be taken into concern, but you are not paid for the pensionary benefit.
Yes, my lord, yes.
You do one.
Said no.
File the report. You file the report.
Yes.
Yes, my lord, I shall. And let the parties be added, the concerned
authority who paid the PF, they are the authority for pension also.
Okay,
Let them be added. It will help in the matter.
Let you file the report, then we'll see what is to be done. The learned,
Yes,
you
my
are
lord.
learned counsel appearing for the respondent authority space for time to file report. Let the report be filed within 2 weeks after serving the copy to learned counsel for the petitioner. The petitioner is liberty to take exception to the report if any within a week thereafter. Let the matter on 28th of August 2026.
My lord, only one indulgence, my lord. May I favor one more time, 1 more week, my lord, if my lord permit.
3 weeks, 1 week.
My lord.
The matter is to appear
28th.
instead of any day.
28th August, my lord.
No, 27th August.
All right, my lord. Deeply obliged.
Next.
27. I'm getting. Get full.
Yes.
Lordship, I'm for TNI, your lordship.
Yes. Who is for the petitioner?
Myself, I'm the petitioner in person.
What is your name?
Shatrabrata Biswas.
Lordship,
video बंद करो. Video बंद करो.
Number 15, my lord.
Ah,
My lord, last occasion, my lord, there was a direction upon the respondent number to file affidavit, my lord. My lord.
okay,
I
come
have-
tomorrow, let us see.
Fix a time. नाले होते ना, आप कहीं बोल सकते, इसको जो time दिया।
Lord, may I have Lord, kindly note to mention, Lord, item number 149. Lord, this was actually not appearing as to mention the only prayer, Lord, was to file a report by the special officer, which your Lordship had allowed, and the report was to be taken on record on 23rd July. Lord, the report has been circulated, Lord. It could just appear as to be mentioned tomorrow. Lord, Lordship can report compliance and as to be mentioned on tomorrow. I'm grateful to Lordship.
Lord, before the original site is taken up, Lord, may I only mention item number 21? It's for extension of interim order. Lord, we thought it's in the appellate side, my lord.
That is over.
Lordship, I did not actually mention it in the morning because, my lord, it's item 21. If it can be kept as to be mentioned, my lord, only this much because, my lord, it's an interim order which, my lord, needs to be extended.
Till?
Lord, it was to be, my lord, the matter was till 23rd of July. So, my lord, on the next, it was continued till 23rd of July, my lord.
Interim order is till today or
No, my lord, it was till 23rd of July. It's running in the list. It's item 21, my lord.
So you not mentioned the matter, 23rd now we are on?
We are on 27th, my lord.
27, so?
We are on 27th, my lord. My lord, because it was running in the list, so we did not mention, my lord.
Every person are mentioning, you are not mentioned, what can be done?
Lordship, may I only pray, my lord, if it can be kept as to be mentioned tomorrow, my lord, we'll only pray for this.
Item number?
21, my lord. Item 21.
Yes.
I'm very deeply obliged, my lord. Very deeply obliged.
21. Yes,
But I am instructed, my lord, to mention this matter. It's item number 8 in your original side list. Lord, that MSME writ petition Mr. Mitro was arguing. Lord, tomorrow the matter is fixed on NCLT.
Item number, Learned Counsel for the petition.
My lord, I'm withdrawing. My lord,
The matter is listed as
My
item
lord,
number 8.
I'm
Learned
withdrawing, my
Counsel for
lord.
the petition mention the matter for upgraders and let the matter appear on 1st of September at the top.
My lord, I'm withdrawing. My lord, I'm withdrawing. I'm sorry. My lord, I'm withdrawing. My lord, kindly doesn't pass this order, my lord. My lord, on instructions I was asked, my lord, I know, my lord, your lordship's predicament, my lord, kindly recalls the order, my lord. My lord, I'm mentioning upon notice, my lord, kindly, my lord.
Yes, item number 1, who is appearing?
My lord, kindly, I'm only requesting your lordship, my lord, kindly recalls that order, my
Who is
lord.
item number 1?
I'm led by Mr. Anirban Rai, my lord. He's appearing virtually in the matter, my lord, item 1.
Where is it?
My lord, I am appearing in this matter, my lord. May I just kindly request your lordship, my lord, for another adjournment today, my lord, because my lord, I'm in a personal emergency situation, my lord. So if this could be taken up, my lord, any other day, my lord, if your lordship kindly permits that, my lord. I'm sorry, my lord, I'm appearing online, my lord. But I've spoken to Mr. Ghosh also, man. It's absolutely personal, man. So I'm also rushing, my lord. Kindly, my lord, if your lordship permits, my lord.
So the matter is specially fixed today at 3 p.m. But due to personal difficulty of Learned Counsel for the plaintiff, the matter could not be taken up for hearing. Let the matter appear on 28 August at
The second week of August.
no time cannot be. I can fix tomorrow, but the time cannot be. 27th, 27th, 28th August at 3 p.m. Come on that.
But I'll be there. Man, kindly exchange the interim order, my lord. Interim order is still today, my lord, if your lordship.
It's extended till the next date of hearing.
Very grateful, madam. I can tender my apology, my lord. Kindly, my lord. Sorry.
Next.
Shri, my lord, I'm appearing for the respondent bank.
Lordship, I appear on behalf of the petitioner, Your Lordship.
Yes.
Your Lordship, this matter, Your Lordship, in this matter, Your Lordship, since 2019, the petitioner has been asking for the guidelines that are there in favor of the petitioner to avail the OTS
to avail the OTS benefits, Your Lordship. However, Your Lordship, the respondent bank has been rejecting our letter by saying that we do not fall under any guideline. But they have never mentioned any guideline. They have never even in each and every letter that they have issued, they have referred to a specific guideline, but no annexure to that guideline or any guideline was ever given to us, Your Lordship. Your Lordship, in this case, petitioner is a MSME concern. ND, Your Lordship, this is a circular. Your Lordship, may kindly. Your Lordship, ND is a guideline which was given by the RBI. Your Lordship,
So what do you want?
It stands for non-discriminatory and non-discriminatory. It's a public circular of the bank. It's available on the internet.
Yes, Your Lordship.
Serve the copy.
Your Lordship.
There is an OTS scheme of
So,
one-
I'll just, once my learned friend concludes, I'll indicate.
There is an scheme of one-time scheme of one for
Yes, but there are several schemes of the bank. These are all public documents. But I am only on one point. These are all public documents which are available. I can, a non-lawyer can also go online and take them out. But no, there's a different angle to this. I'll indicate. But I don't want to hijack my learned senior friend's submission. But this is otherwise also not maintainable because there's a gross suppression of material fact in this.
One indulgence, Your Lordship, then
I'll indicate, one thing. There was a proposal that they made to the bank for an OTS. Now, my lord is aware, OTS cannot be enforced by any court. They file an application in a pending Section 17 DRT proceeding which is pending. The DRT disposes of that application by saying that the DRT cannot enter into an OTS proposal, which is settled proposition. They prefer an appeal from that order before the DRAT. They are unable to pay the pre-deposit, because then the pre-deposit order they assail, my lord, by way of a civil revisional application. The civil revisional application is today stood dismissed by an order passed by a coordinate bench, Justice Rice bench, my lord. That is, now they know that OTS cannot be enforced anymore. So now they come and file this writ petition and ask for prayers for disclosure of public documents and no coercive steps. And this entire factual matrix has been suppressed in the writ petition. They don't even mention that their OTS proposal has been rejected. The DRT has dismissed their application. The DRAT appeal is now gone. 227 file, that is also... The entire thing has been suppressed in the writ petition. It's regarding the same subject matter.
Your Lordship.
But this only my learned friend will make submission.
Your Lordship, nothing has been suppressed, Your Lordship. Everything has been indicated in the writ petition, Your Lordship. In this matter, Your Lordship, we are not... whatever has been submitted by my learned friend, Your Lordship, today, the OTS petition that was the writ petition that was filed for OTS, Your Lordship. Your Lordship,
But insofar as the OTS is concerned, the rejection of OTS is annexed with the writ petition. My lord, my sole grievance is that there is an RBI circular, which I've annexed with the writ petition, which says that in case of any chance with regard to any MSME, and the dues of the MSME could be condoned and any settlement can be arrived at, there is a mandate on the bank to provide an offer to the borrower. It is not for the borrower to give an offer. It is for the bank to give an offer to the borrower, and under the circular, bank also does not have the right to reject the offer, whatever it is there, outrightly. May I draw your lordship's attention to that circular, which is at page...
But the problem is, can't come to the prayer?
Yes. Prayers, I'll not trouble your lordship with the prayers. I'm not pressing for most of the prayers that have been prayed in the writ petition. I only want the bank to give me an offer in terms of the circular.
Once the OTS given, but that has not been...
That OTS was not under this RBI circular. There was a previous OTS which the bank rejected. There are proceedings pending against the company. There are proceedings pending before the NCLT. I am not into all that. I only want the bank, and I fall under the RBI circular. I only want the bank to give me an offer. That is the obligation of the bank under the circular, which the bank can't hide away from.
Which circular?
Kindly takes page 54 of my writ petition. But the prayers have not been happily worded in the writ petition, so I'll not trouble your lordship with that. Kindly sees. I'm so sorry, page 58. 58, I'm so sorry, page 58.
Yes.
That kindly takes paragraph 3. NPA accounts under substandard category as on 31st March 2020 with OLB up to 25 lakhs as on the date of compromise to be considered, and for NPA accounts under doubtful and loss assets as on 31st December 2020 with OLB up to 5 crore as on the date of compromise to be considered under the scheme. Now, my due as per the bank is 4.37 crore. I fall under clause 3. Now kindly comes to clause 5. Branches, which are the banks, branches will send written intimation to all eligible borrowers for availing this facility, detailing bank's dues and the non-discretionary and non-discriminatory OTS amount in Annexure A, which will be treated as in principle approval by the bank. Now, my lord kindly takes Annexure A, page 63. This is for the bank to give.
But that is not your prayer.
Right, I have pleaded about that in the writ petition. I've annexed
But
the.
you're not prayed. Can't you see
Right,
the
there's
prayer?
there's one prayer, my lord, that
What?
may, my lord, suffice.
Disclose the account, disclose the
No, my lord,
all these things.
my lord, prayer
also
A,
not-
my lord, prayer A, I'm not troubling. Prayer B also, my lord, I'm not troubling. Prayer C also can't be granted, but I'm not pressing for that. But insofar as prayer F is concerned, a writ in the nature of mandamus to direct the respondent to adhere and take action as per RBI and bank's directive and correct the wrong being done. But not happily worded, but still, my lord, what I want from the bank is covered under this prayer.
Once
Bank
your
to-
one-time settlement has been
one-time settlement has been rejected. I had
and that
preferred
has
the
been
writ.
up to the DART and the revisional application. Now what remains? What remains?
But what happened is, my lord, I gave them an OTS. OTS was rejected by the bank. I preferred a writ petition. Writ court said that you go before the DRT, since proceedings before DRT is pending. I go before the DRT. The borrower went before the DRT. DRT said that DRT cannot get into it. It's the option of the bank. If the bank wants to accept the OTS, bank can. If they doesn't want to, then it's the bank's call. Challenging that, appeal was preferred. Appeal, we could not deposit the pre-deposit amount, and we have withdrawn the appeal, I'm told. But what my cause of action insofar as this writ petition is concerned is restricted to the RBI circular, which has never been adhered to by the bank. Neither have been any decision been pronounced by any of the court or tribunal anywhere. I am entitled to being an MSME. The company is entitled, and I'm a guarantor. The writ petitioner is a guarantor, so I have liability insofar as the borrower's liability is concerned. So, my lord, I have a right under the circular for the bank to give me an OTS, not an OTS, to give an offer. Once the bank gives me an offer,
After applying all the things, then you come to the MSC
no, it is not that. I have been writing to the bank for a long time. It is not that after everything has done, then I've gone before the bank.
So if the OTS will, why you are not requested the bank at that time? Okay, OTS will come to dealt with the circular dated.
But page 84 kindly takes. Page 84. My representations to the bank. Well, this, or somehow we got hold of this this RBI circular. Otherwise, it was the bank's mandate, obligation to give me this, which the bank never gave it. I did not even know about this circular. And it was the bank's obligation to give me this. Bank took it away from me. They never showed me this. Now, what is the intention of the bank? Then 2024 wala representation at page 85.
That is a different thing. Again, OTS.
Yes, and then kindly sees my representation of
84 also OTS.
84 is also, but I ask for the schemes, OTS schemes. This is a RBI scheme which says that bank can offer a settlement to the borrower, and the bank has an obligation to do so under the RBI.
Now, what is the stage of your account?
My account has been declared as NPA.
So what has happened to the DRT?
DRT, my lord, my application was dismissed and it has stood at that stage.
His section 17 is still pending before the DRT.
Yes, my lord, it is
Section
there.
17 is
And
not
there are
the-
proceedings
not his.
before the NCLT against the borrower. There are
When the section 13 notice was issued to you?
13-2 notice was
4th of
issued.
October 2018.
30?
4th of October 2018.
4th of August.
Against the company, against the borrower, not against him. He's not the borrower. In
No,
fact,
I am the guarantor.
he's a private individual. All these letters at 84 and 85 have been issued by the company, not by the borrower.
Yes, yes, I am the guarantor. I have concurrent liability, Lordship.
His reply 13.3a, his reply is of 2018, 13.4 is of 2019. Then the borrower company files a section 17 proceeding. OTS proposals have all been made by the borrower company. They have been rejected. All are subject matter of the DRT.
Absolutely. Well, I am not disputing any of
remains,
that.
Go and tell me, go and appear.
But what this RBI, under this RBI
RBI
circular?
has come in 2021. How it is affected?
No, it is covered. My account is covered.
Account is covered, but it is of 2021.
It is of
And
2021.
Your NPA is at 2019.
Yes,
Then
and my lord, no, my lord, the RBI circular says
Where retrospective effect or prospective effect? How it
Right.
can be?
as on
21 subsequently, your account has been declared as NPA in 2018.
my lord, this says that my lord, clause 3 of the circular, which says as on 31st December 2020, OLB up to 5 crore.
Correct.
So I am covered by
2020,
this
How you can cover?
because my lord,
You are in 2018. It is the NPA.
yes, 2019 it has been declared as NPA.
Then
Well, it is not that my right goes away, but the NPA amount is
this,
still there.
This circular will affect you.
The NPA amount is still there. It is still an NPA. It has not been.
NPA, but the bank has already initiated the proceeding.
Yes.
2018 itself, 19
Yes.
itself.
19 bank has filed the original application before the DRT.
Now, section 13 notice.
Section 13 notice 2018.
18.
4th August
Then-
2018.
Then DRT in 2019.
Yes, DRT in
17 is also
2019.
pending.
Yes, DRT 2019. But this circular does not say that if the bank takes any step under the SARFAESI Act or under the Recovery of Debts Act, this circular will not apply. This circular doesn't say so. The circular says this overall settlement of all the MSME units which are suffering from any debt.
No. 3. NPA account under substandard category as on 31st March 2020.
Yes.
But prior to that, the bank has already taken steps. So
But-
how?
May I? If an account is declared
So
as
cut off date
non-performing
has been taken by the in this circular from 31st of March 2020.
No, my lord, that, my lord, in my respectful submission, that, my lord, is not reasonable because, my lord, insofar as the NPA account is concerned, once an account is declared as a non-performing asset, immediately the bank takes steps under the SARFAESI Act, 13-2 notice. Now, NPA account, this circular says that NPA amount as on 31st December 2020 shall be under the purview of this circular. Now, whenever the NPA, if the other interpretation is taken, then whatever accounts
And
that
you are-
are to be
And you
declared,
are the guarantor.
I am the guarantor.
Yes, it's not coming forward.
So it only says to the borrower, not he. The company is not the petitioner.
Liability, I have the same liability towards the bank.
So you how? Kindly come there. It is the borrower.
Clause 5. Clause 5.
Yes, you're the borrower. You're not a borrower.
But I am representing.
All
the-
eligible borrowers to avail the facilities.
That's right.
Yes.
Then
But if it is the bank's stance that the borrower has not come forward, and it is only the guarantor which has come forward, I'll make a representation to the bank. The borrower will make a representation to the bank, and the bank will consider it because I have a coextensive liability. Whereas the borrower and the guarantors have coextensive liability towards the bank.
yes, sir.
Lord, number one, I wanted to make that submission, Lordship has already pointed that out. If his entire case today, if he's not pressing the rest of his prayers, he's only saying you let let the bank follow the RBI circular. RBI circular clause 5 says that it's only it's upon the borrower. The borrower is not even before your Lordship, is a separate legal identity, my lord. This is absolutely elementary. The company has not come forward and filed a writ petition. In fact, when this writ petition came, I was trying to give higher credence to the case. So, in fact, your Lordship today has passed maximum number of judgments in this MSME, RBI, well, all these cases. I was looking at all this up. All of these judgments rendered by your Lordship are at a pre-13-4 stage. Once 13.4 happens, the remedy lies under section 17. I'm carrying my lord 2 judgments on that point also.
No, absolutely. There is no
So,
dispute.
and if his only point is you follow the RBI circular, how can he come and enforce it for the borrower?
How you can take the burden of the borrower?
But my only cause of action is that I have coextensive liability towards the bank. It is the same liability as the borrower has towards the bank.
But the circular says otherwise.
Circular says it will be applicable on all the borrowers.
Borrower.
All the borrowers. Now, my lord, the bank says, today, my lord, the bank says that the borrower has not come forward, and that is why the bank will not accept.
The bank has already taken
Rejected.
steps. The borrower will face the consequences.
That the borrower, let the proceedings go on, my lord. I can't, my lord, ask for any order against the proceedings. But my lord, the circulars have to be followed. The RBI circulars have to be followed. The
You're
bank,
satisfied that the circular is to you also.
but all eligible borrowers, and I have coextensive liability. I am a director of the company. I am representing the company. I am acting on behalf of the company because
Where is it? British says only the one, not
Private
the
individual.
company.
yes, I am one of the directors of the company. Right? May I?
Kindly come to the cost writer.
Amendment. Amendment.
Not as a director of the company. Not as a director of the company.
Well,
You file the writ petition as a home of
at
your
the
own.
paragraph 1.
Yes.
Petitioner is the erstwhile guarantors of Genco project such and such who had executed purported personal guarantee in favor of the bank on behalf of Genco project, which is the borrower,
Correct.
which is an MSME, etc.
It is, yes.
Well, since I have a coextensive liability towards the bank, and it is the same if there is a settlement of the account under the RBI circular, it will be for both the guarantor as well as the borrower. Now, what is the bank's issue in sending me an offer? For all these years, bank has not, whereas it is the mandatory obligation on the bank to do so.
Yes.
The circular is very clear. Bank has to give it.
That's all.
That's all, Malad. And Malad, in the light of the bank submission that the borrower has not come forward, the borrower can make a representation to the bank and the bank will give the offer.
Yes, anything further?
Today, nothing. I don't think I'll really require it.
The petitioner has filed the present writ application praying for several reliefs, but at the time of hearing, the petitioner has only pressed for prayer F, which reads as follows. Inward comma, a writ in the nature of mandamus direct the respondents to adhere and take action as per RBI and bank's directive and correct the wrong being done. Inward comma close. And counsel for the petitioner brought to the notice of this court to the circular issued by the UCO Bank Recovery Department dated 27th of July 2021, wherein 2021 and has relied upon clause 3 and clause 5 of the said circular. And counsel for the petitioner submit that the bank has not followed the circular by giving an opportunity to the petitioner for come forward to compromise to settle the loan amount. Instead, the bank has initiated the proceeding against the borrower under the SURFACI Act. Full stop. And counsel for the petitioner submit that the petitioner has made representation for giving benefit to the circular dated 27th of July 2021, but the bank has not considered the same. Per contra, an advocate appearing for the bank submits that the writ petition is liable to be dismissed as the petitioner has suppressed various material facts. He submits that the bank has initially issued the section 13 within bracket 2 notice and 2 of the issued notice under section 13 within bracket 2 of the SURFACI Act, and subsequently the petitioner subsequently the bank has initiated the proceeding before the DRT and DRT. The petitioner, you have filed the DRT.
The borrower.
No, the borrower has.
The borrower has filed an appeal against the order of the DRT, and the appellate authority, appellate tribunal has dismissed the appeal of the borrower.
Well, it was withdrawn. The appeal.
Being agreed with the said order, the borrower has preferred a civil revisional application, and the civil revisional application was also dismissed. He further submitted the said fact was not brought to the notice of this court in the present date application. And counsel for the bank further submit that the circular with the petition, the circular dated 27/7/2021 with the petition intent to take the benefit, the said circular is for the borrower. The petition is not the borrower. Unless such the petitioner cannot ask for any benefit with regard to the circular dated 27/7/2021. Had the learned counsel for the respective parties peruse the materials on record. The circular dated 27/7/2021 and the clause 1 of the circular dated 27/7/2021 as per clause 1, as per clause 1 of circular dated home loans and UCO properly and UCO property loan accounts under doubtful Roman 2, doubtful Roman 3 and loss categories of OLV up to 5 lakhs are covered, irrespective of the amount originally sanctioned to the borrower. Full stop. Clause 3. Clause 5 also provide that the branches will send written intimation to all eligible borrowers for availing these facilities, detailing banks' dues and the non-discretionary and non-discriminatory OTS amount in Annexer A, which will be treated as in principle approval closed by the bank. On complete reading of the said circular, this court find that the circular is for the borrower. Borrower has not come with any request with the bank for giving any benefit to the circular dated 27/7/2021. The bank has already the petitioner herein is only a guarantor. The bank has already initiated the proceeding before the DRT and before the death recovery tribunal, and the same is pending before the tribunal. Considering the above, this court find that the writ petition is not maintainable. Accordingly, writ petition is dismissed. Next.
Item number 4.
But item number 4, my lord, I apply for the petitioner.
Yes.
To be candid, your lordship, I have been briefed just now today. I want to come back to assist your lordship,
Your lordship, I'm appearing on behalf of SEBI, your lordship.
Yes.
Your lordship, it's a very small issue. Your lordship has heard it also. If your lordship.
My lord, I want to come back tomorrow, your lordship.
Not today. Next.
Grateful, your lordship.
Okay.
5, I beg to appeal for the.
My lord, I am for the state, my lord.
Yes.
But matter relates to my lord.
My lord, before my learned friend starts, my lord, this writ petition is not maintainable, my lord.
Why?
There is an alternate remedy, my lord, and they have not exhausted the alternate remedy.
What is the prayer? What is the remedy asked
Setting
for?
aside of the, my lord, final order passed by disciplining authority, my lord.
Where is that? Which authority?
Page 170, my lord.
170.
No, 170. 180, my lord. I am extremely sorry, my lord. 180. And if your lordship sees at page 190, my lord, the appellate authority description has been given, my lord.
Arthak, top floor, protocol section, High Court building. Who is he? High Court staff?
No, my lord.
Marriage registrar.
The marriage register. He was appointed sometimes in 2000, and there was a disciplinary proceeding, my lord.
before I place the disciplinary proceeding, my lord, I have to place a checkered history, and your lordship kindly, as because my learned friend alternative remedy, I have challenged the process, my lord. Your lordship kindly sees, I have annexed. My lord, notices were served upon the, my lord, charge officer, my lord. After the date of hearing, we could not, my lord.
Yes, there is an appeal provision.
Your lordship kindly sees. Your lordship kindly sees, my lord.
And my lord kindly sees para 82, my lord, what they have stated.
Para 82 of the writ petition.
My lord. 82. Page 47, my lord.
No alternative and efficacious remedies available. Sought for. And what is a prayer?
For setting aside the order passed by the disciplinary
Motion
authority.
set aside the order. Reinstate the petition on official marriage register. Yes.
My lord, may I, my lord, please, my lord, the factual aspects of the matter, my lord. My lord,
How that it is maintainable?
my lord, I say, my lord, from the since 2023, several proceedings were initiated before this honorable court, and in pursuant to directions passed by this honorable court, my lord, I have participated. My lord, my grievance is that, my lord, the proceeding has not been, my lord, continued in accordance with law. My lord, may I just, my lord, your lordship kindly comes to page 171 for the first page 171, volume 2. My lord, we approach this honorable court, and with regard to,
yes,
my lord, this honorable court was pleased enough, my lord, to permit the petitioner to take assistance of a legal representative. Your lordship kindly comes to page 172. The notice, my lord, requesting, my lord, to appear before the inquiry authority for hearing of the disciplinary proceeding, my lord. With reference to, I'd like to remind you, inspection and receiving documents. Now you've been requested to appear before the office chamber. This is 11th August 2024, and I was called to appear on 20th August 2025. Your lordship kindly sees my next reply, my lord. This is to page 175. This is to draw your kind attention that the above referred letter dated 11th August 2025, calling upon my client to appear before the disciplinary proceeding on 20th August 2025 at 12 p.m. was received by my client on 22nd August 2025. As such, my client was not in a position to attend the hearing of the disciplinary proceeding on the scheduled date and time. It is surprising to note that upon inquiry with regard to the service of the letter dated 11th August 2025 issued from your office, it is revealed that the same was posted on 20th August, well after the scheduled time of hearing of the disciplinary proceeding at 12 p.m. and the same was received by my client on 22nd August 2025. It is apparent that the deliberate attempts were made to prevent my client to attend the hearing of the disciplinary proceeding. My lord, next, your lordship kindly sees, again, my lord, a letter dated 20th August was issued to me, my lord. With reference to the subject noted above, I would like to remind you that in the proceeding...
Where from you're reading?
My lord, page 177.
Yes.
Again, my lord, notices were issued after the date of hearing, my lord. With reference to the subject noted above, I would like to remind you that in the proceeding dated 24th July 2025, inspection and receiving of documents in connection.
Yeah, just you read this.
My lord, my lord, no notices with reasonable time was granted to us to appear, my lord. And on the basis of non-appearance, and lastly, my lord, strange manner, no notices was issued to me, and my lord, final order was passed. I was
okay. 20th August notice was issued.
After the time of hearing, the hearing, because these days your lordship
proceeding remind you in the proceeding dated 20th, the inaction, inspection on receiving a document by you in connection with already been completed.
And the letter was not. It is admitted that the letter was not delivered to you till forenoon, and the hearing
dated was dispatched to you, request to appear before the department, but it has ascertained that the letter was not delivered to you on 20th. So now you being the requested to appear on 28th of August.
28th of August.
Correct. So what has happened?
This 28th of August notice we received on 26th August.
Correct.
My lord, in the late afternoon hours, and I stay in a far off place, my lord, about 100 kilometers. I, my lord, prayed for a time that this particular date is not possible to arrange, and my lord, without granting me an opportunity, my lord, to present my case, final order was passed. And prior to that, my lord, I will show several orders passed, my lord.
When the order was passed?
My lord, this order was passed, my lord. Final order was passed on 13th October 2025.
So thereafter no date was fixed?
No date was, my lord, no intimated.
My lordship will come at page 184, bottom 2/9/2025 date was fixed. Page 184, my lord.
184.
Bottom of 184, my lord.
The next date
The
of
next
hearing.
date of hearing was fixed on 2/9/2025.
My lord, any communication from my learned friends, my lord, to show that this notice was served upon me, I'll be out of this court.
My lord, first he has to cross the maintainability ground, my lord. Then the merit he can.
Okay, if your notice is not served, whatever it may be, you
That is an appealable order, my lord.
He says the date was fixed on 2nd of September 2025.
Yes.
My lord, let my learned friend show that any notice was served upon me.
But you have asked for time on 28th of August. You received on 26th of August.
No,
You
20th
have
August, I
just
have
a minute. You have received the notice of hearing of 28th August on 26th of
26th,
August.
my lord.
Correct. 2 days before you received.
No, we-
But just a minute. But you have requested, you have some difficulties, so time may be given.
Time was granted.
Time was granted. So it is your duty to see the date.
My
So
lord, I
you
tell
have
your
not
lordship, your lordship knows, my lord, in disciplinary proceedings, dates, my lord, immediately was not been given, my lord, it was informed by post or by some other means. In these particular cases, on earlier occasions also, notices were served upon me. Because that is not the first time. Prior to these notices, we appeared, there were proceedings, we participated in the proceedings, inspection was given. It is not a case that we have not participated.
My lord, he was represented by the authorized advocate of the advocate, my lord.
How the advocate can appear in the discipline?
In pursuant to an order passed by this honorable
What
court,
is allowed?
yes, it was permitted. An advocate was permitted because there was an order, my lord.
So if your advocate was allowed and your advocate has given the notice, so your advocate could have been taken.
Advocate was not served with any notice.
Your advocate has made an adjournment.
When for
Kindly come to
adjournment?
the page 178. 178, the advocate only.
Yes, my lord.
So your advocate could have been-
Adjournment was granted. Next date was not notified. My case is that, my lord, next date was not notified. If the next date was notified, my lord, that would be, my lord, duty on the part of the advocate to appear and contest, my lord, participated in the disciplinary proceeding.
No, you see you come with the whether because kindly see the page 184. The next date of hearing of 2/9/2020 Law Department letter dated a copy of the place flag 8 fixing the date of hearing on 2/9 and was immediately communicated to the charge officer through email and the
registered email.
Produce that. You produce that. If it is produced, it is email is been given to them. Then he will not be. Then I will dismiss the writ petition herein now.
My lord.
My email, no email was registered with the disciplinary authority, my lord. That is my case, my lord.
Where is the case that the no email is there?
My lord,
where is
prior to this particular step?
Where is your writ application? You made an averment that there is no email. You are not having the email.
No, I myself have an email. Initially, prior to this, my lord,
petitioner has filed the present writ application challenging the order passed by the disciplinary authority. Challenging the order passed by the disciplinary authority.
One moment, my lord. My lord, let me be one submission, my lord. Prior to this email, all my lord notices were served by
2025. The Learned Counsel appearing for the respondent raised objection with regard to the maintainability of the writ application. He submit that the order of the disciplinary authority is appealable order, but instead of filing the appeal, the petitioner has filed the present writ application. Counsel for the petitioner submit that initially the disciplinary authority has issued the notice to the petitioner with regard by fixing a date on 28th of August 2026. The petitioner has received the said notice on 26th of August 2026 and has informed the authority that due to the short notice, the petitioner could not able to appear before this court. Accordingly, disciplinary authority has adjourned the matter on 28th of August 2026 and fixed the matter on 2nd of September 2026. It is fine from the impugned order that on 22nd, the date of 22nd of 2nd September 2025 was duly communicated to the petitioner through in his mail, his or her,
my lord.
in her mail ID, but in spite of the receipt of the same, the petitioner has not appeared before the disciplinary authority on 2nd of September 2026. In view of the above, the respondent's authorities are directed to produce the record to satisfy this court whether the mail was sent to the petitioner for informing the date on 2nd of September 2025 on the next date fixed. List the matter on 6th of August 2026 under the same heading.
Grateful, Lordship.
Grateful.
Appear for the petition.
Yes.
Lord, for the respondent number 5, my lord, Mr. Bachawat, my lord, is online, my lord.
Yes.
Well, I'll just take maybe 5-7 minutes, my lord, to finish it. I had almost finished my submission on the last day.
Yes.
And Lord, I was not just distinguishing some of the points which they had taken. Now, my lord, apart from Lord, the submissions which I made, your lordship will see that they had referred to 2 different documents in an attempt to show that the respondent number 1, respondent number 5 was the man in charge of the company and should be caught. Because I've showed your lordship, there is nothing against me at all. Absolutely nothing. These were the only 2 documents that they showed. But if your lordship not first takes, not page 446 of the petition, volume 3. Now, there are 2 documents and 2 places in the list of dates. And all of them, Lord, I'll deal with together.
Yes, 446.
Yes, Lord. This is a part of the memorandum and articles of association of the company.
Yes.
Now, from that, they point out that signatory number 2 is my client.
Yes.
Avinash Agarwal.
Yes.
Now, your lordship will find right at the bottom there's a date. 10th December 2004.
Yes.
Now, the fact that I was one of the incorporators of the company means nothing at all. Because I've showed your lordship that I had resigned from the company, sold all my shares, resigned as a director, and gone away long before that. Long before the fraud took place. Long before. My lord.
Yes, yes, done. Yes.
Lord, I ceased to be a director. Your lordship can make a note on 17th of September 2018. And that document to show that, with the stock exchange and NSE and other things, your lordship can make a note that your lordship will find in AO page 51, which I've already showed your lordship.
Yes.
So 17th of September 2018, I had gone. Similarly, all my shares had been sold on and that is taken on record by the official bodies. That your lordship will get. Again, affidavit in opposition, page 56 and 57. If your lordships would just take that once, please. So I'd ceased to be a shareholder, I'd ceased to be a director.
Page
56, 56.
Yes. Harshvardhan Bolia.
Just give me a moment. Yes, page 56 and 57. Now, my lord, what your lordship will find is that, my lord, we are writing to NSE on the National Stock Exchange on 4th of April 2019.
Yes.
Or the NSE is writing rather. And, my lord, your lordship will find that, my lord, against the third bullet point, the dominant promoter, Mr. Anubhav Bhattar, who is the respondent number 2, my lord, who has tried to say that I am involved, the dominant promoter, along with the relative support, will hold 51.13% and will continue to hold at least 51% of the shareholders of the trading member at all points of time. So, my lord, even in April 2019, my lord, I had gone. That your lordship will find on the next page, the annexure to this letter, your lordship will find that my shares, the first name under item number 1, I was earlier a 5.54% shareholder. I become 0%. That's on the right-hand column. Left-hand column, 5.54 and 0%.
Yes.
So, long before this fraud happened and all of these transactions happened, I had gone out. It ceased to be a shareholder, it ceased to be a director.
Yes.
And Lord, since we are on that page, Lord, if your lordship would also, Lord, once just have a look at page 51, which is in that same volume.
Yes.
Where your lordship will find that I had ceased to be a director, Lord, under item Roman 17.
Yes, that you have already pointed out.
Yes, I pointed out. So I'm just showing your lordship the document.
Yes. Yes. Anything
And
else?
my Lord, please remember that in addition, if your lordship takes the affidavit in opposition, page 67 once more, my lord. Here, my lord, I have annexed the affidavit filed by SEBI. SEBI's affidavit in another proceeding. It starts at page 66.
Yes.
And, my lord, if your lordship comes to page 67, para 5.
Yes.
But the SEBI itself says, as the respondent number 3 did not find any evidence of involvement of the respondent number 5, which is myself, and the respondent number 8, in the unauthorized pledging or misappropriation of client security of the respondent number 4, it has been decided that no further enforcement action from the answering respondent against the respondent number 5 and respondent number 8 is necessary.
Yes.
So, my lord, SEBI itself has cleared me. And I showed your lordship the earlier orders also. I am not troubling your lordship.
Yes.
So, my lord, this is the first point. My learned friend showed one more document, which is on the next page, page 447 of the petition. Petition, page 447. Same volume as I showed your lordship. Now, what they've done here is they've annexed a contract note. Your lordship will find the date at the bottom. 27th November 2020.
Yes.
Now, please have a look at this document. It is not signed by me. There is no signature. There is nothing. Now, what they say is, if your lordship sees right at the top, on the top left-hand side, the letterhead contains my name. Authorized signatories, Anubhav Bhattar, Avinash Agarwal. So, on this basis, they say you are involved. Now, my lord, please see, this is a format. This is a pre-printed format, which not the plaintiff himself has printed out. The fact that my name is there in some pre-printed format will not make me responsible because I've showed your lordship, NSE itself has accepted that I'm not involved in any way.
But fact of the matter is I was not there. This is his form. And no signature of mine is there. So, my lord, this is the second second document. Now, the other two things he relies upon, my lord, is his list of dates. So, my lord, there are two lists of dates which he has produced. One is the list of dates, my lord, relating to the affidavit in opposition of the respondent number 9. And one is the list of dates to do with the respondent number 11. Both are really similar in nature, but if I may take your lordship, only through that one entry. If your lordship has the list of dates relating to the respondent number 9.
Yes.
But if your lordship takes item number 5.
Yes.
Respondent, 5th of April, 2016.
Yes.
The respondent number 1 entered into a loan against securities of 100 crores with the respondent number 9 on the representation that the securities pledged belong to the respondent number 1. Application contains signatures of the respondent number 2 and 3 and the PAN and passport copies of the respondent number 2, 3 and 5. I am 5. Now, the loan application made in 2016 had my PAN copy. Now, how does this make me liable in any way? Firstly, like I showed your lordship, 2018 I went. I had gone. Secondly, SEBI has said I am not involved.
Yes.
So, my lord, this can't, my lord, the fact that my PAN is given along with the application for loan made by the company in 2016 does not make me the person in charge of the affairs or in any way related to it, because, my lord, this entire set of pledge that my learned friend is aggrieved about took place much later.
Yes.
And, my lord, similar is the list of dates relating to the respondent number 11. Please have a look at, my lord, item number 3. Now, that goes back to 2005.
Item number 3.
3. 7th October 2005. Respondent number 1 availed of, please see the date, 7th of October 2005. Well, this is the list of dates pertaining to the respondent number 11. I'm sorry, my lord, I couldn't make that out.
Yes, got it. Good.
So, my lord, please see the date 2005. Now, in 2005, the letter of sanction was accepted by the respondent number 5. That's his case. Now, my lord, I had gone 2005 document to show that I'm the man in charge of the company, but it's stretching things very, very far. It's not just not clutching at straws, but it's stretching it very far. Now, to stretch it this far, my learned friend relied on two authorities. Lord, your lordship will remember, Lord, he had showed LIC escorts. Lord, AI 1986 Supreme Court. Page 1370. He had relied on para 90.
1986 Supreme Court, life insurance.
Yes, LIC versus escorts. So, lordship would take para 90. So I don't have to place the whole of the para. May I just say this, LIC escorts, recognizes the principle that, there is a corporate entity which is different from the entity, not from the shareholders. It goes on to also say that there are certain exceptions when the corporate veil may be lifted. Now, those exceptions, your lordship will find are usually things like breach of statute, tax fraud, attempt to defeat the state exchequer. That is really the basis for it, and fraud. Now, may I just show your lordship I don't fall within these exceptions from this judgment itself. The lordship comes to para 90. If your lordship is at the bottom of, is on page 1417. If my learned friend has not given the copy from AIR.
Yes, paragraph 90.
Yes, my lord. Your lordship will find that there is a quotation from Pennington.
Yes.
And my lord, your lordship will find, my lord, if I may place from there, 4 inroads have been made by the law on the principle of separate legal personality of companies. By far the most extensive of these has been made by legislation imposing taxation. So, my lord, we don't get covered by this. The government naturally enough does not willingly suffer schemes for avoidance of taxation which depend for their success on employment of the principle of separate legal personality, etc. So, my lord, this is the first exception. Then, my lord, if your lordship goes to the next para of this, the other inroad on the principle of separate corporate personality has been made by 2 sections of the Companies Act. Now, my learned friend has not pointed out any section of the Company Act. By judicial disregard of the principle where protection of public interest is of paramount importance. Now, here, my lord, again, no public interest involved. It is his own grievance that he says, look, give me money, although I have the right to and I have a decree which I have already got. He is seeking to really execute a decree. Then, my lord, the next para. In Palmer's company law, the present position in England is stated and occasions when corporate wealth have been my lord, enumerated and classified into 14 categories. Now, my lord, if your lordship goes down, so I don't have to read too much of it. Not about 15 lines from the bottom of that para, not where it refers to Commissioner of Income Tax versus Meenakshi Mills.
Yes.
In Commissioner of Income Tax, the corporate veil was lifted and evasion of income tax prevented by paying regard to economic realities behind this facade. So, my lord, this is again taxing. Then, my lord, in Workman versus Rubber Industry, resort had to be had to the principle of lifting the veil to prevent devices to avoid welfare legislation. Not here again, it doesn't fall within that. It was emphasized that regard must be had to substance, not the form. Generally and broadly speaking, we can say that corporate veil may be lifted where a statute itself contemplates lifting the veil. Now, my learned friend relied on one statute for that purpose and only one statute. Please have a look at section 27. I do not fall within it. If your lordship would just have a look at 27 of the SEBI Act. So, my lord, he is really, my lord, if I may put it, my lord, in a manner of speaking, put himself on the cross by showing this judgment. And then, my lord, he is crucified himself. Because 27 does not apply in his case. Section 27, where an offense under this act has been committed by a company. Every person who at the time of the offense, but please mark the words, at the time of the offense, was committed, was in charge, and was responsible to the company for the conduct and business of the company, as well as the company shall be deemed to be guilty of an offense. So for that, my lord, I had to be a person who, at the time of the offense, was in charge. I've showed your lordship from documents that at the time of the offense, I was nowhere near about. Lord, the rest of the paragraph from Lord LIC escort I won't place because Lord, your lordship has seen tax, breach of statute, fraud of not other nature. But not if he is complaining of breach of statute, he relied on 27, he doesn't fall within 27. Lord, I think that takes care of my submissions, Lord. Those are my submissions, Lord. I'm obliged to you, Lord. I'm obliged.
Number 6. Brother of respondent number 5 for whom Mr. Bachawat made submissions. I have very short submissions to make. Threefold submission.
You are for the respondent number 6.
Yes, please, my lord. I'll be very brief, my lord. I'll not trouble your lordship with the facts. Save and accept the facts which are specifically applicable to me.
Yes.
I have threefold submissions to make, my lord. First, the suit is not maintainable. Second, even if it is maintainable, first, the suit is not maintainable, being hit by the provisions of the SEBI Act. Second, even if it is maintainable, no prima facie case against me. And third is the technical submission, my lord, that there was no urgency for dispensation of 12A, and the dispensation granted should be revoked. But that will come at the end, my lord.
Yes.
Your Lordship will kindly have the SEBI Act first, please, my lord, because that goes to the jurisdiction.
Appeal provision.
Please, my lord, yes. But why it is relevant, my lord, I'll just show your Lordship. Kindly have from the appeal provision also, but apart from that, my lord, kindly have the preamble once, please. An act to provide for. An act to provide for the establishment of a board to protect the interests of investors in securities. That is the function of the board. That is why this act has been brought in.
Yes.
That is the, my lord, object of this act, and for this purpose, it is a complete code. Now, my lord, kindly have section 15Y once, please.
Civil court jurisdiction.
Yes, please, my lord. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating officer appointed under this act or the appellate tribunal constituted under this act is empowered by or under this act to determine. And no injunction shall be granted by any court, so that we are, there are two limbs of this. One is the bar on receiving and determining. Now, my lord, so I need to show your lordship that the cause of action of this suit, or what the subject matter of this suit, is something which the adjudicated officer appointed under this act was empowered to determine. And in fact, he has already determined.
Yes.
Kindly have, my lord, section adjudicating officer is constituted. Kindly have section 15 once, please, my lord. Penalties and adjudication. Chapter 6A, penalties and adjudication.
Yes.
Now kindly come to, my lord, 15HA. Penalty for fraudulent and unfair trade practices.
Yes.
If a person indulges in fraudulent and unfair trade practices relating to securities, he shall be liable to a penalty which shall not be less than 5 lakh rupees, but which may extend to 25 crore rupees, or 3 times the amount of profit made out of such practices which is higher. So, if a person indulges in fraudulent and unfair trade practice. Now, fraudulent and unfair trade practice, there is a specific regulation. Kindly have, my lord. Your lordship has this taxman book, my lord. Taxman's Bear Act, your lordship has. No, your lordship has. It has the regulations, my lord. Kindly have. I don't know if your lordship's book.
Security Exchange Board India.
Securities and Exchange Prohibition on Fraudulent and Unfair Trade Practices. Your lordship's book has that, my lord. There is a regulation of 2003, Securities and Exchange Board of India, Prohibition of Fraudulent and Unfair Trade Practices.
No, that is issue of capital and disclosure. That is fraudulent.
ये निकालो ना soft copy दाओ हम ये book दे देते हैं जज साहब. मतलब may I hand over my book if your lordship permits me?
Yes.
Kindly have, my lord. 4M, please. This is the unfair trade practice which is punishable under 15 HA. For M, your lordship kindly have. A market participant entering into transactions on behalf of the client without the knowledge of or instructions from client is not. Kindly see, misutilizing or diverting the funds or securities of the client held in fiduciary capacity. 4M.
Yes.
So his entire case is this.
Yes.
That the respondent number 1 misuse.
Participant entering into transaction on behalf of
This
the
part is
client.
not attracted, my lord.
Yes.
Or misutilizing. After client, your lordship sees.
Yes.
Or misutilizing or diverting the funds or securities.
Held in the fiduciary.
Yes. That is his entire case. Diverted, pledged. The securities which he was holding, that is defendant number 1 was holding of the claimant, of the plaintiff, and caused loss. So this is something which is squarely covered by the Securities and Exchange. That is the duty of the Securities and Exchange, and there is a complete jurisdiction of civil court. It is akin to 238 of the Insolvency and Bankruptcy Code.
Yes.
Now in this case, my lord, volume 3 is the order passed by the adjudicating officer. Now that matter cannot be re-agitated before your lordship today. There was a statutory mechanism of appeal which he has not availed of. These issues, even if he has not availed of, whatever he has done, even if his case was not specifically referred to, the adjudicating authority to determine is the adjudicating officer under the SEBI Act. There is a complete jurisdictional bar. Ouster of section 9. Civil courts will not have jurisdiction. This is the complete jurisdiction. Whether he has availed of the remedy, not availed, is immaterial. So that is my first submission. Second submission is this, my lord, on the prima facie case. I'll give the judgments also, my lord, on this point and on the other points. Prima facie case, my lord, if your lordship kindly sees. As far as I am concerned, kindly have the petition once, please. I will not repeat Mr. Bachawat's submissions. I will just show your lordship what kind of sketchy prima facie case is made out against me. Kindly have the petition once, please.
Yes.
Petition volume. Kindly have paragraph. I'll just give you lordship the paragraph numbers. Paragraph 2. Can you see the third sentence there? Second sentence. Respondent numbers 2, 3, and 4 are the present directors of R1. Respondent number 6, that is whom I represent, my lord, are erstwhile directors of R1. Respondent number 1 was at all material times and still appears to be controlled and managed by the family of respondent number 5.
Yes.
This is the only averment apropos respondent number 6. Then your lordship will kindly have paragraph 14 once, please.
Yes.
From the aforesaid interim orders, it further emerged that the respondent number 13, that is, my lord, National Stock Exchange, had detected that securities of clients had been and were being pledged unauthorizedly by the respondent number 1 with the respondent numbers 9, 10, 11 to raise funds despite requests from client to return the securities. This is the classic case, my lord, of unfair trade practice. The respondent number 13 had detected that such pledges were undertaken at the instance of, now my lord, kindly see, the respondent number 13 had detected that such pledges were undertaken at
respondent number 3. Respondent number 3.
They have said 3, but it should be 13 if your lordship should be 13. That's a
13.
typographical error, Malad, because the paragraph starts with 13. That's why I'm sorry I read it as 13. Eyes played tricks on you, Malad. You read what you want to read. The respondent number 13 had detected that such pledges.
No, if it is the 3, then the case will be otherwise.
3 kaun hai? Huh? Oh, yes, it can't be 3. I'm grateful. That would have been even better for me.
Good one. Came very silently, but
Respondent number 13 detected, and that too at the end of the day. Respondent number 13 detected that such pledges, now I kindly see this. Respondent number 13 detected that such pledges were undertaken at the instance of the respondent numbers 3, 5, and 6, constituting the erstwhile management of the respondent 1 and had been continued by the respondent numbers 2, 3, and 4. By pausing here for a minute, I will show you, Lordship, the respondent number 13's detection is absolutely to the contrary. And second, he says is, respondent number 6 tendered. Now, kindly see the admitted position. I tendered my resignation from the board of the directors of respondent number 1 on 13th March 2012. And 31st March 2012. Now, Malad, he started trading with the respondent number 1 sometime in 2018.
Yes.
October 2017, paragraph 5. Malad, kindly make a note of these two. And as far as the incorrect statement of NSE detection, I'll show you, Lordship, from the document. Can you see paragraph 5? Accordingly, in or around October 2017. So started trading in 2017. I have admittedly resigned on 31st March 2012. 5 years ago.
Yes.
52 of AO. 52 of AO. I tendered my resignation on 31st March 2012. I'm showing you, Lordship, the uncontroversial portions, my lord. NSC, I will show you, Lordship, later, please, my lord. Now, kindly see, my lord, paragraph 39A. Subject to correction, my lord, these are the only places in the whole petition where I am referred to. 39A, your Lordship will kindly have. At page 38. I'm sorry, starts at 37. 52 of AO. Yes. The respondents in collusion, conspiracy with each other. Paragraph 39 at the bottom of page 37, my lord. Respondents in collusion and conspiracy with each other orchestrated massive fraud. Then not only respondents 1 and 8 to have perpetrated the fraud, banks and financial, everybody has defrauded him. Now kindly see A, please, my lord. The respondent number 1 was originally incorporated as a public company limited by shares by the promoters, being the respondent numbers 3, 5, and 6. Then respondent numbers 3, 5, and 6 have particularly 5 and 6 were the masterminds. Not even 3. Now he says 5 and 6 were the masterminds behind the unauthorized and illegal pledging of client securities, and such practice commenced, kindly see, commenced during their directorship. I ceased to be director in 2012. Respondent number 6.
As per their case, you are the hiding director.
I am the hidden director, yes. But that is a prima facie case he has to satisfy, your Lordship. I am not director, but I am the...
On paper, you resign, but
Yes.
you have hidden.
Yes.
And you conducted all the business.
I will show, my lord, how this is just very imaginary, my lord. Knowing this, the whole case is because 5 and 6 are moneyed people. 5 and 6 are people of substantial means. So you don't go chasing an ant. You chase the elephant, you might get something. It's like that. 3 is now defalcated and gone, declared fraud. That is why he comes chasing me. However, upon using, kindly see, my lord.
nowadays, my lord, ant is more powerful than the elephant.
We'll not use other terms here now. It has created a nationwide upheaval. When
Now
the Lordship will not enter into that.
Never say anything. Never say anything about an insect.
I have not heard it.
Now, my lord. However, upon using the client securities, kindly see, this is the allegation that there is no supporting document to this. However, upon using the client securities of R1 to secure the massive financial facilities owned by the said company, from R 9, 10, 11, thereafter diverting and siphoning of such finances into other related companies, kindly see, into other related companies and or businesses and all for their personal use. Respondent numbers 5 and 6 in collusion and have slowly and fraudulently distanced themselves from the liabilities arising out of such unauthorized pledging of shares. The same has been possible only with the active investments who, after being aware of the involvement of the said respondent numbers 5 and 6, have not taken any steps to pull up respondent numbers 5 and 6 for the illegal acts. Three things, my lord, at the prima facie stage at least, three things have to be established. Even after my cessation, I had any manner of control over the company for 5 years, continuous. Second, monies which came into the company were diverted to, my lord, kindly see, very important, fifth line, other related companies and or businesses for my personal use. So this is what he has to show. He has to show first, I was controlling the company even post my retirement 5 years ago. Second, monies which allegedly came into the company post 2018 was siphoned out into even a single company where I held a stake. In order to, Mr. Bachawat has argued, lifting of corporate will is not permissible in these facts, A. B, I say I go a step further. Even if your lordship is keen to lift the corporate wheel, it must lead to some recipient of mine who has got these monies. Connected. There's no connection. In this volume, in the 4-volume petition which is there, your lordship will not find anything. That is why I showed your lordship the paragraph.
No, Mr. Banerjee, during the conference might be kept in some secured place that.
My lord, this is a commercial suit now. This is a commercial suit. Whatever he has to come. You live by the sword, you die by the sword. This is a commercial suit. If he doesn't have it, he doesn't have it. And on this basis.
Not reading between the lines, man. His insect vision is not permitting.
But if whatever documents he had are there, now this is the document and averment on the basis, the bare averment without any document on the basis of which he seeks an injunction over my personal accounts. I am only interested in my personal accounts. And this is the only averment.
Yes.
And without any bare averment, allegation had to be made to complete the circle. This is the allegation made, but no supporting document whatsoever.
Yes. Yes.
So, Malad, there is no prima facie case apropos me made out in the petition. Now, Malad, on his submission, on that allegation there, that NSE has found that I was responsible. That your lordship saw, 2 submissions there. Yes. Kindly now have the order of the adjudicating authority once, please. It starts at 357. On volume. Volume 3 of the petition.
Yes.
Starts at 357. Kindly come to 378 once.
Yes.
I'm sorry, kindly have 377 once. It is noted. My lord has that. It is noted because I was not a director at that time, nor was my brother Avinash a director at that time. Kindly see, my lord. It is noted that it was contended on behalf of the noticee 1, 2, and 3 that the FAR and the SCN does not delve into the role of Sudhanshu Agarwal, that is R6, Avinash Agarwala, that is R5, who along with noticee 3 were the initial directors of noticee 1. In this regard, I note that a similar contention was raised by noticee 3 prior to the passing of the confirmatory order, and at that stage, after taking it was directed in the confirmatory order that. Now, present director of BMA, namely noticee number 3 in his oral submissions made during the hearing, has contended that the said pledge of securities were being undertaken by the erstwhile management, Avinash and Sudhanshu, and continued by the present management. This is what he also alleges. Therefore, the Stock Exchange Clearing Corporation are further directed that the forensic audit appointed by them, oh, it should be forensic auditor appointed by them, shall also look into the role of Avinash Agarwala and Sudhanshu Agarwala, who are non-dominant promoters of notice number 1 and are alleged to be directly involved in these companies as submitted by these notices. Now kindly come to 22, please, my lord. This is the finding.
Yes.
I note from the records, so a forensic audit is directed after objections are raised by respondent number 3. I note from the records that pursuant to the said directions, the matter was examined by SEBI, and kindly see, views of NSE was also taken on this issue. Thereafter, based on the examination of the material available on record, it was decided to not to proceed against Mr. Avinash Agarwala R5 and R6, and accordingly they have not been made notices in the proceedings before me. In view of the same, I am constrained to note that contention raised by noticee in respect of the role of Avinash Agarwala and Sudhanshu Agarwala is beyond the scope of the present proceeding. There was no material on record. And that is after considering the views of NSE. It is for the petitioner to show your lordship that NSE anywhere came to a finding that I was involved. There is no document, just a bare allegation which is contrary to the material on record.
Yes.
Now, this stand, when this matter went up to the High Court of Gujarat, affidavit was filed. Kindly see the affidavit once, please. Page. (59) and 63 of AO. Kindly have page 59 and 6. This is my AO.
AO of 6.
My affidavit.
6 AO. AO of 6.
Kindly have, this is the order.
Page.
Starts at 59, please, my lord. Your lordship will kindly make a note of the cost title once, please. Your lordship will find serial number, respondent's name in the left-hand column, my lord, after the name of the petitioners. Your lordship has that, my lord?
Yes.
Kindly make a note of my name there, my lord. Respondent number 8.
Sudhanshu Agarwal.
Yes, please. The order starts at, I'm sorry, this is the affidavit by respondent number 2, SEBI, filed before the High Court. Starts at page 63. Kindly have paragraph 4 at page 64. I'm sorry, paragraphs 3 and 4.
Yes, same was Mr.
Mr. Bachat has already, yes, I'm sorry, my lord, I'm repeating.
Yes, no problem.
So this is as far as, because your lordship will find there respondent number 5 and 8.
Yes.
8 is my client, my lord, who's respondent number 6 before your lordship.
Yes.
So, my lord, as far as prima facie case is concerned, there is no prima facie case on the basis of the averments made in the petition itself and, my lord, the court records. Now, my lord, on the technical point, my lord, which I told your lordship, my lord, the urgency is pleaded for institution of these proceedings. There is no application, but your lordships have held suo motu revocation is permissible. Kindly have the plaint once, please, my lord, because here the plaint comes into play. Page 64. The plaintiff state, I'm sorry.
Yes.
This is the urgency which is pleaded. The plaintiffs state that the plaintiffs have had to file the instant suit owing to the urgency as mentioned below. While the plaintiffs were in the process of collecting further information for getting a more complete picture of the transactions and their ramifications, the plaintiffs suddenly came to learn this on 2nd October 2024 from certain persons having information of the affairs of the natural persons controlling the defendant number 1. The plaintiffs came to learn that, now this is the additional information he comes to learn, because of which he rushes to court and says, grant me 12-day leave. the plaintiffs came to learn that the defendant number 1 had, in concert with a section of financial experts close to the defendant number 12, devised a strategy whereunder they would immediately obtain certain purported clarificatory directions from SEBI, in the garb of which the defendant number 1 and its past and present directors would transfer their properties to third parties, partly by transfer by registered conveyance and partly by transfer of shareholding, in order to ensure that neither the regulators nor any court of law would be able to lay hands on the assets capable of being attached, with a view to frustrate proceedings for recovery of money, including possible suits before civil courts of competent jurisdiction. Now kindly see, the plaintiff came to learn about the same from the plaintiff number 2, who was present at a function organized to commemorate the father of the nation on occasion of Gandhi Jayanti. So plaintiffs inform themselves. Can you see the last sentence? Plaintiffs came to learn about the same from the plaintiff number 2, who was present at a function organized to commemorate the father of the nation. So plaintiffs, one plaintiff informed the other, and that is the urgency. Now why that plaintiff number 2 and plaintiff number 1 and 2 are husband and wife, incidentally?
Yes.
I'm sorry, mother and son. Hey,
Mother
sorry,
and-
mother and son.
So might be she was not there in the national occasion of Gandhi Jayanti. Then Mr. Banerjee has chosen a very good
I
day.
don't know what is the significance of 2nd October.
He has chosen a very good day.
Ah,
Cheeseburgers.
that is why.
So that's why he will not say that for any.
Plaint is verified on 7th, so date close to 7.
7th maybe Mr. Thakkar's birthday. I don't
No.
know.
Now, my lord, they found all this out, paragraph 10 on 1st October 2019. 1st October 2019, they found out that all these wrongdoings have been done. That is in paragraph 10, my lord.
Paragraph 10 of the plaint.
10th of the plaint, my lord, page 15. Your lordship, since your lordship has the plaint, now kindly see, my lord. Change kore dijiye. No, mane next day. On or about 1st October 2019, broking account of D1 was frozen, and then the newspaper articles of December. So, my lord, cause of action, knowledge of unfair dealing is of December 2019, and the suit is filed much later and taking advantage of the COVID limitation. Can you see paragraph 67? COVID order extending limitation, otherwise perhaps the suit would have been barred. Suit is filed in 2024. Paragraph 67.
Yes.
Seventh October 2024, the plaintiff is affirmed, and this is the only urgency which is one plaintiff informed the other plaintiff.
Yes.
And my lord, your lordship will see there is no relief. My lord, I think this is some signal we have to leave.
Because otherwise Mr. Thakkar will not.
Lord, your lordship has given us one more day, I think. Tomorrow, my lord, may I conclude tomorrow? I just cite 2 judgments and conclude. Wait.
Mr. Bachawat has concluded his argument on behalf of the respondent number 5. Mr. Thakkar and senior advocate has argued the matter at length on behalf of the respondent number 6. But due to constraint of time, hearing cannot be completed. Let the matter appear tomorrow at 3. At 3:45.
তোমার অ্যাপ্লিকেশন অরিজিনাল আমি অ্যাপ্লিকেশন রেখে ওপরে
ওটা করুক। Number 8,
Tell your
I know,
junior.
this is this MSAB which I was arguing, my lord. I know,
No,
he's-
I know.
why
Tell
mention?
It's serial number 8 and juniors should appreciate
I
the
understand fully.
burden of the court. When they're telling that it has to be taken after hearing, he knows whenever the time is getting, this court is giving the time to all advocates.
I know that.
Lord, Lord, I'm sorry, Lord.
I'm grateful.
May I, Lord, I'm
Yes.
telling you, Lord, Lord, my Lord knows me, Lord, in those day before yesterday's rally, the media persons were beaten mercilessly. But I'm from a, Lord, the media house, Lord, we want to file a writ petition, Lord, very urgently, Lord, there is no,
What this court will do?
Lord, for formation of a policy, Lord, there is nothing for, Lord, prevention of these attacks on the media houses. Lord, my person, my media person, my reporter went to the spot to bring, Lord, the news. They have been mercilessly beaten by the persons who are not connected to the rally. Lord, allow me to move it tomorrow at 2 p.m. Lord, it's very important.
What the injunction can be passed?
Look, I am
Not
asking,
interim
I am asking for only upon a direction, upon a statement for formation of immediately a policy, so that we should be given some protection, something like that. But I am not asking for any interim order. If my lord's direction to consider, upon them to consider and take a decision, my lord would do. Let me move it tomorrow at 2 p.m. Lord, kindly allow
My
me.
appellate side is not.
Okay, officer, can I?
Come tomorrow. I will take day after tomorrow. No problem.
नहीं অফিসার নেই
I'll get it.
আরে আই উইল গেট ইট টাকা তো আনতে হবে জজ সাহেব কি বসে থাকবেন if they could inform him that my lord has granted leave, if that could be done, then we can get it filed tomorrow morning. I think I am seeking for something, Lord.
No, because my staff is not. Come tomorrow morning. I will sit.
Very
with
well.
you.
Tomorrow morning.
I apologize for the Friday, that fraud report matter which was heard by your lordship. The members in the bar who were present here said I was very loud on the visual. I apologize.
No.
Actual mode,
No, Mr. Thakkar.
I was told I was very loud.
No.
Come tomorrow.
Wait.